in the USA, people find themselves in court.
After this, Jeanette will call our no-show arraignments. Then we'll call our no-show show causes. Then we'll shift gears to our felony cases. Good morning, sir. Give me a minute, Mr. Ritchie. I don't move too fast.
Yes, sir.
And I don't think they put this case in my queue because it came from pre-trials. So take a look. Six. All right, this is file numbers 25856ST, 855, and 857. Trampus J. Ritchie. Mr. Ritchie got a ticket at 5:19 at night at Halfway Road and Clinton Street in the village of Burr Oak for operating while suspended, no insurance, and an improper plate. That ticket was issued on May 7th. Today's May 13th. The defendant's been in jail for 5 days. It says hold only, no charges. I don't think this is what's keeping you in jail. Mr. Ritchie, why are you in jail?
A hold out of LaGrange.
LaGrange County, all right. Well, let's talk about these charges. The prosecutor, Mr. Gabriel, is willing to dismiss the driving suspended charge. That's good because that would carry an additional suspension of your license. That's punishable by up to 93 days in jail and a fine of up to $500, 2 points, and the suspension of your license. They're offering to dismiss that. for a plea to no valid plate and no insurance.
Yes, sir.
No valid plate is punishable by up to 90 days in jail and a fine of up to $100. I'm just gonna give you 5 days jail credit, 5 days on that charge. The other one's a little trickier. Driving with no insurance is a misdemeanor. It's punishable by up to a year in jail. It carries no points, but it does carry a minimum fine of $200. Minimum means that the state says I'm supposed to assess that. So I'm gonna give you a fine. Also gonna give you 5 days jail credit and let you go to LaGrange and take care of your issues there. So other than what was told to you by the prosecutor and what I just told you, did anybody promise you anything to get you to plead to this
No, sir.
or threaten you?
No, sir.
All right. Do you understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or a jury?
Yes.
There will be no trial. If you had a trial, you'd have the right to be represented by an attorney. Mr. Knopfinger is just sitting here. I could appoint him to represent you or another attorney from the public defender's office
No,
can also waive it. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. If you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
All right, Mr. Ritchie, where were you going? You and I go back a long ways.
Yes, we do.
But this was in May in Burr Oak. Where were you going?
I was gonna go do my laundry, actually.
And did you have any insurance?
No, sir.
And did you not have a proper plate?
No, sir.
Haven't been in here, you've been in lockup, but I discussed this a couple times this morning. Those go hand in hand. If you don't have a license, you can't get insurance and you can't get a plate.
I thought my license were good, but they were out of Indiana.
Yeah, so you got some baggage down there. What does Indiana want you for?
I've been going through Michigan and Indiana for courts, and supposedly the judge or the lawyer down there gave me the wrong court date, and so it's a failure to appear.
On what kind of charge?
They're trying to get me for dealing.
All right, well, we'll take care of these two. On the improper plate, I'm gonna give you 5 days credit, 5 days concurrent with the no insurance. Fine is $0. On the no insurance, that's the one I said is a little trickier. $5 days credit, 5 days. But I have to order a minimum $200 fine and $125 of state costs. That's required. I'm gonna give you until September 1st to pay that. You got other problems. Did you still have the halfway road address?
Yes, sir. I got pulled over in my driveway, so.
All right, Mr. Ritchie, that takes care of these. The driving suspended charge is dismissed, which has some benefit because that carries a suspension. These charges don't. But you're good to go back to Indiana.
Thank you, sir.
You guys aren't old enough to remember Ms. Jackson does. R. Dean Taylor's song Indiana Wants Me. And when you were driving in your car, it had a siren in it. In the song, you'd have to turn around and see if the police were following you, but Indiana wants him. Up your alley, you could get all over town without violating
Violate those laws.
any law, I think. All right, the bailiff's gonna take you out and set up a payment plan,
All right,
and then good luck, sir.
thank you.
Jody Lynette Wood. All right, Ross, is she here or is she at the jail?
She's here.
Okay. Paul, is that the only one you've got?
That's the only one aside from bandit.
All right, then we'll just deal with Ross in the meantime. All right, let's take a look at how Miss Wood's been in jail.
I think, yeah, she's got credit.
She also goes by Klein, so she's been in jail 11 days. Do you have anybody else back there?
Not that you need to see, Judge.
All right, thank you. Not that you got homeless people stashed back there. She's got more than that, January 13th. Good morning. Do you prefer Wood or Klein?
Wood.
All right. We have two cases this morning with Jody Lynette Wood, also known as Jody Lynette Klein. The felony case is in file 241559. And the original complaint alleges carrying concealed weapon, a dangerous stabbing weapon on or about your person. The way this is charged, that's a felony. It's punishable by up to 5 years imprisonment. And the crime allegedly occurred July 8th of 2024. I was trying to figure this out. The warrant was sworn to by the officer in August 16th of 2024. You got arrested on January 12th of 2025. And you bonded out on January 12th. So I have 1 day there. Then you didn't show up. Adjourned 1 week, you were on behavior center. Then they had a pre-exam conference. On February 18th, they didn't show up. So Judge Patterson issued a bench warrant for your arrest. Then you got arrested again on May 1st. And you've been there ever since. So you got 12 days there. So you have 13 days total jail credit on this charge of carrying a concealed weapon, a stabbing instrument. What's the plea offer, Mr. O'Bear?
Offers for the defendant to plead to use of methamphetamine and forfeiture of the box cutter and knife that she had.
In addition, the Three Rivers City Attorney, Mr. Reed, granted authority to put their case uh, 24562 disorderly person as part of the plea agreement. Also dismiss disorderly. All right, so let's break this down, Ms. Wood. The weapon charge is going to be dismissed. You're going to plead to use of methamphetamine, which is under the Public Health Code. It's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. The disorderly person charge from Three Rivers from March of 24 is going to be dismissed. That's got a bunch of no-shows in it too. And as far as I can count, you have 12 days of jail credit. Is anything other than this charge holding you in custody? You don't have a hold from other state or county or anything?
No.
All right, let's go through a couple of other things. I don't have your advice or rights, so let me take a minute and tell you and anybody else that's going to enter a plea that by pleading guilty to this charge, you give up your right to have a trial in front of a judge or jury. Do you understand?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. I say that a lot. Understand?
Yes, sir.
Now, the affidavit in this case states it right out there. Affidavit says the affiant was dispatched a report of a suspicious situation, Constantine Road. Trooper Tracy Smith and a deputy Joseph Chittister went out there. The complainant, Mr. Chittister, said you showed up in his driveway. You were very upset. You're afraid of your husband. There's been a lot of turmoil out there in your neighborhood.
Yeah.
A lot of it from your husband. And they found in your possession a meth pipe, and you said you last smoked it the night before. And you also had some stabbing instrument, box knife, and knife in your bra. So that was the felony charge, not the most compelling, but do you acknowledge that you used methamphetamine before that time?
And before.
All right, that's close enough. All right, now, you had multiple occasions where you didn't show up. You were in and out of the hospital. But you were like trying to grab smoke with your hands. You then got arrested on May 1st. How did you come to get arrested on May 1st?
The cop showed up to the house because my stepdaughter's boyfriend didn't report to the parole officer, and I was there, so they.
Or they came for another purpose, ran you and arrested you?
Yeah, I got searched.
Why didn't you show up?
I was in the hospital and I don't have a vehicle, so. And when my mom will come from Indiana a lot of times to take me to appointments, but it's like an hour and a half drive one way for her to get here. And other than that, I don't have any transportation.
Well, they gave you transportation in the back of a police car.
Yes, sir.
That's not a very good excuse because you were out of the hospital weeks before this May 1st date. I'm not sure what to do here. Mr. O'Barry, have any thoughts?
She clearly has a drug problem.
Yes.
I don't know if probation would be beneficial to her to help deal with that.
Mr. Gibson, you have any thoughts?
The defendant said that she's been going to Pivotal and that apparently they were the aftercare after her hospitalization. So she said she is taking steps to be proactive in that regard. And so if I would ask the court to sentence the defendant for credit for time served as far as jail, if the court believes that she needs supervision, then I would ask for a short probation term. Thank you.
We haven't been very successful with our probation. Judge Pattison tried a probation with Miss Wood back in 2019, which involved testing, and we couldn't get her to test, and the probation was revoked. She doesn't have enough transportation to even get to court or inclination. And then she had another couple of larceny cases in the 2020. And then that disorderly person charge where she missed multiple court dates. So I don't see a probation being successful. Now, this happened way back in July of 2024. And you were distraught and you ran to the neighbor's house. And you ended up getting arrested because you were afraid of being assaulted, which I won't argue that point. Then did you just end up back there with him?
They didn't actually arrest me that day.
They took this.
Took me to Keystone.
Okay.
And then she just told me that she couldn't tell me that there wouldn't be charges brought up later, and this is where it was brought up.
All right. We've got a civil infraction also. So are you back with your husband? Who else is there?
My stepbrother,
What's her name?
Destiny.
Oh, and who's the boyfriend that got arrested?
I don't know his last name. His name, Cody. I don't know who. I don't really know him. I don't know his last name. He's still, when my husband came and visited me last night, they Destiny and him.
Is that your Cody?
I'm sorry, what was the last name?
Well, she didn't know it, but he's got picked up, so we'll see. Well, anyway, Miss Wood, Destiny's got issues also. In fact, I thought there was a warrant for her. No. All right, she doesn't have the wherewithal to get to court. She has at least one previous failed probation. I think more than one, but most recent one was 2019. We have a couple of weapons, which were not very compelling. She was fleeing a domestic assault situation. I'll take her at her word. As I said, there've been a lot of turmoil at that house. She failed to appear multiple times, but she was in and out of the hospital for medical problems and mental health problems. If they had tested you on May 1st, would you have tested positive then for meth? I'm not sure I buy that. You obviously knew there was a warrant out for your arrest, and I don't know what, you were just waiting to get picked up. When did you last have any involvement with Pivotal or any treatment people?
I had an appointment on May 7th, but I was incarcerated.
When was your last meeting with them prior to that?
Probably, I think we were gone 3 months. He was gonna see me, so probably 3 months prior to that. I gotta reschedule an appointment when I get out. But I've been going to Pivotal for quite a long time, like over 14 years. I'll continue to be going there too.
You do have a couple other things that you owe us for. Not involving threats or drugs, but involving theft. And I certainly understand, Mr. O'Bear, how you came to this plea offer. That's really what the nub of the problem is. But it was last year, it was July of 2024. In between there, the 11 days she got here, she also did some days on the misdemeanor where she continually failed to appear. Same thing. All right. I'm gonna order 21 days, credit 12, leaving 9 days to serve. We'll give you a little more time to get detoxed here. 0 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $150 attorney fee. $275 a part of a payment plan. And also other cases. You will get some good time days built into this. So you probably have, I'm guessing, 4 or 5 more days to do, but you continually failed to appear on both cases. One got dismissed outright. I think there is an underlying methamphetamine issue, but this was a year ago. You also had a previous failed probation and a number of unpaid retail fraud fines. So you can go with a court officer. When you get out of jail, I want you to come up here and set up a payment plan to pay this stuff off. All right, you're good to go.
Thank you, sir.
All right, do you need a minute, Mr. Truckee? Well, let's sit down and see where we are. I saw that you were doing some difficult sentences. I'm not sure how those 3 sentences got set on your duty day, but that didn't work out so great. And you got a lot of tough cases this week. So let's see what we got before us. So much firing them, but having them in the car and under the seat and in the console, these kids are pulling the trigger.
I think I've made the argument before that guys used to have cool cars.
Oh, they
Now
got
they
cool
have
guns. Good morning, Mr. Austin. This is Judge Middleton. I wanted to talk to you this morning. Are you Eric Ryan Austin?
Yes, sir.
Mr. Austin, we've met. We had those domestic violence cases a few years ago. We had 221106 SM, which was a domestic violence. We had 222049 SM, which is 2 counts of domestic violence and malicious destruction of property, and 2382-SM, which is a domestic violence second offense. All of these, to my recollection, involved your family. And let's talk about the case that you're in custody on right now. Here with me is your lawyer, Mr. Ross Truckee, and Chief Assistant Prosecuting Attorney Joshua Robert, and his assistant, Ms. Stoll. Mr. Austin, in this case, the allegation is, let me look at the actual complaint, that on or about April 27th, you did enter a home at Carl's Road without permission, breaking in, which was the home of your parents. They've charged it as a home invasion, punishable by up to 20 years imprisonment. Count 2 alleges aggravated stalking of your mother primarily, and that's charged as a 5-year felony. As I said, these other previous incidents involved your parents, and you moved out of the Carl's Road address, and I think you were at Maple Crest, and the allegation is that you went to your parents' house and took some things and smashed their door in, and other allegations. Your lawyer, Mr. Truckee, having met with you at the jail, is concerned that there may be an issue regarding your competency to fully assist in your defense. How are you doing at the jail?
Not good.
Are you getting your medication?
Barely.
Who's giving you your medication?
You can go ahead and answer that, Eric, if you would, or if you can.
Is the jail staff, is the jail nurse giving you your meds, or?
Yeah.
I can tell just from this brief interaction, we're having trouble getting full communication. Is that part of your concern, Mr. Truckee?
No. Mr. Austin readily speaks to me and communicates with me. And this is not so much an understanding of the object nature of the proceedings as it is a rational ability or ability to assist in defense in a rational way. That is my concern.
Mr. Robert, you have a position?
I have no objection.
I'm familiar with Mr. Austin. I handled all those three cases that I spoke to earlier by case number. We struggled. There were some mental health issues and there were a lot of inter-family issues between him and his parents. And they didn't want further contact with him. All right. I'm going to order that the defendant be evaluated for competency. Mr. Austin, they will either take you to or connect you with the Center for Forensic Psychiatry for an evaluation regarding your ability to assist in your defense. Your bond, in the meantime, is set in the amount of $6,000 cash or surety. I don't believe it's been posted or probably will not get posted, but it will be set for further proceedings. I'm gonna do a target date here. Ross, let's see where you got a duty week.
I'm almost done with my duty weeks for the year, so.
I think I got RT. Oh, that's RI. All right, we'll set a date.
I'll make myself available.
All right, Mr. Austin, best of luck. Continue to take your medications and do any other treatment as directed. We're gonna get a competency evaluation. All right, as I indicated, I do know that defendant and I know there are some significant mental health issues. Let's set this for pre-exam for August 5th.
Judge, could we do a week earlier or a week later? I'm actually planning to.
August 12th.
That would work.
All right, I've signed the competency order. I don't think we have anything left, do we?
I,
All right, thank you. I'll sign these waivers. There's more coming. You'll go out to the jail and see Mr. Brownridge.
Yep.
All right, thank you.
get those sorted. Josh, do you have a couple minutes?
Sure.
I can show you right here on my.
All right, we're gonna up your alley. You could get all over town without violating
Violate those laws.
any law. I think. All right, the bailiff's gonna take you out and set up a payment plan,
All right,
and then good luck, sir.
thank you.
Jody Lynette Wood. All right, Ross, is she here or is she at the jail?
She's here.
Okay. Paul, is that the only one you've got?
That's the only one aside from bandit.
All right, then we'll just deal with Ross in the meantime. All right, let's take a look at how Miss Wood's been in jail.
I think, yeah, she's got credit.
She also goes by Klein, so she's been in jail 11 days. Do you have anybody else back there?
Not that you need to see, Judge.
All right, thank you. Not that you got homeless people stashed back there. She's got more than that, January 13th. Good morning.
Morning, sir.
Do you prefer Wood or Klein?
Wood.
All right. We have two cases this morning with Jody Lynette Wood, also known as Jody Lynette Klein. The felony case is in file 241559. And the original complaint alleges carrying concealed weapon, a dangerous stabbing weapon on or about your person. The way this is charged, that's a felony. It's punishable by up to 5 years imprisonment. And the crime allegedly occurred July 8th of 2024. I was trying to figure this out. The warrant was sworn to by the officer in August 16th of 2024. You got arrested on January 12th of 2025. And you bonded out on January 12th. So I have 1 day there. Then you didn't show up. Adjourned 1 week, you were on behavior center. Then they had a pre-exam conference. On February 18th, they didn't show up. So Judge Patterson issued a bench warrant for your arrest. Then you got arrested again on May 1st. And you've been there ever since. So you got 12 days there. So you have 13 days total jail credit on this charge of carrying concealed weapon, a stabbing instrument. What's the plea offer, Mr. O'Bear?
The offers for the defendant to plead to use of methamphetamine and forfeiture of the box cutter and knife that she had.
In addition, the Three Rivers City Attorney, Mr. Reed, granted authority to put their case uh, 24562 disorderly person as part of the plea agreement. Also dismiss disorderly. All right, so let's break this down, Ms. Wood. The weapon charge is going to be dismissed. You're going to plead to use of methamphetamine, which is under the Public Health Code. It's a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. The disorderly person charge from Three Rivers from March of 24 is going to be dismissed. That's got a bunch of no-shows in it too. And as far as I can count, you have 12 days of jail credit. Is anything other than this charge holding you in custody? You don't have a hold from another state or county or anything?
No.
All right. right, let's go through a couple of other things. I don't have your advice or rights, so let me take a minute and tell you and anybody else that's gonna enter a plea that by pleading guilty to this charge, you give up your right to have a trial in front of a judge or jury. Do you understand?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. I say that a lot. Understand?
Yes, sir.
Now, the affidavit in this case states it right out there. Affidavit says the affiant was dispatched a report of a suspicious situation, Constantine Road. Trooper Tracy Smith and a deputy Joseph Chittister went out there. The complainant, Mr. Chittister, said you showed up in his driveway. You were very upset. You're afraid of your husband. There's been a lot of turmoil out there in your neighborhood.
Yeah.
A lot of it from your husband. And they found in your possession a meth pipe, and you said you last smoked it the night before. And you also had some stabbing instrument, box knife, and knife in your bra. So that was the felony charge, not the most compelling, but do you acknowledge that you used methamphetamine before that time?
And then before.
All right, that's close enough. All right, now, you had multiple occasions where you didn't show up. You were in and out of the hospital. But you were like trying to grab smoke with your hands. You then got arrested on May 1st. How did you come to get arrested on May 1st?
The cop showed up to the house because my stepdaughter's boyfriend didn't report physical officer, and I was there, so they.
Or they came for another purpose, ran you and arrested you.
Yeah, they got searched.
Why didn't you show up?
I was in the hospital and I don't have a vehicle, so. And when my mom will come from Indiana a lot of times to take me to appointments, but it's like an hour and a half drive one way for her to get here. And other than that, I don't have any transportation.
Well, they gave you transportation in the back of a police car.
Yes, sir.
That's not a very good excuse because you were out of the hospital weeks before this May 1st date. I'm not sure what to do here. Mr. O'Barry, have any thoughts?
She clearly has a drug problem.
Yes.
I don't know if probation would be beneficial to her to help deal with that.
Mr. Gibson, you have any thoughts?
The defendant said that she's been going to Pivotal and that apparently they were the aftercare after her hospitalization. So she said she is taking steps to be proactive in that regard. And so if I would ask the court to sentence the defendant for credit for time served as far as jail, if the court believes that she needs supervision, then I would ask for a short probation term. Thank you.
We haven't been very successful with our probation. Judge Pattison tried a probation with Miss Wood back in 2019, which involved testing, and we couldn't get her to test, and the probation was revoked. She doesn't have enough transportation to even get to court or inclination. And then she had another couple of larceny cases in the 2020. And then that disorderly person charge where she missed multiple court dates. So I don't see a probation being successful. Now, this happened way back in July of 2024. And you were distraught and you ran to the neighbor's house and you ended up getting arrested. Because you were afraid of being assaulted, which I won't argue that point. Then did you just end up back there with him?
They didn't actually arrest me that day.
They took this,
took me to Keystone,
okay,
and then she just told me that she couldn't tell me that there wouldn't be charges brought up later, and this is where it was brought up.
all right. We've got a civil infraction also. So are you back with your husband? Who else is there?
My stepbrother,
What's her name?
Destiny.
Oh, and who's the boyfriend that got arrested?
I don't know his last name. His name, Cody. I don't know who. I don't really know him. I don't know his last name. He's still. When my husband came and visited me last night, they Destiny and him.
Is that your Cody?
I'm sorry, what was the last name?
Well, she didn't know it, but he's got picked up, so we'll see. Well, anyway, Miss Wood, Destiny's got issues also. In fact, I thought there was a warrant for her. No. All right, she doesn't have the wherewithal to get to court. She has at least one previous failed probation. I think more than one, but most recent one was 2019. We have a couple of weapons, which were not very compelling. She was fleeing a domestic assault situation. I'll take her at her word. As I said, there's been a lot of turmoil at that house. She failed to appear multiple times, but she was in and out of the hospital for medical problems and mental health problems. If they had tested you on May 1st, would you have tested positive then for meth? I'm not sure I buy that. You obviously knew there was a warrant out for your arrest, and I don't know what, you were just waiting to get picked up. When did you last have any involvement with Pivotal or any treatment people?
I had an appointment on May 7th, but I was incarcerated.
When was your last meeting with them prior to that?
Probably, I think we were gone 3 months. He was gonna see me, so probably 3 months prior to that. I gotta reschedule an appointment when I get out. But I've been going to Pivotal for quite a long time, like over 14 years. We'll continue to be going there too.
You do have a couple other things that you owe us for. Not involving threats or drugs, but involving theft. And I certainly understand, Mr. O'Bear, how you came to this plea offer. That's really what the nub of the problem is. But it was last year, it was July of 2024. In between there, the 11 days she got here, she also did some days on the misdemeanor where she continually failed to appear. Same thing. All right. I'm gonna order 21 days, credit 12, leaving 9 days to serve. We'll give you a little more time to get detoxed here. 0 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $150 attorney fee. $275 a part of a payment plan. And also other cases. You will get some good time days built into this. So you probably have, I'm guessing, 4 or 5 more days to do. But you continually fail to appear on both cases. One got dismissed outright. I think there is an underlying methamphetamine issue, but this was a year ago. You also had a previous failed probation and a number of unpaid retail fraud fines. So you can go with a court officer. When you get out of jail, I want you to come up here and set up a payment plan to pay this stuff off. All right, you're good to go.
Thank you, sir.
All right, do you need a minute, Mr. Truckee? Well, let's sit down and see where we are. I saw that you were doing some difficult sentences. I'm not sure how those 3 sentences got set on your duty day, but that didn't work out so great. And you got a lot of tough cases this week. So let's see what we got before us. Want to talk to?
Jacob Hamilton?
All right, Jacob Hamilton, come forward, please. Thought you didn't want to come over here anymore.
Well, that's my son, but this is the
Yes.
first time he's ever been in.
If you could get your kids to quit dragging you over here.
That's right. But I can't blame him. This is his first time.
All right, well, let's talk about this. He started off with a bang. Are you Jacob Andrew Hamilton?
Sir.
Mr. Hamilton, you got charged with carrying a concealed weapon, which is a pistol, in your car. That's a felony, punishable by up to 5 years imprisonment and a fine of up to $25,000. You also got charged with making an assault upon a guy named Tyson Clemens with that weapon. It's actually a 5-year offense to possess it and a 4-year offense to threaten somebody with it. And then it also alleges that you assaulted somebody named Trapper Johnson. And here's the big one. They charge you with possession of firearm during the commission of a felony that carries a mandatory minimum 2-year prison sentence preceding and consecutive to any other case. So if you get convicted of this, you're going to prison for not less than 2 years. This is called a pre-exam conference. We would set this for a preliminary examination next Tuesday at 1 o'clock. So is that what we're going to do for the time being?
Yes, Rob.
And what's the bond issue?
Mr. Hamilton's wearing a GPS tether and it interferes with his workplace activities, the work boots he's required to wear. He'd like to be considered for the other GPS alternative. I think there's a kind of like a handheld or a cell phone one. He doesn't have a criminal record. He's got strong ties to the area. I don't think he intends to depart anytime soon. So I'd ask the court to consider that option.
Where do you work?
I work down in Indiana, Jayco. I build RVs.
I knew a guy that worked at one of the plants. I won't name it. He was one of the managers there. He said half the guys on the shop floor are wearing a tether on their leg. So why can't you do your job wearing your tether?
I work in floors in the back, and I'm required to wear boots because of all the, like metal and heavy lifting stuff. Like precautions so it don't fall on you. Type of deal.
Yes, I'd also note that he does own a home in this area, so he's got a property and monetary interest in.
I'm not worried about him not showing up, but I'm worried about young kids with guns. We got 4 of them today. There's a prelim this afternoon where a guy's mad at some other kid, so he's blam, 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 blam right through the car door. This young man isn't gonna abscond, but it's more of a public safety issue. They say he likes guns. Had to do with a girl. According to one of the witnesses, Mr. Hamilton placed a gun against his girlfriend's neck at some point after 3 victims had left the residence. I could amend your bond to just put you in jail, and then you wouldn't have to worry about wearing a tether. So you're a blessing by having a tether rather than sitting in the county jail. So you can struggle through with this tether.
And is it okay if I put the offer on the record?
Yes.
So an offer was made of 1 count of felonious assault, 1 count of CW, others, and it's found felonious assault with felony fire attack, and say that our office will not be dismissing that. And he will be looking at a mandatory 2 years in prison.
Probable cause search of his truck resulted in the seizure of a tan and black semi-automatic 9mm pistol with an obliterated serial number. The handgun was unloaded underneath the driver's seat where Hamilton was seated. A loaded 9mm magazine fitting the pistol located under the seat was found in the center console of the truck. Also, several 20-gauge shotgun shells were located in the center console of the truck, along with an unloaded AR-15 rifle on the rear floorboard of the truck. Furthermore, 2 .450 caliber unspent bullets were located in the rear driver's door area. We'll leave the bond as it is. And we'll see you next Tuesday to see whether you wish to have a prelim or waive it. And you can talk about that with your lawyer in the meantime.
Thank you, Your Honor.
Thank you.
Call the next one.
Have a blessed day. Thank you.
All right, thanks. What's your question?
A waiver for a towing fee?
So much firing them, but having them in the car and under the seat and in the console, these kids are pulling the trigger.
think I've made the argument before that guys used to have cool cars.
Oh, they
Now
got
they
cool
have
guns. Good morning, Mr. Austin. This is Judge Middleton. I wanted to talk to you this morning. Are you Eric Ryan Austin?
Yes, sir.
Mr. Austin, we've met. We had those domestic violence cases a few years ago. We had 221106 SM, which was a domestic violence. We had 222049 SM, which is 2 counts of domestic violence and malicious destruction of property, and 2382-SM, which is a domestic violence second offense. All of these, to my recollection, involved your family. And let's talk about the case that you're in custody on right now. Here with me is your lawyer, Mr. Ross Truckee, and Chief Assistant Prosecuting Attorney Joshua Robert, and his assistant, Ms. Stoll. Mr. Austin, in this case, the allegation is, let me look at the actual complaint, that on or about April 27th, you did enter a home at Carl's Road without permission, breaking in, which was the home of your parents. They've charged it as a home invasion, punishable by up to 20 years imprisonment. Count 2 alleges aggravated stalking of your mother primarily, and that's charged as a 5-year felony. As I said, these other previous incidents involved your parents, and you moved out of the Carl's Road address, and I think you were at Maple Crest, and the allegation is that you went to your parents' house and took some things and smashed their door in, and other allegations. Your lawyer, Mr. Truckee, having met with you at the jail, is concerned that there may be an issue regarding your competency to fully assist in your defense. How are you doing at the jail?
Not good.
Are you getting your medication?
Barely.
Who's giving you your medication?
You can go ahead and answer that, Eric, if you would, or if you can.
Is the jail is the jail nurse giving you your meds, or?
Yeah.
I can tell just from this brief interaction, we're having trouble getting full communication. Is that part of your concern, Mr. Truckee?
No. Mr. Austin readily speaks to me and communicates with me. And this is not so much an understanding of the object nature of the proceedings as it is a rational ability or ability to assist in defense in a rational way. That is my concern.
Mr. Robert, you have a position?
I have no objection.
I'm familiar with Mr. Austin. I handled all those 3 cases that I spoke to earlier by case number. We struggled. There were some mental health issues, and there were a lot of interfamily issues between him and his parents, and they didn't want further contact with him. All right. I'm going to order that the defendant be evaluated for competency. Mr. Austin, they will either take you to or connect you with the Center for Forensic Psychiatry for an evaluation regarding your ability to assist in your defense. Your bond in the meantime is set in the amount of $6,000 cash or surety. I don't believe it's been posted or probably will not get posted, but it will be set for further proceedings. I'm gonna do a target date here. Ross, let's see where you got a duty week.
I'm almost done with my duty weeks for the year, so.
I think I got RT. Oh, that's RI. All right, well, we'll set a date.
I'll make myself.
All right, Mr. Austin, best of luck. Continue to take your medications and do any other treatment as directed. We're gonna get a competency evaluation. All right, as I indicated, I do know that defendant, and I know there are some significant mental health issues. Let's set this for pre-exam for August 5th.
Judge, could we do a week earlier or a week later? I'm actually planning to.
August 12th.
That would work.
All right, I've signed the competency order. I don't think we have anything left, do we?
I-
All right, thank you. I'll sign these waivers. There's more coming. You'll go out to the jail and see Mr. Brownridge?
Yep.
All right, thank you.
Get those sorted. Josh, do you have a couple minutes?
All right, so is this criminal trial division?
It is, Judge, it's an arson.
All right, so if you'll talk to criminal trial division and let's see how far they want it set off.
Okay, Judge, I will.
All right, thank you. All right, who's here on Daniel Berlanga? And is he in custody? or- All right, if you'll come forward, please. Let me just pull this up in the system. Thank you for dressing appropriately for court. My odyssey is a little slow, so just give me a moment.
Oh, yeah. if you need a phone for me. Yeah,
All right, what are you here for today?
Judge, this is a case where we had a hearing on partial versus full house arrest, and
Mhm.
I asked you to advance the trial in light of the fact that you denied his motion.
Mhm.
So we're actually in line to get to trial. However, we were confirming this morning and the state is still getting new discovery and Brady disclosures.
Oh, no,
So we're
wait,
not quite ready.
so here's the thing. I'm gonna have you all come back tomorrow morning, state. You need to make sure they have all of their discovery. Is there a reason why there's late discovery?
As a result of the quick setting of this trial, we had to meet with the victim, get prepared, and at that victim meeting, she disclosed to us a lot of new things that had not previously been disclosed.
All right,
To us through, I guess, her interview with the detective and all that.
Mhm.
So we're wanting to make sure that because that was disclosed, that we have everything available to get.
so have you given them to the new information that was given to you by the complainant?
Everything that was disclosed to her on our interview with her, we have disclosed to them, which included, well, I uploaded the notes from the interview. There's a handful of videos that she disclosed to us that we uploaded for their review. And then some EMS records from her being created at the scene have also been uploaded.
It's too big.
All right, yes.
Your Honor, some of those videos are too large for the portal, so defense needs to provide the state with an external hard drive to burn those.
All right, I'm gonna have you all come back tomorrow at 9 and we'll see where we are. But what I can tell you is I'm not gonna charge a continuance to the defense.
Okay.
All right, so I'll see you all back here tomorrow. Ms. Ferguson, if you can give them a reset form for tomorrow, 9 a.m.
Understood, Your Honor.
All right, thank you.
lot of them. I didn't see the copy of it, but if you want the guys to do the video, basically, but all the video. But I'm pretty sure this is- If you reach me, I'll take a quick look.
John Robertson? Hi, you have Lori Valdez, correct?
Yes.
All right, they're gonna bring her out.
She apparently has a different attorney on a second case and
Mhm.
almost said that he is in trial.
Well, which case are you on? Are you on?
Possession penalty group 2.
All right, so his case is less than a gram, so it won't be controlling. All right, Norma, give this to me when they're ready to approach.
Judge, I just got notice of this setting yesterday. Got discovery this
problem.
morning, so I'll be-
Okay. They'll bring your client out. Emmanuel Gonzalez.
Come on, everyone.
All right, so defense attorneys, excuse me, defense attorneys, if you could not block the court's view down the center. Summer Mascata, Summer, Mark Descata, Mascata. Allison Settle.
She's here with a caseworker. I'm just speaking to her that she ran to the left.
All right, thank you. Robert Barnett. Robert Barnett, Mark Anthony Wizar. David Wayne Huff.
He's outside of the hallway, Judge. I was conferring with him this morning.
All right, thank you. Kevin Kenneth Deleuze. Thank you. Jesus, oh, he's custody. Emmanuel Gonzalez. Emmanuel Gonzalez.
I think he's walking the Emmanuel Gonzalez.
Emmanuel Gonzalez. All right, just have a seat. Samantha Venegas. All right, thank you. All right, the court didn't call the name of the persons that are in custody. So to the attorneys, if you have a client who is in custody, let the deputy know so that they can be brought out. Once you confer with the state and confer with the client, then you're ready to approach the court. Just approach the clerk or the coordinator, ask them pull your file, and I'll call you in the order of appearance. Yes.
Dismissal for evidence.
All right, thank you, counsel.
Thank you.
You're welcome.
This is for Mr. Mills.
Deputy Laura, was Jack Evans sent back?
I'm sorry, what was that?
Jack Albert Evans?
Yes.
All right, thank you. All right, Zachary Munoz, who do you have?
I have, sorry, Your Honor, Kevin,
Kevin Deleuze? Can I see the file on Deleuze, please?
My lawyer's not here.
All right. Oh, no problem. And Norm, I need a reset form for tomorrow for jury trial. This is family violence, is it not?
Yes, Your Honor. We've actually, believe we've come to an agreement with the state on this case. We've been conferring. Ms. Kramer is on a misdemeanor case. I believe what's going to happen is they're going to drop this case down to a misdemeanor VPO, and he's going to plead to 1 year deferred on this, run concurrent with this terroristic threat as well.
All right, when is that going to be done?
I'm speaking with Ms. Kramer to see when she could, I guess, get the misdemeanor case set. I believe it's currently in County Court 7. And
Do you
so
know?
We do, Your Honor. It's in County Court 13. We've requested the earliest setting that it can. We're hoping for before the end of this week.
All right. So what I'm going to do, Ms. Ferguson, recall this case for May 19th. And if everything is completed by then, you won't need to be back here.
Can I ask you a question?
I'm sorry?
Can I ask you a question?
Sure.
I'm still on the monitoring.
Yes.
I haven't had information given to me about how that works.
Oh, you'll remain on the monitor until this case is resolved. And the state is telling me that it will be resolved once the other case is taken care of. This case will be dismissed.
Question to you is that last time I saw you, you asked, you changed it to I can work Monday and Friday.
I asked both parties to come up with a schedule. And I said, once that schedule was given to the court would sign it. The court did not receive a schedule.
I will get that scheduled to you, Your Honor. I thought I'd emailed it, but I will email it again to Norma, and we will get that to you by today.
All right. All right. Thank you. So Norma, he needs a reset form for May 19th. All right. Once you sign the reset form, you're excused. You're welcome.
Thank you, Your Honor.
You're welcome.
Go ahead and grab a pen, sign this. Okay. Oh, flowers.
Yeah, the guard.
Yeah, Dari.
I mean, I haven't been here in the building till now, so
Okay.
could I ask for a day or something to try to find him?
You need to speak with the state and see if they have any objections to having this recalled for tomorrow.
Okay.
Could I see the file on Mosqueda, please? Summer? Summer, Mark Moscata, she's on page 2. Sure.
What's your plan? I understand that, but. Okay. Yeah, I think so. Moving out the other way.
Criminal Trial Division?
Yes.
Thank you. On page 1, Summer Mosqueda,
Yes.
her defense attorney said that he didn't receive notice. And this is their first setting here. So do you have any objections to recalling that for tomorrow without issuing a warrant? No. All right. Because what she's charged with is a state jail felony.
Yes.
All right, Norma, Summer Moscato is going to be recalled for tomorrow.
It's conferring with him about it.
I'm sorry. Oh, no, that's a separate matter.
Yeah, no, I'm talking about Barnett.
All right. All right, could I see, let me see. Yes. Are you ready to approach on Barnett?
Yes.
No,
Oh, he's not
because
ready.
I want to know if Mr. Barnett signed a reset form.
All right, if you'll check with them and I'll look in Odyssey as well.
Yeah.
I want to know if Mr. Robert Barnett signed a reset.
Hello, how are you doing? All right, council, where are we on discovery?
Judge, I was granted access this morning. I haven't had a chance to download it yet. It's the first setting. She was just indicted like 3 weeks ago.
All right,
So she has a different attorney on her other case, which is a state jail. He's in civil trial. So I think, I don't know where he's at on that. You have to talk.
oh, well, I don't think that's going to be the controlling case, most likely.
It's my goal to get the discovery, look at it, talk to Ms. Valdez over the weekend. And if we can come back to court, maybe I'll let y'all know
When would you like this recalled?
and leave it open.
No, I need to have a date for the system. If you want it called back sooner rather than later, I can call it back sooner. Or I can give you a date.
How about next Thursday? That works?
All right,
It'll work for you. How about Thursday?
Thursday, the 15th, or
Yes.
this Thursday?
Next Thursday.
Next Thursday? Okay, that will be the 22nd.
Okay.
All right. Ms. Ferguson, Lori Valdez, May 22nd. Is there anything else you need?
That's it,
Any
Judge.
questions? All right, thank you.
Thank you.
You're welcome. Bond forfeiture. Who is here on Michael Gonzalez?
Return.
Okay. All right, where is,
It's on his way.
okay,
It's a custody judge.
okay. Oh, your plea deadline date is has expired. And I know there were some issues because of defense counsel, you were in an accident.
Well, there was that, and then the last time I was here, Angelini was presiding.
Yes.
And so, yes, I
So-
conferred, but there was one single issue about whether or not there is a phone extraction.
All right.
And Judge, I just assumed the docket. I did see what defense counsel was talking about. I did send an email to the detective today to see if there was an extraction or not. It's unclear from the report. So I'm hopeful that I get an answer, if not today, very, very soon.
All right. Norma, have this case brought back tomorrow. It is Gonzalez.
Can we do it on Thursday?
Oh, you guys are up for trial. Is he gonna be wearing that? What does that say?
The Blight Club, it's a Magic the Gathering tournament club.
Ah, it's a gathering of,
Magic the Gathering, it's a card game.
oh, it's sort of like,
Pokemon.
no, what did they used to have before Pokemon? Dungeons and Dragons?
Yeah,
Yes.
yeah, it has some similarities.
Oh,
yeah.
okay. Does that glow in the dark? I'm just wondering.
No.
Let's turn off the lights.
Okay. All right, we'll bring you back tomorrow. Council, you need to have that information for defense.
Okay, yeah, I'll reach back out to the detective, so we need an answer ASAP.
All right, thank you.
Thank you.
Your Honor,
Judge.
just to clarify, when was our plea deadline then? Because when I was
Your
in
plea
front of,
deadline date was April 17th.
okay, just because when I was in front of Judge Angelini, I don't recall him saying that, but
Oh, no, so on April 4th, I set a plea deadline date for April 17th.
okay,
And then it got recalled, but I'll keep the plea deadline date open for you all for tomorrow.
okay.
All right, thank you.
Thank you.
Thank you.
Reapproach Mike Ross, so reset for the trial. I don't know if she still has it up there. Ross,
All right, who's here on Samantha Venegas? Who is here on Dwayne Huff? I'm sorry, David Huff?
Behalf, Your Honor.
All right, if
Judge,
you,
we've conferred this afternoon, Judge. There's an offer that my client is willing to accept, but he would just like a little bit more time. There's another drug case out there, but
just one moment. Where's your client?
he's out in the hallway, Judge. Would you like me to
Oh,
grab?
yes. All right, state, on this case, it shows that he has a case that is awaiting indictment. Has that, are the drug labs in for that or no? So what's gonna happen with this case?
Offer is 6/6 on this case, TIC in the.
All right, so, Mr. Huff, if you're accepting the plea from the state, we can either do this today or either you will come back tomorrow. What do you wish to do?
I've got somewhere to be this afternoon, Judge, and tomorrow's going to be a little bit tight. I've got 9 settings throughout the day tomorrow.
Okay, Ms. Ferguson,
Get 30 days.
yeah, Ms. Ferguson, recall this for Thursday for disposition. All right, once you sign the reset form, you're excused.
Thank you, Judge. That Grosso, Judge, that incompetency issue, the file should be up there. I can
All right,
correct it
I'll
today.
take that. Who's your client? The arson case?
Yes, Joseph Grosso.
All right, just give me 1 second. Let me put this in the system. Do you want all of the people to my left to be moved over to the right? All right, everyone, you're gonna move over to the right. Summer Mosqueda. Robert Burnett.
Now I'm here for it, but I don't see him.
All right. Could I see the file on Robert Burnett, please?
Afternoon. Ready on tomorrow.
All right, counsel.
Yes, Your Honor.
I'm sorry, I'm waiting.
All right, so your client is on bond, and I see
Yeah.
that this case was previously set on April 7th. It
Right.
was recalled for today, so he should know about the setting.
Yeah. I don't know if he's one of those guys maybe showed up in the morning. I don't know what happened to him. I mean, I haven't been here in the building till now, so
Okay,
could I ask for a day or something to try to find him?
you need to speak with the state and see if they have any objections to having this recalled for tomorrow.
Okay.
Could I see the file on Mosqueda, please? Summer? Some.
I trust you.
It's on a research.
Okay. Okay.
All right.
All right. Thank you.
Deputy, if you make an announcement, if someone would make an announcement for Robert Burnett, please. All right, thank you. All right, we're gonna go on the record. Court is calling 2025 CR 0000166 State versus Robert Burnett. Could I have parties announced?
Andrew Harris Edelman for the state.
Dwight Chumley's present for the defendant.
All right, this hearing was scheduled at 1:30. It is now 1:45. The defendant has not made an appearance. Defense, have you had any contact with your client?
I have not, Your Honor.
All right, state. Any requests?
Forfeit the bond, issue warrants.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Okay, thank you.
All right, thank you. Yeah, this one is a judge's warrant. Are the parties ready on Lori Valdez?
Yes, Your Honor.
Oh, no problem. Yeah, it's an odyssey. Mark Anthony Weezer.
He's not here, Your Honor.
Okay. All right. Have you had contact with your client?
The address they gave me is just homeless and I have called the number. Not since he's made bond.
Let me see. All right, could I have a prosecutor on Mark Anthony Weezer, please? Court is calling 2025 CR 003-216 State versus Mark Anthony Weezer. Could I have parties announced?
Megan Galloway from the state.
Christopher Simpkins for the defense.
All right, this hearing was scheduled at 1:30. It's now 1:51 PM. The defendant did not answer docket. Deputy Laura, was an announcement made? All right, have you had any contact with your client?
Not since he made bond, Your Honor.
All right, State?
Requesting a bond for your honor.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Yes, and I'll let the court know, thank you, Judge.
All right, thank you. Bond forfeiture. No. All right, the court is calling 2024 CR 008052, State versus Samantha Venegas. Could I have parties announced?
Jason Garrett, from the State Yard.
Danny Callahan, defense.
And are you Miss Venegas?
Yes, ma'am.
You entered a plea to count 2 on March 26. You entered a plea of no contest. According to your plea bargain agreement, punishment is to be assessed at a cap of 15 years in the prison. There's a $2,000 fine. State opposes your application for community supervision and deferred adjudication. They're taking in consideration 2024 CR 008054. Have both parties had a chance to review the PSI report and TAP evaluation?
Yes, Your Honor.
Yes, Your Honor.
Any objections, state or defense?
No, Your Honor.
Any witnesses, state?
State.
Defense, any witnesses?
Only allocution in writing from the defendant.
All right, any objections to the court reviewing the defendant's writing?
No, Your Honor, the state is actually reviewed. No objection.
Counsel. All right, the court will hear argument. Well, before I hear argument, there are some things that defense, maybe you can address with the court. It says in the PSI that her guilt is minimized. And I did read where she's saying that the vehicle's not hers. She knew there was drugs in the trunk, but she didn't throw them away. She didn't do anything about it. So I don't know if there's any insight you would like to give on that.
Yes, Your Honor, I think it's a good inference from the stipulations and the PSI that she was used as a pawn, taking advantage of her poverty and her addictions to methamphetamine. And she's ashamed of that in her life, not only you, but more particularly to her family. There is an element of voluntariness in her actions. There's also an element of being trapped in her actions. And that was one of the things I would ask the court to consider before you assess punishment. I have 3 other remarks.
All right, you may proceed.
And I suggest to the court as a proper resolution of this case, because she's still relatively young, deferred adjudication, 10 years, ISF treatment, and she asks you to put her into drug court, which is intensive supervision for every day. That shows some indication of remorse and desire to be rehabilitated.
All right, so here's part of my issues, right?
Yes, ma'am.
One, I have to look at criminal history. And I would have clients sometimes, you know what they would tell me? Why are people looking at my criminal history? We're just here for this. That was in the past. But I would always tell them that your criminal history is sort of like a credit report. And what you're trying to get is probation. So people are trying to say, has she been placed on probation before? You know, will she do well? So it shows that you've been on probation before. And a motion to revoke was filed and you were revoked and sentenced to 5 years. I know that was in 2007.
Right.
And then in 2014, you were sent to prison for another case. And in 2015, there's a case that you were sent to prison for, and I believe these were running concurrently because it appears that they were running concurrently. And then 2016, again, that's a case. It was running concurrently with the others. So what I'm viewing, it doesn't appear that you would be a good candidate for probation.
May I say something?
Sure. You want to raise your right hand though, because the state may have some questions if you want to say something. All right. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Samantha Benavides. I know, okay, I did, in 2010, I went to prison. I was gonna get reinstated on probation, but I took it up with my grandfather, and my grandfather wanted me to go do the time instead of being reinstated on my probation, because he was scared that I was gonna get messed up again and go do a large number of time, and he was gonna pass away.
And
while I
how
was
old were
gone.
you when that happened?
I was 29, 30. And so that's why I chose that. I chose that because my grandpa asked me to do that, and he ended up passing away 6 months before my release. But that is why I was gonna get reinstated. At the time, my attorney was William Reese, and they were gonna reinstate me and send me home, but my grandfather asked me to get it over with. That is why I went to prison.
All right, so you're telling me that I could understand maybe there being pressure on you with saying, oh, let me listen to my grandfather and take this time. But at the time you were 29, 30. Okay.
Yeah.
And then the other cases, because you got out of prison and then you pick up more cases.
In 2014, I revoked. I have my parole, and I went back to ISF for the last 3 months of my my parole. And then that was done with that. And then in 2016, I went to prison again in 2016. And then I revoked and went back to safety, and I came out and I completed the rest of my probation.
Okay. Why do you keep failing at probation?
Of it with parole, the second.
Well, I mean, you failed at probation and you failed at parole. Why?
The first time when I was younger, I really don't have, you know, I made some poor choices in my life back then, and I was young, I was ignorant.
But no, for the case that you said the first case, you said, I just agreed to be revoked because of my grandfather.
Yeah.
All right, you're telling me then you were 29.
Yes, I didn't
30.
go report.
All
I didn't
right.
go report, and I
But then
had
you-
a drinking problem back then.
Okay.
And back then I would use cocaine a little, and but I had a heavy drinking problem. So I was young, I was stupid, I was living in the bars, basically. And I wasn't, you know, keep out there running the streets or nothing like that. I just didn't want to go report. And that was my biggest downfall right there. If I would have just went and reported and went and taken a UA, everything would have been okay. My life would have been a little bit, you know, different. The other time, when I got out, I violated parole. It was because I came out of dirty UA.
Okay, let me ask you this, because I understand your past. Do you know the amount of drugs this was, the weight of it?
Yes, ma'am, I do.
It's a lot, right?
Yes, ma'am.
Okay, you can continue.
My life for a little while, I was just, I made a lot of mistakes, and I'm not proud of it. I'm very sorry for them. If I could take them all back, I would. Now that I'm older, now that I see things differently, and trust me, this opened my eyes. I was doing a lot, you know. I was just trying to, this last offense I was something, it was just, I was trying to, you know, get by, pay my bills. I was stuck in it. I was just trying to get out of it. And I see now that what it cost me, what it could cost me. And I apologize for that.
No, but here's the thing, you had a previous drug case.
Yes, ma'am.
So I don't understand why you continue to try to build your happiness off somebody else's misery. And when you sell drugs, that's basically what you're doing. You're taking a shortcut and you're building your happiness off somebody else's misery who has a drug addiction and can't stop. And there you are giving them drugs for money.
Correct, you're right.
All right, State, do you have any questions?
Just facts of this case.
Okay.
Mr. Vegas, on this case, you stated that the drugs weren't yours or the drugs were somebody else's.
It wasn't mine, it was in the vehicle.
All right, could you speak up, please?
It wasn't mine, it was in the vehicle, but I was aware that it was in it, and I should have gotten rid of it.
So you're
When I
aware that you had a
located it.
key in your pocket that matched the lock to the box that the drugs were in. correct?
Yes, correct.
Okay, no further question, John.
Nothing further. I have one other point, Your Honor.
Yes.
She has family support and was unable to get finalized letters into your hand indicating that support. That's all, Your Honor.
All right. Ms. Venegas,
Yes, ma'am.
the amount of drugs in this case
Yes, ma'am.
is, let me see, over 400 grams.
Yes, ma'am.
And from what I read in the police report, you're a seller of drugs. And this whole thing about the drugs being in your boyfriend's car and you don't know, you knew the drugs were in your boyfriend's car and you should have got rid of them, but you didn't. It doesn't ring true based upon what I read in the police report, because according to the police report, you're known as a trafficker of drugs. That's what it says in the police report, and that's what was stipulated to. I don't think you're a good candidate for probation. The court is going to find you guilty. The court will sentence you to 15 years in the prison. There's a $2,000 fine. Time and money will run concurrently. The court will take in consideration 2024 CR 008054. I'll suggest the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal, excuse me. Thank you. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
May I address the court? And she would
Yes.
like drug therapy.
All right, I'll add the therapeutic community.
And one more thing, Your Honor.
Yes.
Would the court entertain a delay in imposition of sentence 1 week and let her go and take care of her affairs?
No.
Thank you, Your Honor.
All right, thank you.
Thank you.
$2,000 fine, time and money to run concurrent.
We tell her Patterson.
Hey, could you give that to probation, please? Thank you. State on that dismissal for her.
USA, people find themselves in court.
A form for fingerprints.
Okay.
And you need to go to the sheriff's department, provide your fingerprints, but then you'll be free to leave, okay?
All right.
All right. Thank you. We are adjourned. Do I have Mr. Sanders? No, I don't, because I called
Yes,
his case.
I'm right here.
Oh, You're
I'm
right
on
there?
video.
Okay. Oh, you're on video. Okay, I cannot
Yes,
see
yeah.
you.
Okay. Should I push the, let me see. I can't see it's, mouse isn't working real well.
And that's fine. If you can't get it to work, that's
I
totally
can,
fine.
but I'm pretty sure I can. I already did it once. It was, I can get there. It's just, it's crazy here.
Mr. Sanders,
Anyway.
have you applied for the public defender's office yet?
I have not. I didn't know, I don't know what, is that better, Your Honor?
Yes, that's much better. You need to apply for a public defender or you need to retain an attorney, sir. These are very serious charges.
Yes, I understand, Your Honor. And I do want to do that. I do need to do that, Your Honor. But, we'll go ahead and talk, but I would like to request a bail reduction amendment. So
Well, I see that and we'll address that, but this is very serious. It's a G felony. It's very serious. So you need to contact the public defender. And you've been in custody now for some time, I think over a week. And
10
so
days.
you really need to contact the public defender.
Okay, well, very limited information around here, I've noticed.
Well, I don't know what that means or, but it's not their job to tell you what to do.
I know, I understand that, Your Honor.
We'll go on
But
the
I would-
record in the matter 25 CF 66, State of Wisconsin versus Kevin Sanders. The state appears through District Attorney Kevin Schmidt in person. Mr. Sanders appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for an initial appearance. Mr. Sanders, this is a very serious case. It's an OWI 5th or 6th, a Class G felony, a possession of drug paraphernalia, a U misdemeanor, and operating while revoked, a U misdemeanor. These are serious allegations and charges. Off the record, I inquired as to whether or not you've applied for a public defender or you have retained your own private attorney. You indicated you had not done either. Mr. Sanders, I am highly recommending that you contact an attorney and or you apply for a public defender immediately. Again, these are very serious. You do have a right to represent yourself if you wish to do so. That is your right. But I'm just informing you that a Class G felony is a serious matter. Mr. Sanders, I need to ask you if you wish to proceed in an initial appearance here today and represent yourself, or if you wish to have this matter adjourned to a different date and time to allow you to apply for a public defender and or retain your own private attorney. Do you wish to proceed with this hearing here today? Or do you wish to adjourn it? And I will still hear you on bond, no matter what your answer is.
I would just wish to adjourn it, Your Honor. Is that my option to get an attorney to adjourn?
Yes, I can adjourn it to allow you to get an attorney.
Yes, Your Honor, I would like that. Thank you.
I'm going to adjourn it to 1:30 on May 28th, 1:30, May 28th. Now, Mr. Sanders, as to a bond modification request, I have read your request, your written letter. I'm going to tell you, it was kind of hard to read. It's in pencil, and I just had a very difficult time reading your handwriting. So I'm going to ask you to explain or argue to me on the record what it is you're seeking and what it is you indicated on your written request, okay?
Yes, Your Honor. Well, what I am seeking is a amendment on my bail, lower amount. Because I'm not receiving the medications that I'm supposed to be taking daily. Somebody here has decided that I don't need them. And the sertraline is for PTSD. And I'm not getting that. I haven't had it for a week. It's wearing out. It's already wore off and I need to, and they're here. My friend dropped them off here for me, but apparently, and also the magnesium chloride. My body doesn't produce magnesium, that mineral, and now it's been 9 days without that also. And now I have to go to the hospital to get a IV drip, a bag of magnesium put into me. So, because that magnesium I take is only to maintain the level. I have to take it twice a day to maintain my magnesium level.
What's going on? What's your illness or disorder?
Well, lack of I don't know what they call it. It's lack of magnesium. I don't know if there's a disease about it or anything. All I know is that
Why do you take the citrulline?
Sertraline?
Sertraline.
Yeah, that is to control PTSD and anxiety.
Okay.
I'm a military veteran, Your Honor.
I understand, and I do commend you for that. I highly respect our veterans. Anything else you want me to know?
I intend on going to the VA for alcohol treatment as soon as I can, as soon as I get if I can get enough space between court dates, and if I can bail out. I really want to bail out so I can do something, take care of stuff. I know I'm an alcoholic.
Sir, I really want to hear all of your story. I just have to ask or inform you that anything you say can be used against you in this case. You do not have an attorney right now, so I'd be very cautious of the things that you say, all right?
Yes, Your Honor, I understand.
All right, so is there an amount that you would be able to pay in lower a bail?
$3,000.
$3,000?
Yes.
All right, Mr. Schmidt, argument?
Just reading one thing. Yeah. I guess what my big concern would be is his ties are much stronger to Minnesota than Wisconsin. The courts noticed all of his prior OWIs are Minnesota. He has a siren address now. When I look at Minnesota, his last two OWIs, he had multiple missed court appearances there in 2020, 2021, 2022. This is a high OWI with a high penalty, much higher than what Minnesota would do compared to Wisconsin for OWI. I see that he's twice been extradited from Wisconsin to Minnesota on these OWI offenses. So I guess I'd have concern about him appearing in court. Thank you.
Mr. Sanders, how long have you lived in Siren?
Since I've lived in Siren since 2016, and I lived in Polk County from 2006 till 2016. I've been in Wisconsin for those many years. And
Mr. Sanders, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God, under perjury?
Yes, I do, Your Honor.
All right, penalty of perjury. Are you swearing to the court that if the court were to trust you and amend the bond to an amount that you can post $3,000 with the conditions that I have to protect the community, you are going to seek treatment and you will make all court appearances?
Yes, Your Honor, I do.
Do you understand that if you do not make a court appearance, you miss a court appearance, or you are late to court, that means that $3,000 goes bye-bye. It goes to the county general fund. Do you understand that?
Yes, Your Honor, I do.
Do you understand that? To me, $3,000, that's a lot of money. Is that to you?
Yes, Your Honor, it is.
All right. So what I'm going to do is I'm going to trust you. I'm going to trust you, and I'm going to trust that you're going to seek veterans services. I'm actually going to add that as a part of your bond condition to seek veterans services. I will amend it to a $3,000 cash because I still believe that that is a significant amount to assure your appearance with the same conditions I have, except adding that you will seek veterans services. Mr. Sanders, if you are in an inpatient treatment facility and you have a court date, you must notify the court ahead of time. And if you have the ability to appear by Zoom, then you need to ask the court if you can do so. I most likely will be lenient and allow that to occur. You also need to apply for a public defender today or by the end of the week, so that you can know if you are appointed and qualify for a public defender, or you need to retain a private attorney, okay?
Yes, Your Honor, I understand.
All right. So we will see you on the May 28th date. We are amending bond. It'll be sent up to you for signature, okay?
Thank you, Your Honor.
Thank you. We are adjourned. Mr. Rosenthal. Or that's Mr. Keen. Mr. Rosenthal, I knew I had you. Do we want Mr. Den in person or by Zoom is okay? Who is Mr. Den? You're Mr. Den.
I'm Mr. Den.
Yes, you're Mr. Den. Zoom or in person?
We have a plea, so I presume you'd rather have him.
Okay, yes. So I just wasn't sure what was happening because I wasn't sure if that was really happening. All right. Now let me. Well, Mr. Keen. We will go on the record in the matter 25 CF 22, State of Wisconsin versus Michael Den. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Den appearing in person in custody with counsel Glenn Keen. We're set today in this matter for a final pretrial. The court's drop dead date as to any agreement to be reached. The parties have reached an agreement. Mr. Keen, can you please recite the agreement for the record?
Yes, Your Honor. The agreement calls for Mr. Den to plead guilty to count 5 with all other counts dismissed and read in. We're both calling for a PSI with the state restricted to the PSI cap with defense free to argue.
All right. Mr. Den, that is the agreement that you have reached with the state?
Yes, Your Honor.
So I have in front of me a plea questionnaire, waiver of rights form. Do you recognize this document?
Yes.
Did your attorney go over this document with you?
Yes.
Did he go over it thoroughly with you?
Yes.
Essentially word for word?
Yes.
You understand everything on that document?
Yes.
If you didn't understand something, did your attorney explain it to you until you did?
Yes.
And attached to that document is the jury instructions for possession of a controlled substance with intent to deliver with lesser included offense of a possession of a controlled substance. Did your attorney go over that with you?
Yes.
And you understand that?
Yes.
And he explained it to you thoroughly?
Yes.
You are pleading guilty to 1 count. That would be count 5, possession with intent, methamphetamine greater than 10 grams, but less than 50 grams, a class D felony. Is that correct?
Yes.
You are 63 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that correct?
Yes.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties that you face?
Yes.
You are not receiving treatment for a mental illness or disorder, but you have had some type of medication in the last 24 hours?
Yes,
What type of medications?
I'm not for sure for diabetes.
Just diabetes?
Yes,
And those medications don't interfere with your ability to comprehend or understand?
no, they do not.
Okay. Other than that, no alcohol, medications, or other drugs?
No,
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Did your attorney thoroughly go over those rights with you?
yes,
Do you understand them completely?
yes,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that you'll no longer have the right to a trial?
yes,
You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. You would also no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm or have a concealed knife, which would include a pocket knife, for life.
yes,
Do you understand that you would not be able to vote in any election until your civil rights are restored?
yes,
Do you understand here that the state would have to prove on or around January 24th, 2025 in Burnett County, Wisconsin, that, give me one second, in Burnett County, Wisconsin, that you did possess with the intent to deliver a controlled substance, to wit, methamphetamine, in an amount of more than 10 grams, but not more than 50 grams, contrary to Wisconsin law, a Class D felony. Do you understand what the state would have to prove?
yes,
Do you understand that upon conviction, you face a fine of not more than $100,000 or imprisonment of not more than 25 years of incarceration, or both?
yes,
Do you understand that there is an agreement that's been reached between the parties in which the court would order a pre-sentence investigation report and the state would be capped at the recommendation for sentencing in that report? Do you understand that?
yes,
Do you understand what that PSI report is?
yes,
And that document will have a whole lot of information about you and about your life, and it will provide a recommendation from the Department of Corrections standpoint as to sentencing. Do you understand that I'm not bound to follow that recommendation?
yes,
Do you understand I'm not bound to follow the recommendation and argument of the state?
yes,
And I'm not bound to follow the argument and recommendation of the defense when defense is free to argue. Do you understand that?
yes,
Do you understand that it would be my discretion to sentence based upon the facts that I have? And it could be up to the maximum possible penalty.
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Did you go over the criminal complaint with your attorney?
yes,
In particular, there is a section called the probable cause section, which basically says what happened that day and why you were charged with the crimes. Do you remember that?
yes,
He is showing you a copy of the electronic criminal complaint right now. For the most part, are those facts, are they accurate?
yes,
Are you admitting here today that you in fact did possess with the intent to deliver methamphetamine?
yes,
And it was greater than 10 grams, but not more than 50 grams.
yes,
And so you're admitting here to having the guilt with possession of intent to deliver methamphetamine.
yes,
Mr. Keen, may the court use the probable cause of the criminal complaint along with the statements made by your client to find a factual basis.
yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Den, for you to plead guilty to this charge?
No,
You're doing so freely and intelligently. That means you understand what you're doing here today
yes, Your Honor.
voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
yes,
Are you satisfied with his services?
yes.
Do you have any questions for the court or for your attorney before I proceed?
No, thank you.
Mr. Keen, do you believe that your attorney is entering his plea freely, intelligently, and voluntarily
Yes, Your Honor.
with a full understanding of his constitutional rights and what he would be waiving?
Yes, Your Honor.
Do you understand do you believe he's entering his plea competently?
Yes, Your Honor.
Did you thoroughly go over what the state would have to prove, those elements with the facts of the case from the discovery?
Yes, Your Honor.
And did you go over the strengths and the weaknesses of the case with your client?
Yes, Your Honor.
Mr. Den, do you believe that your attorney went over with you whether or not you have any defenses or a lack of defenses in this case?
Yes.
Are you satisfied with his services?
Yes.
One last time, do you have any questions for the court or for your attorney before I proceed?
No, thank you.
As to count 5, possession with intent to deliver methamphetamine greater than 10 grams, but less than 50 grams, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 5. The remaining counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Mr. Den, on the second page of the plea questionnaire waiver of rights, is that your signature?
Yes.
The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available if questions arise. The court will now revoke bond and will set the matter for sentencing. I can do July 29th at 1.
That works for the defense, Your Honor.
All right. Okay. We'll see you July 29th at 1 o'clock.
Right now,
We are adjourned.
No,
okay, okay. Talk to you.
Yep.
I can't hear you when you're
Right,
whispering.
yeah. Okay.
We're done?
Yep.
Thank you, Your Honor.
Thank you,
You
Mr.
have a
Ben.
great day.
Ms. Benjamin, Mr. Rosenthal, can you hear me?
Yes.
We will go on the record in the matter 25 CF 65 State of Wisconsin. Sorry, called the wrong case. I didn't close out all those cases and open the new one. We will go on the record in the matters 25 TR 326 and 25 CF 57 State of Wisconsin versus Kelly Newman. The state appears through District Attorney Kevin Schmidt in person. Ms. Newman appears in person with counsel Nicholas White. We're set today in this matter for a preliminary hearing. Mr. Schmidt, please call your first witness.
Sure, I call Patrick Carlson.
Mr. Investigator Carlson, please come forward, raise your right hand, be sworn in, and have a seat at the witness stand.
Do you swear that the testimony you're about to give in the matter today is the truth, the whole truth, and nothing but the truth?
You may begin.
Could you state your name for the record?
It's Patrick Carlson.
What do you do for a living?
I'm a detective with the Burnett County Sheriff's Office.
How long have you been so employed?
I've been employed with Burnett County for a little under 10 years.
On April 18th, 2025 in the morning, did the Burnett County Sheriff's Office receive any phone calls about child custody?
Yes.
What was the nature of the phone call?
I checked on just prior to 8 a.m. and was dispatched to 118 Broadway Avenue West in the village of Grantsburg for a child abduction.
Why did you go there?
It was relayed by DL that Kelly Newman ran up to her residence when she was taking her kids out to bring them to daycare and took KS without consent and drove away with her.
Is that who you made contact with at that address?
Yes.
What did you talk about with her when you made personal contact?
I asked her to tell me what happened. She said she walked outside to get the kids to the van and then observed Kelly walking up and described that she was parked down the street behind other vehicles where she wasn't able to see her in the vehicle at first. And Kelly went up and grabbed KS, and DL told her she could not take her. And Kelly said she was gonna, and Deborah said she was gonna call the cops, and Kelly told her to call the cops. And Kelly ran back to the vehicle and drove away with KS in the vehicle.
What is Kelly Newman's relationship to KS and to DL?
So Kelly is the non-custodial grandmother of KS, and DL is the other grandmother, but is the legal guardian of KS. She has been given guardianship through Burnett County.
How do you know that?
We were provided guardianship paperwork from social services and also directly from DL.
Okay. So what did you do next for your investigation?
Based on direction of travel, we believe that Kelly may have been returning to her mother's residence, which is located north of there in the village of Kranzberg. I responded there and spoke with Kelly's mother, who stated that Kelly had her vehicle, had made comments about taking KS earlier in the day, did not know that she was going to do it, and at the current time did not know where Kelly currently was. I went back and spoke with her later in the day and learned from her mother that Kelly was in Minnesota with the child and near Rush City at another family's residence, and that they had called after seeing the missing child alert get broadcasted, and Kelly was believed to be traveling back to Grantsburg with KS.
Did they know why Kelly was driving back to Grantsburg?
She said she just told the family members that she was going home.
Okay. I guess I should clarify, the place you made contact with DL, did she say that's where KS was abducted?
Yes.
And was that in Burnett County?
Yes, it was in the village of Grantsburg in Burnett County.
Okay, so going back to what you were saying, you had information Kelly Newman might be coming back to Wisconsin. What'd you do next?
I then notified other deputies that were out looking for KS, and one of the deputies set up at the state line and observed Kelly driving into the state of Wisconsin from Minnesota in her mother's vehicle. And they made a traffic stop on Kelly near the state line and located KS and was able to reunite her with DL, and Kelly was taken into custody.
So KS was in the vehicle?
Yes.
How old is KS?
4 years old.
The Kelly Newman who was arrested, do you see her in court here today?
Yes, she's sitting at the defendant's table in a white t-shirt.
The record reflects that investigator Detective Carlson has identified Ms. Newman.
So. Other questions?
Mr. White, questions?
Yes, Your Honor. Investigator, you testified that there was some guardianship action. Is that how DL, I guess, became the custodian of KS?
Yes.
And is there any part of that guardianship action that states that Miss Newman's not supposed to have contact with that child?
Not to my knowledge.
Okay. Just to your knowledge, is there any court order preventing Miss Newman from having contact with a child?
Objection, relevance, that has nothing to do with one of the elements of the offense.
Sustained.
As part of your investigation here, how many hours do you believe that Ms. Newman had the child for without consent?
Would have been to about 7:50 a.m. to 11:09 a.m.
And this fact about an allegation where there's crossing state lines, did that factor at all into this arresting decision?
Yes.
I don't have any other questions, Judge.
Redirect,
No.
you may step down. Thank you, Detective. Any other witnesses?
No witnesses. I would just ask the court to take judicial notice of document 6 in Burnett 24 JG01, which is as well as document 9, which are the documents assigning DL guardianship.
Does defense have a copy of those?
I have not because,
Then I cannot take judicial notice.
okay. I can print those out for defense and then ask the court to do that.
All right.
The reason I'm doing it that way is for privacy reasons, since it has the names of all those people in
I
that.
cannot, it has to be, you cannot share it as a confidential case, so I'm not taking judicial notice.
Okay, thank you.
All right. Any witnesses, Mr. White?
No witnesses today.
I don't believe I need argument. The court has heard enough from Detective Carlson to find that a felony was probably committed, and it was probably committed by Ms. Newman. So the court does find the probable cause and will bind the matter over. The burden here, Ms. Newman, is it's a relatively low hurdle. The court must look at the evidence in what's called the light most favorable to the state in this hearing, but it's just this hearing. And the court has to find that a felony was probably committed, okay? And so the court did find the probable cause information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Proceed with the arraignment or set for another date, Mr. White.
Your Honor, we can proceed with the arraignment today.
She understands the charge and the maximum penalty.
Yes, she does.
Waive formal reading.
We'll waive further reading, enter a not guilty plea to count 1.
Not guilty plea will be entered on her behalf. She is entitled to a jury trial. She would be entitled to a speedy trial should she request one. Are you still on Phantom Lake Road?
No.
You're not? May I
No.
get an updated address, please?
307 North Oak Street in Grantsburg, Wisconsin.
Okay, and let me just quick see. Can I get a telephone number, please?
715-222-9757.
May we send you text message notifications?
Yes.
All right, thank you. Next date and time for a status. I can do your June 23rd at 1:45, Mr. White, June 23rd at 1:45. We'll see you then. We
That
are
works.
adjourned.
All right, thank you, Judge.
See you, Patrick.
Anyone in the jail? I'm asking you to unmute and I'm asking you to start the video. There we go. Thank you. We will go on the record in the matter 22 CM 123, 22 CM 124, State of Wisconsin versus Jolene Brask. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Brask, who is appearing by video conferencing in custody in Burnett County Jail. We're set for a return on warrant initial appearance in both of these cases. Warrants are quashed. These cases are from 2022 and they stem from when Ms. Brask's mother was in BMC and the facility had a no contact with Ms. Brask So that's where these stem from. Before we get too into it, Mr. Schmidt, and before we look on whether or not we need bail and bond and any of that, and if she's going to get an attorney, is there an offer that could be presented to Ms. Brask?
No, I'd have to look at the case more.
All right.
And I would like to thank the two of you before we begin. Is that okay?
Sure.
You are like, I taught children for 20 years. I've used analogies, but you are like a starburst candy. You are a star in the courtroom, a star in the community, and you burst listening ears. You burst love, kindness, compassion. You burst a good conscience, and you listen to your conscience to be a star in as many situations as you can. So thank you for who you are, and I'm delighted to be here today.
Thank you, Ms. Brask. That was very warm and heartfelt, so thank you.
And Zachary's my judge?
No.
It says Zachary Fisher on the screen.
Oh, no, Zachary, he's an attorney for the public defender. He's just kind of hanging out.
Oh, good. He's listening to this?
Yes.
Okay, Zachary Fisher, thank you for who you are. I'm glad you're going to be my public defender because we're going to go fishing for some good things to happen in the lives of people. I taught children, first graders A to Z, and you and I are going to have a blast, and we're going to laugh a lot, and I'll predict my emotions. I'll say, Zachary, we're going to laugh now. Courtroom, we're going to laugh now on June 10th. And we're going to just have a wonderful time of laughing and crying together. To honor my mother, and honor my dad.
Yes, I'm sorry to hear about your mother's passing.
Yeah, but that's a wrong, what you told me is not correct. You said there's a no contact. That's how you word.
It's no longer there. Mr. Fisher, I'm not sure if you want to take a public defender case. If you do, you're more than welcome. Ms. Brask,
I would like him to be my public defender.
Have you applied for the public defender's office to see if you qualify?
I know that I qualify. I've qualified in Minneapolis, St. Paul for North. I've qualified for mental health with other people in the Twin Cities.
You need to still make an application though. You still need to talk to them on the phone and see if you qualify. Mr. Schmidt, so.
Just a minute. Zachary, jot down my phone number. I'm very busy with appointments. But if you could call me sometime in the next week, the court date is
I'm
June
sure
10th.
we're going to address that a little bit. I just need to mute you for a second, okay? Muted. Mr. Schmidt, we need to discuss bail and or competency.
Well, I do observe in the original reports from 22 that the defendant made assertions about a cult. Let me use the exact wording. About a cult in Burnett County violating the rules and laws of God. When I look on MCRO, I see that it appears she was committed in Hennepin County in January of this year. I'm looking to see if she still is.
Okay. I will have her get assistance or help with unmuting and then make sure that we have her correct address because I have Crystal, Minnesota. All right, Ms. Brask, if you can, there should be a button now that you can hit to unmute because we need you to answer a question and Mr. Fisher can't be involved at least at this stage. Use the mouse, use that mouse or yeah, use the mouse to go click it. Is Sudi anywhere near you? Your CO? There you go.
When does the judge
I
appear?
have an address for you in Crystal, Minnesota. Is that correct?
That is correct. My debit card was declined. I should have been out of here on Monday evening and I had 20 minutes till and I'd be out because if my debit card is declined to pay my bail. I have money to pay my bail.
All right, okay.
I want to get home as soon as possible.
And so you live on Florida Avenue North?
That is correct.
And is your telephone number 0570?
Yes, that is correct.
And now Mr. Schmidt said that you are receiving services and it may be
Yes,
entitled
correct.
a commitment in Hennepin County.
That is correct.
And so you are under that?
I'm currently under a 12-month Jarvis commitment until, I believe it's till January of next year. With
Yes, Mr.
Hennepin
Schmidt.
County.
I'm gonna move to dismiss both cases for the reasons being the victim in both is deceased. When I continue to look at MCRO, it seems consistent with what she's saying, and she's been committed 13 times since 2008. So.
Okay, sir,
All right.
sir.
So,
No, just
Mr.
listen. I should
Ms.
not be here. I should not be here. I did not violate the
Nope.
law.
And Ms. Brask, that's exactly what he's saying right now. He's dismissing the cases. He's asking me to say, you know what, I'm gonna grant him, both cases are dismissed, so you don't need to come up with bail. You get to be released, okay? And you get to go home.
I don't have to pay bail?
You don't have to pay bail. You get to go home, okay?
Why don't I have to pay the bail? 800 bucks
Because
I was gonna pay 2 days ago.
You don't have to worry about that. As of right now, the state, Mr. Schmidt is asking the court to dismiss these matters and grant that, so they'll go away. You don't have to worry about them anymore, okay?
Do I have to pay the bail on June 10th? When I have
You
my
don't have
court
to pay
hearing?
any bail, no bail ever. You don't even have to come back to court, okay?
I wanna be in court June 10th.
You don't
I
need
want-
to.
I will be there. I will be there
Okay.
June 10th. I will be there.
Sounds great. We'll see you on June 10th. But you're
No,
gonna
June
be
11th.
released.
I'm sorry, June 11th.
June 11th sounds great too. You will be released as soon as we can get the minutes up to the jail, okay?
Thank you so much.
Thank
You
you.
made my day. I thought I have a tree that needs to come down. Thank you.
Excellent. You're welcome. We are adjourned.
How do I get out?
Sudie will come get you. Your CO, she'll come get you, okay?
As a first grade teacher, I've never been in the self-contained classroom of a hearing and this kind of thing. This was the first time I've had one of these. I have attachment disorder, lack of bonding.
State of Wisconsin versus Byron Benjamin. The state appears through District Attorney Kevin Schmidt in person. Mr. Benjamin appears by video in custody in Burnett County Jail. We have his newly appointed counsel, Daniel Chapman, in person. We're set today in this matter for an initial appearance. First and foremost, I believe we can address it after the fact of bail because the charges do not mirror the alleged allegations that were presented in the probable cause statement. So bail is going to need to be addressed. Mr. Chapman, were you able to go over a criminal complaint with Mr. Benjamin?
I wasn't able to discuss the actual complaint with him, but he knew what the charges were going to be at that point, and we discussed the charges. I believe he's probably received one by now.
Mr. Benjamin, do you understand those two charges and those maximum penalties?
Yes.
Waive formal reading?
Have you received a copy of the complaint yet, Mr. Benjamin?
Yeah.
Okay, yes, Judge, we will waive reading of the complaint.
Mr. Benjamin, are you still on Oshki Udina Street?
Yeah.
And can I get a telephone number when you're not in custody, please?
Yeah.
Which is?
320-591-0994.
May we send you text message notifications of upcoming hearing dates?
Yeah.
All right, not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. As to bond, Mr. Schmidt?
I don't have any objections to reducing it. I'd want conditions of AODA to remain on there. Alcohol was believed to be involved. I think the court set a high cash bond based on a PC that said substantial battery. The substantial battery was based on police contacts with an individual who was not cooperating with them and continues not to cooperate with the state to this day.
All right. So any idea or suggestion as to the cash that you're requesting?
I would suggest, I don't have a restitution number on the criminal damage, so
What was damaged? Because I didn't get that either on the,
Looks like a gate fence board was broken out and possibly a windshield on a car.
Yes.
right. Mr. Chapman,
Judge, I just did a look on CCAP and I don't believe Mr. Benjamin has any prior criminal history. These are misdemeanor charges and he's now been in jail for over 2 weeks. I think a signature bond is appropriate at this point.
Mr. Benjamin, are you swearing and attesting to court that you're going to make all of your court appearances?
Yeah,
You're going to abide by the law and the conditions that the court sets to protect the community?
yes,
$1,000 signature bond, same conditions. Next court date, Mr. Chapman, July 31st at 10:45. That is your status block date.
That's fine then.
All right, we're adjourned. Thank you.
July 31st.
July 31st at 10:45. Mr. Chapman, I also appointed you another case and I can go
For
over
today?
it with you a little later. You're not officially
For
appointed.
today, Judge?
No,
Oh, okay.
for, it'll be on your June 19th day.
Who was it?
It is, I can give you the complaint too. You're not officially appointed. He has to put a deposit down first. Where is it?
I don't mean to interrupt. It looks like Mr. Benjamin's trying to get.
Jeffrey
Oh, I
Butler.
can't see you. Oh, there you go, Mr. Butler. We will go on the record in the matter 25 CM 78, State of Wisconsin versus Jeffrey Butler. The state appears through District Attorney Kevin Schmidt in person. We have Joel Feliski, Defense Counsel in person. Mr. Butler appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for an initial appearance. It appears that there's 2 counts of drug paraphernalia being charged. Before we determine if we go normal course, is this a case that an offer could be presented?
Yeah,
It appears that he's been in custody for over 2 weeks.
I'm looking at.
I believe that is for a probation sanction, Your Honor, based on my conversation with Mr. Butler. He has also advised that he is scheduled to go into treatment with the DOC.
He's also on a cash bond, so he has credit.
Yeah,
coming
so
on
he'll
this.
get credit.
Oh, I see.
I would propose an ordinance on the paraphernalia in count 1, dismiss the other for $250, appreciating that he's been in jails for 2 weeks.
Mr. Butler, do you understand what Mr. Schmidt is asking of the court?
Yes, Your Honor.
To amend the crime down to or for the crime of a misdemeanor down to an ordinance violation, like a ticket with a court cost of $250. Do you understand? And you understand that offer? Do you wish to accept it?
Yes, Your Honor, I could accept that offer.
Formal motion to amend count 1.
So made.
Granted. How do you wish to plead? Guilty or no contest?
Guilty, Your Honor.
Court will accept your plea of guilt. I will assess $250 to be paid at a rate of $50 per month. Failing to pay not only means the court will enter a civil judgment against you because you're always going to owe it, but the court will issue a warrant. You could sit up to 6 months in jail. Okay, Mr. Butler?
Okay, Your Honor.
All right, thank you. You should be able to be released upon your probation hold being released, okay?
Okay, Your Honor, thank you.
Thank you. We're adjourned. Dwayne Mosey, he's not in custody, is he?
He should be,
He
Your
is?
Honor. Yep.
Okay. Yeah. Wish we had a fancy little thing where we can like buzz the jail and say which ones we want. Put it on the phone. And Mr. Benjamin?
Yep,
Excellent. I have your attorney right here waiting.
good.
We will go on the record in the matter 25 CM 77, State of Wisconsin versus Brandon Benjamin. The state appears through District Attorney Kevin Schmidt in person. Mr. Benjamin appears by video conferencing in custody in Burnett County Jail. His counsel, Zachary Fisher, appears by video. We're set today in this matter for an initial appearance. We're going to need to address bond on this as well. It is a co-defendant of Byron Benjamin. Mr. Fisher, were you able to go over the criminal complaint with Mr. Benjamin?
Your Honor, I've reviewed the complaint. I have not had a chance to review with Mr. Benjamin. Mr. Benjamin, did you receive a copy of the complaint?
Yes, I did.
Do you have any questions about the complaint?
Not that I'm aware of, no.
Your Honor, I would waive formal reading at this time, enter not guilty, please, and address bond. I would ask to address bond.
Thank you. Mr. Benjamin, can you read, write, and you understand the English language?
Yes,
And you read those two charges and the maximum penalties?
yes,
Do you need me to read them to you again?
I read them.
Okay, all right, so not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I need a telephone number for you.
320-591-0999.
May we send you text message notifications of upcoming hearing dates?
Yes,
All right, thank you. Mr. Schmidt, argument for bond?
I wouldn't object to setting the bond the same as Byron, which was $1,000 signature bond with same conditions. The court set a higher cash bond based on the probable cause because the probable cause stated there was a substantial battery. The police predicated that upon their visual observations of an individual who wasn't cooperating with them and still continues to not cooperate with the state. Thank you.
All right, Mr. Fisher, any opposition to $1,000 signature bond, same conditions?
No, Your Honor.
Court will enter $1,000 signature bond, same conditions. Mr. Benjamin, you will receive a copy of your bond and you must sign that before you are released, okay?
okay, yes,
We need to set this matter for another date and time. Mr. Fisher, how about your July 7th at 1:30 date?
That works, Your Honor.
July 7th at 1:30, Mr. Benjamin, July 7th at 1:30, okay?
July 7th at 1:30, yes,
You will get a notice, or you should, okay? We'll see you then.
okay,
We are adjourned.
I'll be in touch, Mr. Benjamin. They'll have my phone. I'll be able to contact you at that phone number.
okay, sounds good.
Ms. Perrin, can you hear me?
Yes, I can.
All right. We will go on the record in the matters. 25 CF 54, State of Wisconsin versus Zachary Chafee. Mr. Chafee appears in person, in custody. His attorney, Charlene Perrin, appears by video conferencing with approval of the court and with approval of Mr. Chafee. Mr. Chafee, have you changed your mind, or do you still consent with Ms. Perrin appearing by video?
That's fine.
If at any time you have any questions or concerns and you need to speak with her, let me know so I can have the lieutenant bring you to a Zoom room so you can talk with her, okay?
Okay.
All right. And we also have 25 CF 53, State of Wisconsin versus Laura Chamberlain. Appearances are Ms. Chamberlain appears in person, in custody with counsel Renee Landgraf. We have the state appearing through District Attorney Kevin Schmidt. We're set today in this matter for a joint preliminary hearing. Mr. Schmidt, are you ready to proceed?
I am.
Please call your first witness.
My first witness, I'd call Bridget Getz.
Officer Getz, please come forward, raise your right hand, be sworn in, and have a seat at the witness stand.
Do you swear that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
You may begin.
Could you state your name for the record?
Bridget Getz.
How are you employed?
I work for the Village of Grantsburg Police Department
How long have you been so employed?
since August of 2018,
How many total years law enforcement experience do you have?
26 plus.
So in the 26 plus years, are you familiar with drug investigations?
Yes, sir.
And that includes use of field test kits.
Yes,
Were you involved at all on a search warrant on a residence in Grantsburg on March 20th?
yes.
What led up to doing that search warrant? How did your attention first get apprised of it?
Well, I received information. I got a phone call on my squad cell phone on the 19th of March stating that there was possibly an armed male that was trying to get into the building and they were struggling with the key lock. So they thought that it was kind of out of place. So I went to the building to check on that.
What did you find? Well, where did you go?
I went to the old US Bank building on Madison Avenue in the Village of Grantsburg.
Is that in Burnett County?
Yes, it is.
What did you find when you got there?
Well, I checked the area. I didn't see anybody, so I went and knocked on the door because there were some lights on. And a male party came and answered the door and let me in.
Who was it?
His name was Aaron Kackman. He was a security guard, apparently that was employed by the building owner at that time.
You said apparently. Why did you think that?
That's what he identified himself as.
Did you corroborate that later?
Yes, I did.
How so?
I talked to the building owner, Troy Chamberlain, and he stated that he did indeed employ him and that he was staying at that place.
Okay, so how did your contact with Mr. Kackman that day go?
He had stated that he asked me if I wanted to come in and look at all the paraphernalia and stuff that they had located. And he advised me that he thought that there was some kind of a lab down in the basement. So he asked if I wanted to come in and take a look at that.
Okay, did you?
I did.
What did you see and where was it?
Well, when I walked up, I entered the building on the Madison side street entrance, walked up some stairs and off to, I believe it would be my right. There was 3 different containers. One was like a plastic white basket with, it was a laundry basket. And then there was a little rectangular box kind of in the middle. And then there was like another box that was sitting next to it. I kind of glanced at that. There was some pipes, paraphernalia that was sitting kind of on top of that. And then he brought my attention as we turned and went, it would be east in the building. There was some firearms laying down on the ground. And he pointed out some surveillance cameras or video cameras that he had taken down as well.
Okay, did he guide you to what he thought was a lab?
He did.
What was that? What did you see?
We walked downstairs and there was like 3, I want to say like makeshift closets that were kind of made of plywood. In the first one, there was a scale and it had some other type of objects in there. There was, I believe, there was a coffee pot in there with some white crystallized substance in the bottom of that. There was some beakers. There was a bong in one of them, and there was a bunch of chemicals down underneath that had names that were about this long. And so I just took some pictures of that stuff, and I didn't touch anything.
Okay. Did you understand what you were looking at?
Well, because of the different types of like the lab equipment, it was I've seen meth labs before, or a meth lab before, where the equipment was not as clean. This was clean. The brushes were in, in like a beaker type thing. And I knew it was a lab or the remnants of something of some kind. I just wasn't familiar with what at that point.
Okay. So before I ask more questions about that, why was this security guard in this residence showing you these items of drug paraphernalia and this lab?
Well, the Burnett County Sheriff's Department had received a call there from Mr. Chamberlain, I believe, I believe it was the 16th of March, to assist with a court order eviction of Laura Chamberlain and of Zachary Chafee.
Okay, so those are the two people who are occupying, they were being evicted or they were evicting someone else?
They were being evicted.
Okay. Did you talk with any of the sheriff's deputies who aided in the eviction?
I did.
Who?
I talked to Deputy Krupa.
Do you commonly work with the Burnett County Sheriff's Office?
I do.
Do you know them to be trustworthy and reliable?
Absolutely.
You know Karen Krupa to be trustworthy and reliable?
Yes.
How did she describe what happened that day with the eviction?
She said she received a phone call to go over to the eviction. She looked at the eviction paperwork that was, I believe, provided to her by Troy Chamberlain. And it said that she being Laura, had to vacate the premises by 3:15. Otherwise, the building had to be sold, and apparently that didn't happen. And so that's when he notified the police, and then that's when Deputy Krupa got involved.
So were Laura Chamberlain and Zach Chafee evicted that day?
Yes, according to Deputy Krupa's report.
And both of them were there according to her?
Yes, sir.
Did they leave willingly?
Yes.
Did they try to take anything as they left?
I believe they took some belongings, but I'm not that familiar with that part of the case, sir.
Okay, so did the police at that time, at the time of eviction, go inside?
I don't know that.
Did Deputy Krupa get any information about drugs or paraphernalia that day?
She did after that, yes.
Could you explain that?
Yes. She received, the call was then reopened because there was a drug complaint that had come in, and I'm not sure exactly who made that phone call, but it did come in from that residence on Madison Avenue. And it was stated that there was, I believe, a marijuana plant or a grow operation or something that they wanted law enforcement to come and look at. So Deputy Krupa then responded back over there.
So she went back there same day?
Correct.
What did she do when she went back?
She met up with Deputy Barker, her partner for the day, and they were allowed into the building to go and look at the alleged plant, and it was a marijuana plant, which they confiscated and brought back and had taken into evidence.
Were they shown anything else?
I don't believe so at that time.
Did they give any advice to the people? Was Mr. Kackman involved in that, or Troy Chamberlain? And calling out to come back to the residence?
She received. Can I look at her report to refresh my memory? I'm not sure exactly who called her to come back over there.
Did you bring her report?
I did.
I didn't know you did. Could I see it?
Sure.
Don't have a means of giving this to Attorney Perrin.
No, we do not, unless it's filed and then it'll go e-filing. Use it as an exhibit.
Yeah, I'll have to do that. I'm going to ultimately admit this as an exhibit, but first I'll have to authenticate it. I'm gonna hand you a document and ask you what it is.
Why don't we have it scanned first and put into the file so Ms. Perrin would have an ability to have it and get a copy for Ms. Landgraf.
Sure. I'll need a brief moment to go and scan.
Let's briefly adjourn. Ms. Perrin, I'm just going to put the cord into the waiting room while we are waiting, okay?
Thank you.
Ms. Perrin, he has submitted it through CCAP. It just might take a minute for the clerks to be able to receive it and then send it through.
Okay.
Would you like me to wait before I use as a refreshing recollection document?
No.
Ms. Perrin, can he proceed?
Yes.
Back on the record, same appearances as previously noted. Mr. Schmidt has now scanned and e-filed the report of Deputy Krupa. He has provided a copy to Ms. Landgraf, and Ms. Perrin will receive her copy as soon as it is uploaded into the electronic file by the clerks. Mr. Schmidt.
I didn't make an extra copy for Miss Landgraf. It's just e-filed.
Oh, I'm sorry. I guess you'll have an e-file access to.
Okay. You recognize what that document is?
Yes,
What is it?
it's Deputy Krupa's report.
Is this the document you said would refresh your recollection?
Yes,
Okay, could you refresh your recollection? And then once you're done, if you would put it to the side and not look at it. needs your recollection refreshed.
Yes,
So when they went in there, did they observe any items of drugs or drug paraphernalia?
yes,
Uh, Did they write what they observed?
yes.
What did they observe?
They had observed a marijuana plant. And then one of the parties that was in the residence, Mr. Cackman, Aaron Cackman, or Deborah Broughton, brought their attention to a pill bottle.
Okay. Did they ask about any other items of paraphernalia?
They did, and they said that there was, due to the, Deputy Krupa stated in her report, due to the numerous amounts of paraphernalia, she advised them to gather the paraphernalia and give the police department or the Burnett County Sheriff's Department a call when they were done and it was ready to be picked up.
She advised the occupants there, the non-police occupants, to gather the paraphernalia in one spot for the police later.
Yes, the marijuana plant was taken by Deputy Krupa and another deputy that was her partner that day.
Okay, so they took one item, told the occupants to gather the rest.
I believe so, yes.
Okay, so fast forwarding then to what we were talking about with the lab, you seeing it, not understanding it, what'd you do next?
I took some photos. I advised Mr. Cackman that I would be sending the photos to Captain Julie Mead from the Burnett County Sheriff's Department because she's up to par on different things like that. And then I also advised him that I would be contacting DCI, the Department of Criminal Investigation, for their assistance in hopefully identifying what we were looking at.
Did DCI eventually, what was the interaction with DCI?
I called and left a message for the office down in Eau Claire and I didn't receive a call back. Deputy Greg Schaefer then responded to Grantsburg and he advised me that he had a connection with DCI. So I sent him the photos that I took and he was going to get in touch with his connection with DCI and that they would be in touch with me.
So did you get in touch with DCI and how did that interaction go?
I did. Some of the pictures that were taken, they wanted a more in-depth view. So Deputy Schaefer and I went back into the building and went downstairs and we FaceTimed them so we could show them what we were exactly looking at.
Did they eventually reach a conclusion about what they wanted to do?
Yes, they said that they were going to reach out to a chemist and possibly the FBI to see exactly what they were looking at, and they were going to get back in contact with me.
Did they get back in contact with you?
They did.
What'd they tell you?
They stated that they would be up the next day, which would be March 20th, and we would probably be doing a search warrant.
Did you eventually do a search warrant at the residence?
Yes, a search warrant was done.
Okay. What agencies assisted with this?
We had the Superior Fire Department, their hazmat team came in. We had DCI. We had a couple members of the clean team, which their experience was coming in and cleaning up the hazardous materials and identifying it. We had members from the Burnett County Sheriff's Department. We had a siren police officer there and a member of the Grantsburg Police Department as well to assist me.
Okay. Where did everybody stage to get ready for the search warrant?
At the Grantsburg Fire Hall.
Did you make contact with, when I say you, did anyone from the staging team make contact with either Laura Chamberlain or Zachary Chaffee while staging for the search warrant?
Yes.
Who?
Deputy Bailey Mangan.
How did he come into contact with the person and who did he come into contact with?
He was driving on Madison Avenue and he saw Laura Chamberlain driving a red Ford Ranger. And he contacted us on the radio and said that he had her in front and wanted to know if he should stop her, if there was enough. And we stated that that was the case, to go ahead and stop her.
Did he stop Laura Chamberlain?
Yes.
Was there anything of police interest on her or in her vehicle?
Yes,
What?
it was a little baggie of a crystalline substance.
Was it field tested?
It was.
What was it field tested as?
It was field tested for methamphetamine,
Did it test positive or negative for methamphetamine?
positive.
Okay. Was Laura Chamberlain taken into custody at that time?
She was.
Do you see the Laura Chamberlain that was taken into custody in court here today?
Yes.
You state where they are and what they're wearing.
She's sitting in the middle at the table and she's wearing orange with like a brown shirt underneath.
Let the record reflect that Officer Getz has identified Ms. Chamberlain.
You're the village officer in Grantsburg. Have you had past contacts with Ms. Chamberlain?
Yes.
So you know what she looks like.
Yes, sir.
You had a past contact with Chaffee at this residence.
Yes.
Do you know what he looks like?
Yes.
Do you see him in here at court today?
Yes.
Do you say where he is and what he's wearing?
He's sitting closest to the blackboard at the defendant table, wearing also a brown like undershirt and orange jumpsuit.
Let the record reflect that Officer Getz has identified Mr. Chaffee.
Okay. So after Ms. Chamberlain was taken into custody and that was discovered in a vehicle, what did you guys do for executing the search warrant?
The Superior Fire Department hazmat team went in and they tested the air samples that were in the building to make sure that it was secure and safe for the clean team and the DCI guys to go in. After that was deemed to be secure and safe, then the DCI team, clean team went in and removed all the chemicals from the residence. And then after they were done with the scene, then they turned the scene over to the Grantsburg Police Department, and then we executed the remainder of the warrant.
Okay. So DCI and the clean team went first, then you and others went in after.
Yes, sir.
So you've actually been in the residence.
Yes.
Did you locate, or your team while you were executing the search warrant, locate items of drugs or drug paraphernalia?
We did.
What did you find?
We found numerous scales. We found some bongs. We found a bunch of little drug paraphernalia pipes, both glass with burnt residue in, a lot of tinfoil residue with tinfoil foilies with burnt residue in, some crystalline substance in some baggies, some mushrooms. There were some firearms in the vehicle, firearms in the residence as well. A bunch of video cameras, a lot of cell phones, 70 to 100 probably. There was a lot.
70 to 100 cell phones?
Cell phones.
Okay. You said multiple scales. What kind of scales do you mean?
Little portable scales that, with my experience and training, are used to weigh narcotics.
You said multiple. Do you know how many?
At least 5.
Okay. Were these items strewn about the residence? Were they in a specific location? Where were they?
They were all over the place.
Okay. We had covered that previously on the 16th. The occupants have been instructed to aggregate and put together some drugs and paraphernalia. Did any of that happen?
Yes. The building was searched first, and then we went at the end and looked at all of the stuff that was in that white basket, that laundry basket, that little rectangular box, and then that other box that was sitting next to it right as you entered the residence.
Oh, that's where they put it.
Yes.
Okay. What was in those?
There was crystalline substance. There was there was a few things that we sent to the crime lab because we weren't exactly sure what it was. Some of it matched with similar things. We did a little research about DMT labs and what DMT is. So some of that stuff could have possibly been that. We didn't know. We sent that to the crime lab, so we're waiting on that report. There was numerous metal smoking devices, glass devices with residue in, and tin foilies with burnt residue in there as well.
What's the significance of tin foilies with burnt stuff in them?
Usually that's how they use to smoke, heat up the methamphetamine when they're either gonna probably ingest it.
Were there any needles in the residence?
There were,
Could you describe that?
yeah. There were needles in downstairs in one of the closets in like a plastic, real heavy duty plastic container that had a lid on. And there were some children's shoes that were right above that.
Were there any items there for dealing with drug overdose?
Yeah, there was a little plastic, I think it was a plastic container that contained a vial of naloxone with a needle in there, like a little kit.
And naloxone, what is that used for?
It's used to counteract an overdrug or an overdose.
Is that what's more commonly referred to as Narcan?
Yes.
Okay. Did you locate any items with anyone's name on them?
We did.
What did you find and whose name?
We located several pieces of mail that had Zachary Chafee's name on it. One with an address out of Mora, Minnesota, and another one with an address out of St. Paul, Minnesota. All of which who had his name on it. There was also mail in there that had the resident's address on there as well.
And without asking what their name is, was there anything with a child's name anywhere there?
Yes, on one of the doors upstairs, there was a little, I think it was a crayon that had the name Marvin on there.
The child, are you familiar with whose child that is?
Yes, that would be Mr. Chafee's son.
Okay. You said you found things that you did research were related to DMT labs. Could you describe more specifically what you're talking about?
Well, we found a baggie of a bunch of white, like a white powdery substance, and that could be a product of the DMT. We also found a baggie of like, it was a brown, like a sticky brown substance that smelled horrendous. And that could possibly been part of a byproduct or something of the DMT. So we weren't sure, but we sent that all into the crime lab for analysis.
Okay. The items that you've been asserting are drug paraphernalia related, were any of those field tested in any way?
Yes.
What was field tested and what were the results?
There was a smoking device that was field tested. It tested positive for THC, and there was a small baggie of crystalline substance that tested positive for methamphetamine.
Did you only test 2 items?
That was the items that I saw that were tested. I didn't test them.
Okay. So the assertion that these items, these pipes and these foils, those are based on your training experience?
Yes, sir.
All right. These items of drug paraphernalia that were located by the police, not the ones in the boxes, the other ones, were these in plain view? Did you guys have to rifle around to find them?
Yeah, they were going through drawers and stuff, and I was writing down stuff. So yes.
Which one? Were they in plain view or did you have to like open containers to find them?
They opened the drawers and found different things.
Okay. And And just to clarify, when I asked you about the identification questions, your contacts with Chafee and with Chamberlain, were they at this residence?
Yes, sir, they were.
Okay. No further questions for this witness.
All right, Ms. Perrin, I'm going to start with you. Do you have any questions?
Yes, I do have a few. You said that Mr. Cackman was a security guard, correct?
Yes, ma'am.
Okay, did he work for a security company?
I don't have that information.
Did he have a uniform?
No, ma'am.
How was he dressed when you saw him?
He had a t-shirt and I believe some kind of just regular trousers on.
Did he show you any professional identification?
No.
Okay. Now as to the eviction, do you know what county the eviction order was from?
Yes, ma'am.
And what county was that?
Polk County, Wisconsin.
Polk County. Are you sure that wasn't an order from a divorce?
I don't have that information.
So do you know whether an eviction order would be different from an order from a divorce?
I'm not familiar with that.
Okay, and you're aware that that there's a divorce, difficult divorce going on between two of the parties involved here, correct?
Yes.
Okay. And so the husband in that divorce and this person calling himself a security guard were people that had control of this residence for some time before you arrived there, correct?
Yes.
And do you know how much time they had been there before you arrived?
I don't know.
Okay. And so fair to say that they could have manipulated things in that residence before you arrived, correct?
Objection calls for speculation.
Sustained.
So just to be clear, you're not sure if it was an eviction order or an order from a divorce, correct?
I just know that there was court paperwork that was provided to Deputy Krupa.
Okay. But you had no search warrant at the time, correct?
I wasn't at the scene of when the initial contact of the eviction was processed. I wasn't even working that day.
Okay, well, you can't actually be sure if there was an actual eviction because you don't know if it was eviction paperwork or a court order from a divorce.
I guess I'll object because this is getting into discovery and doesn't have anything to do with the prelim.
Sustained.
Okay, may I make a record?
Yes.
And I think the court is aware of this, that there is a difference that's important between a court-ordered eviction and an order from a divorce. And that is the record that I would like to make. With that, I don't have any further questions.
Ms. Landgraf?
Thank you, Your Honor. Officer, you testified that you had prior contact with Miss Chamberlain
Yes.
and was one of those contacts shortly before this incident in which she reported that Mr. Troy Chamberlain was in violation of a temporary restraining order.
There was some time period, but I'm not exactly sure how much time period there was.
At some point
Prior to
before-
this, yes, there was.
Okay, my client had made a complaint to the police department that he was violating a TRO by being at that building.
I believe so.
Do you know if that was ever followed up on?
I don't know. I'm assuming that it would have been.
Do you know if she called more than once to complain that he was in violation of the TRO?
I don't have her call status in front of me. I'm sorry.
Briefly adjourn. Ms. Coleman, we have a preliminary hearing that's running a little long, so it's going to be a little bit, just letting you know.
Thank you.
Back on the record, same appearances.
Did you have contact with Aaron Keckman on the 16th?
No,
When did you have contact with him, if any?
it would have been on the 19th.
Was he intoxicated?
Mr. Kackman?
Yes.
No.
Do you know if your police department received a complaint on the 14th or 16th that he was intoxicated in the area?
I don't have, no, I don't know that.
Okay. No further questions.
Before I go to you, Mr. Schmidt, do you know how to spell his name, Kackman?
I believe it's King, Adam, Charles, King, Mary, Adam, Nora. Sorry, Kackman.
All right, thank you. And his first name is?
Aaron, Aaron.
All right, thank you. Mr. Schmidt, do you have any redirect?
When the Burnett County Sheriff's Office was with Mr. Kackman and Mr. Chamberlain on the eviction, that was them taking possession of the property on the 16th.
Correct.
Thank you. That's all.
Ms. Perrin, on that note, or I guess on questions from Ms. Landgraf?
No further questions, Your Honor.
Ms. Landgraf?
No, Your Honor.
All right, thank you. You may step down. Any further witnesses, Mr. Schmidt?
Yes, I would call Lance Maskey.
Please come forward, raise your right hand, be sworn in, and you can come have a seat on the witness stand.
Do you swear that the testimony you're about to give today in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Could you state your name for the record?
Lance Maskey, Maske.
What do you do for a living?
I'm a special agent for the Wisconsin Department of Justice, Division of Criminal Investigation,
What do you do for that job?
narcotics investigator.
Does that involve consulting with local law enforcement on lab scenarios?
Yes,
Were you called about a possible lab? Let me rephrase the question. Did you eventually go out to a possible lab on March 20th?
yes.
Could you describe where you went?
The village of Grantsburg, Wisconsin.
Okay. What did you do for your part of the search warrant there?
I was assigned to the entry team after the Superior Hazmat team cleared the residence of any potentially hazardous substances.
What does that mean? Superior clearing of hazardous circumstances?
The hazmat team has air testing meters that they go in and they test the air for high explosives, any kind of chemical weapons, any other hazardous type substances that could be in the air.
So they go in first to see if it's safe for you guys to come in later.
Yes,
Did they say it was?
yes.
What did you do after it was cleared?
Myself and another investigator donned
face mask. It's called an APR. It just has a filter on it. And we basically searched the entire house.
What did you see?
In the basement, we saw the area that Officer Getz had provided photographs of.
And what did you see there?
Various items to include carboy. They're larger containers, probably 2 gallons maybe, with different chemical type names on them. Several different glass vessels with a biphase liquid in them. A pressure cooker with a hose sticking out of it. Several different chemical vessels.
You said biphase liquid. Is that important?
Yes.
What is the significance of this biphase liquid?
A biphase liquid is similar to oil on top of water. The bottom layer was a dark colored mixture and the top layer was like a clear liquid.
And on your training experience, does this mean anything in terms of looking for illegal drugs?
Yes.
Could you explain?
Specifically to DMT laboratories, the bottom layer separates and extracts the DMT from a root powder, and that DMT liquid rises to the top.
Okay. Could you, for the court's knowledge, say we don't know about how DMT is made, could you briefly describe how that's done through a lab process?
It is manufactured through a bark that is typically ordered through the dark web or through various internet sources. Individuals will get that bark and they will mix specific chemicals into a glass vessel and let that basically marinate in that vessel for a specific amount of time. And during that time, that chemical process actually extracts the DMT from the root or the root bark.
Is there only one way of making DMT?
I don't think so.
You're not sure?
Correct.
Okay. So is there any like telltale specific chemical you would always see in a DMT lab?
Vinegar, hydrogen, I'm sorry, not hydrogen, a sulfuric type liquid, bases, ether, or different types of solvents.
And I'm not an expert on labs. When you say vinegars and solvents, doesn't that encompass a lot of different things?
It could.
Okay. Is there any preliminary like a field test like there is for meth or fentanyl or heroin for DMT?
No.
So did you do any tests on these substances?
Yes.
What did you do?
My partner tested the pH of the liquid in one of the vessels.
And what was the result? And what does that tell you?
It showed a pH of 12, which shows highly basic solution. And that is a good indicator of a clandestine type lab.
Okay. But you won't be able to definitively confirmatory test for DMT until the crime lab does something.
Correct.
Okay. Was this a clandestine lab? And if so, why would you reach that conclusion?
In my opinion, it had all of the makings to be a clandestine lab. I am not a chemist. However, based on the circumstances at hand and based on what I'm seeing and what law enforcement is seeing, it led us to believe that it was a DMT lab.
Okay. What was done with these biphase liquids?
My partner and I transported all the glass containers from inside the building to the outside where there was fresh air so they could be adulterated.
What does adulterated mean?
Basically, we add specific chemicals to them to basically neutralize them.
Okay. So like if it's an acid, you add a base to make it neutral.
Not that simply, no, depending on what the substance is, because it was highly basic. We add a powder to it, which is called amphomag. And that basically turns it into a solid.
Okay. Did you keep any samples for testing?
Yes,
Okay. How many glass containers of this biphase liquid was there?
17.
What were the size of these containers?
15 were about the size of pickle jars, larger pickle jars, and then there were 2 probably larger gallon size.
How full were they?
Completely full, almost all of them.
The pickle jars and the liter ones,
Yes,
or the gallon ones? Did you say liter or gallon?
gallon.
When someone's making DMT in this matter, you said that it goes to the top?
Yes,
Okay, of the biphase liquid.
yes, the extracted DMT basically rises to the top, much like oil and water.
How do they get it out?
Various different ways they could pour it out. They could use a turkey baster. We used pipettes to take samples. So you're just taking just that clear liquid on the top and not grabbing the sludge on the bottom.
Okay. How heavy were these containers with the liquid?
Heavy. I mean, for a pickle jar, pretty heavy, you know, I didn't weigh them.
You didn't weigh them. Was the liquid in these 17 containers more than 50 grams?
Yes.
How can you say that?
A gallon of water is approximately 8 pounds.
And there's more than 50 grams in a pound?
Yes.
Okay. I guess I haven't asked the obvious question. DMT, what does that stand for?
It's N, N dash dimethyltryptamine.
And that's prohibited by Wisconsin drug laws.
It's a Schedule 1.
Okay. All right. No other questions?
Ms. Perrin, do you have questions? You are muted.
Sorry. I do. I'm a little bit confused by the math. So can you help me understand? Because you said you didn't weigh anything, but you said you knew how much it weighed. So, can you explain that to me a little clearer? As far as this substance goes, what you can say about the weight of the okay, I'm not going to say this word very well. Dimethyltryptamine. Did I say that right?
Yes.
Okay. What can you tell me about the weight?
I did not weigh the vessels nor the liquid. However, if a gallon of water is in a gallon container, that gallon of water would be 8 pounds. So if you take the 2 gallon containers and the 15 basically liter containers and add all that liquid up together, it would be more than 50 grams.
Okay. Thank you for clarifying that. I don't have any further questions.
Ms. Landgraf?
Where were these containers when you arrived?
In the basement.
Were they in a locked cabinet?
Makeshift cabinet?
And was it locked?
No.
Do you know if it was locked prior to the Burnett County Sheriff's or the Grantsburg Police Department?
I don't know. To your knowledge, did anybody test any of the jars or the
containers for Mr. Chamberlain, or I mean, Miss Chamberlain, fingerprint or DNA?
No.
Is this bark or root that you were talking about, is that illegal in itself?
No.
So you can just order that online?
Yes.
Okay. In the liquid in the containers, you said I'm just gonna call it DMT, that rises to the top? And that's what's extracted?
Yes.
So the whole container is not, I guess, like the illegal DMT, it's a portion of that?
The sludge could certainly test positive for DMT as well. But
Did you examine any electrical devices, electronics, to see if there was any kind of sales of any kind?
no.
I missed that question. What'd you ask?
Did they test any electronic devices like cell phones for sales?
Thank you.
Do you know if anybody in your department or local law enforcement talked to anybody that was potentially purchasing DMT out of this building?
I don't know.
And you're not aware of any reports that DMT was being sold or made out of this location?
No.
One second, Your Honor. No further questions.
All right, Mr. Schmidt, redirect.
No.
Okay, thank you. You may step down. Further witnesses?
No.
Any witnesses for either of the defense?
No.
No, Your Honor.
All right, well, I believe I've heard enough to be able to make a determination based upon the testimony of both Officer Getz as well as Investigator Maskey, in the fact that in a preliminary hearing, the burden is low, and all evidence must be looked at in the light most favorable to the state. And the court here is looking at whether or not a felony was probably committed by the defendants. And in a case like this in the hearing, the court does not look at credibility, does not weigh arguments of any deep defenses or anything of that nature. It's simply to determine whether a felony was probably committed by the defendants. Based upon the testimony the court has heard here today, again by both the officer and the investigator, the court will find that there is probable cause to bind the defendants over. So I do find the probable cause. Mr. Schmidt, informations.
I'd ask for arraignment date.
All right, we're going to set the matters for arraignment. It doesn't matter if they're on the same date or different dates. The next available time I would have would be March 27th at 11:45 or 1:30.
May 20th?
Oh, sorry, May. Trying to gain more time. Does that work, Ms. Perrin?
May 27th does not work for me.
Then I have May 30th at 10:45.
That would work for me.
And Ms. Landgraf, any of those work for you? And again, they don't have to be joint.
I think I'm with you the morning of May 30th.
Could be. Let me just take a look.
Or wait, maybe not. No, that's by Zoom.
You can do it by Zoom. We can tack it on to your Java matter. Did I say Java? I meant Schneider. I'm fine with that. We can do 11 o'clock on May 30th or 29th, sorry. May 29th at 11 o'clock for Ms. Chamberlain.
Okay. 29th.
All right, so we'll have May 30th at 10:45 for Mr. Chafee. And we'll have May 29th at 11 for Ms. Chamberlain. We will see you then. We are adjourned.
Thank you.
Every day in the USA, people find themselves in court.
Change the order to that effect, but wanted to.
And I assume that's no problem, Ms. Long?
I have to check with my client. It's certainly no problem for me.
All right. Thank you both.
Okay, thank you, Your Honor.
You.
And before we take the last case, there was several involving a janky trucking and various defendants that was on this calendar as of this morning, and now I see it's gone. Do you know?
They were, one of them was supposed to be stricken already, so I struck it this morning after realizing it wasn't struck, but the attorneys requested it be stricken.
That's wise of them, because they had all three of them wrong. Okay. Austin Bradford Trucking versus Chrome Logging or Chrome Logging.
Good afternoon, Your Honor. Margaret Kazmaier appearing for the plaintiff in this action.
Counsel, I apologize. How do you pronounce your last name now?
It's Kazmaier.
Thank you. I didn't want to. And we have Mr. McCurry.
Yes, Your Honor. I am remote today.
Okay, so counsel, the first thing I wanted to do is make sure that both sides are agreeable to me sitting as a pro tem. It didn't make a lot of sense to have a revision of a commissioner's ruling in front of a commissioner.
Yeah, we have no problem with Judge Pro Tem.
Yeah, neither do we.
All right, so I've got an agreement signed by Ms. Kazmaier and Mr. McCurry. I'll just indicate approved by phone.
Yes.
All right, thank you. All right, go ahead, counsel.
Thank you, Your Honor. I'm assuming you've had a chance to read the documents. I wasn't sure with the agreement to Pro Tem. So I'll try to keep my arguments brief. This is a motion for order restraining disposition of collateral and ordering payment of surplus or approval of a redemption amount. This case is governed by the Washington adoption of the UCC. Specifically, I'll start with the request for restraining order, which is authorized under 62A 9A-625. So this action was filed for breach of contract. Plaintiff alleges that defendant wrongfully repossessed the collateral, and defendant denies this. So whether repossession was proper is at issue in this action. And then there are issues beyond repossession that are at issue in this action. In December, defendant filed a motion to approve disposition of collateral, which is an option under the UCC. They also have the option to simply sell the collateral. They chose to request court approval of the sale of the collateral. After that hearing, Commissioner Carmi denied that motion and denied a preliminary injunction ruling, which was included in that motion, indicating that whether repossession was appropriate is at issue, and she couldn't approve the request. Defendants filed a motion for revision that also was denied by Judge Hahn, indicating the same thing. Whether repossession was appropriate is at issue in this action, so approval of the sale wasn't possible by the court. About 3 days after Judge Hahn's ruling on the motion for revision, plaintiff received a notification of disposition of collateral, indicating that they were going to sell the property on May 12th, despite the court saying we won't approve this. And so we filed this motion requesting that the order restrain the disposition of the collateral until the issue of whether repossession was appropriate can be determined. RCW 622A 9A609 allows a secured party to take possession only after default by the buyer. Whether that happened is exactly what's at issue in this action. Plaintiff alleges that defendant established a course of conduct of accepting late payments. Defendant says, no, I didn't. I had to force you to make late payments, but then I accepted those late payments. And whether that is a default under the contract and under the UCC has to be determined by a trier of fact. The UCC allows disposition of collateral to be restrained where the secured party is not acting in compliance with the UCC. And here we have allegations that they're not in compliance with the UCC. We have a commissioner and a judge both ruling that that's at issue and we can't approve a sale. So the courts clearly said a sale of collateral is inappropriate here. And then defendants simply try to do that after the court has indicated it's not approved. So we're asking that the court restrain disposition of the collateral until this case can be decided at a trial. Secondary to that, we have an issue where in response to interrogatories, we have defense admitting that they've already made a sale of the collateral. In fact, back in September of 2024, they made a sale of the collateral. They've indicated that this sale is conditional on this action. However, they've indicated that they've accepted payment and they're holding it until this action is resolved. And they've accepted payment of $315,000 from a third party. We provided defendants' responses to interrogatories indicating this. The amount remaining on the collateral or on the contract the day it was taken back into defendant's custody was $159,600 and some change. The repairs were made in September. If you look at clerk's paper 11, which is Eric Kroom's declaration, all the receipts for repairs are from September or later of 2024. And plaintiff has indicated in his declaration that he offered to pay the balance of the contract and be done at the end of August 2024. And defendant said, nope, we won't accept it unless you pay for the repairs that we're going to do. And plaintiff had established that he couldn't pay for the repairs, but he'd pay for the truck and figure it out on his own. Defendant said no, and then defendant made all these repairs and then sold it to a third party. We've provided the bill of sale showing that the truck has been sold and they're holding payment. So at that, assuming that sale has occurred, which it seems it has, defendant has received a surplus of $155,000 and some change. Defendant argues that, well, no, because we're entitled to the expenses of preparing the collateral for disposition. Yes, you're entitled to that, but plaintiff's attempt to redeem came before the repairs were made, and it was denied. So if the repairs had been made before the request to redeem, perhaps there's an argument that he's got to pay the expenses of preparing it for disposition. But defendant's own receipts that they provided in their declaration previously to this court indicate all the repairs were made at the end of September, and plaintiff attempted to redeem almost immediately after the truck was taken back into defendant's possession. So we're asking that the court order that the surplus amount be paid to plaintiff if the sale has indeed occurred. And defendants still can pursue their counterclaim for the repairs that they've made to this truck, which were made after the plaintiff's attempt to redeem. In the alternative, the court could simply approve a redemption amount of the amount owing at the end of August, which would be $159,600. However, this would duly compensate the defendant, as they've already sold it to a third party. So they asked the court to approve a sale that apparently had already happened. The court said no. And then they said, well, we're going to sell it anyway, but they've already sold it back in September. So at this point, we're asking that Your Honor either restrain disposition of the collateral until this matter can be heard at trial, or order payment of the surplus to plaintiff, and the parties can continue to litigate the repairs as a counterclaim of defendants.
Mr. McCurry?
Thank you, Your Honor. I'm going to start generally with the restraining order. And I guess procedurally, this looks like a request for a preliminary injunction. And to the extent that the court agrees that those standards have not been met, certainly the prior arguments about that would apply in the opposite direction of where we were when I brought my original motion. But in this case, the plaintiff is premising the restraining order argument on the notion that possession by Kroom is wrongful, but it's not wrongful. It was voluntary. Bradford delivered the truck to Kroom. If you look at the texts between Bradford and Kroom, it establishes that Bradford was saying, okay, I'll have it over there by, I think it was like the 7th or the 9th or something like that. And then eventually he brings the truck to Kroom. He voluntarily turned the collateral over when the discussion was, hey, Austin, you wrecked the engine and now it's going to need to be replaced. And Austin's saying, or Bradford is saying, gosh, I don't have the money to do this. I can't buy a truck. I can't fix it. Well, bring it into me. So he turns the collateral over to Kroom. Kroom has the right to sell the collateral in terms of a restraining order because he has received a voluntary relinquishment of the collateral under the agreement and under RCW 62A 9A 613. And I guess as an aside to that, the right to non-judicially sell the truck and collateral is separate from getting a judicial approval of it. A judicial approval of it would be nice, but we didn't get that. So we can sell it privately. Then suffer the consequences if we're wrong. It is commercially reasonable at this point to repair the truck and preserve its value. If you look at Eric Kroom's declaration, he explains, he made the repairs to prepare it for sale because the truck was worth less than he was owed before, when the engine was blown and not working. So it wasn't really blown. I guess it was just that the work that Bradford had done to it had made it so that it didn't function properly. And it had to be replaced. So another factor that goes into that is that Kroom should mitigate his damages and dispose of the truck. Well, he tried to do it in a fair manner by bringing it before the court, and that was treated like it should have been a summary judgment motion, and it took, I don't remember the exact timeline, but I think it was a couple months before we got an answer to that. So here we are in May dealing with an issue that got started at the end of last year, really. So Kroom is trying to act in a commercially reasonable manner, mitigate his damages, and dispose of the truck. At this point, a restraining order on a sale will only waste time, and it'll cost Bradford in interest on the loan. It'll cost Kroom in downtime for a truck that could be making him money. It just raises everybody's expenses in a way that doesn't make sense pending trial. So and I guess the final point on the restraining order issue is Bradford argued when we filed our motion that, and Judge Hahn agreed with this notion, that financial loss isn't a reason to restrain a party. This money damages essentially resolve this issue in terms of a restraining order. So if Kroom decides to complete a sale, he's just taking that risk on himself for, you know, that money damages would be assessed against him if he's wrong. Another procedural point is that a lot of what the remaining motions are requests for summary judgment. Basically, the plaintiff is saying, we're right about these matters, and judge, give us the truck if we pay just the underlying amount. Give us the surplus if you know, if you accept that the truck has already been sold, etc. But those summary judgment standards haven't been met in terms of that procedurally or substantively. So I think the heart of the, I guess, substantive issue in this case has to do with the notice issue that counsel claims, because Kroom accepted payments, and the Beardsley case is presented to suggest that, hey, you have to give some big stark notice that you're no longer accepting those monthly payments. And I briefed the issue, so I won't belabor it, but the Beardsley case deals with self-help repossession. Bradford delivered the collateral, so that standard really doesn't apply in this case anyway. Kroom never really approved of late payments. His staff was enforcing the agreement by demanding payment. That demand or request for payment, those texts that his staff sent to Bradford, they don't have to be rude. I mean, what did she say in the text? Hey, kiddo, you're running late, that sort of thing. That's notification to Bradford that the agreement is going to be enforced if you don't pay. And clearly there is a longer term relationship between Kroom and Bradford in terms of, you know, for example, Kroom put new tires on the truck when he sold it to Bradford, didn't charge more, he just wanted him to get off to a good start. So the Beardsley case really isn't on point for purposes of this matter. Even though the facts are similar, they're dissimilar in a way that's incredibly important. That was self-help repossession in Beardsley. It was hooking somebody's car alongside the street when they failed to make payments. Here, Bradford delivered it voluntarily. But that was 1931. In 32, the Drumheller case came down, and it shifted the focus. If you look at the text under note 2, it shifted the focus to the agreement of the parties, and this agreement is pretty stark. It just says if you default 5 days later, you're done, we can take the truck. The texts supplement this agreement because you have Bradford and Kroom texting back and forth and coming to the conclusion that Bradford needs to bring it to Kroom because Bradford can't afford it. So for Bradford to argue this notice issue is really, honestly, it's thin. It's just that it's taking the Beardsley case and hoping that there's enough of a connection to it to try to make sense of it in this case. And that was the response issue to our original motion that we first made. And frankly, it just wasn't briefed much beyond what the plaintiff responded with. I don't think there was another thing that I needed to say there. I guess I would say this, though, that Bradford voluntarily delivered possession, and he's now making these late claims that he was scared that he was scared, and that doesn't change the fact that he voluntarily relinquished possession. It's curious, maybe suspicious, that so many of the things that Bradford claims aren't supported. He has no proof that he offered any money as a redemption amount. He has no proof that he was scared at the time, so he gave the truck to Kroom. He has no proof regarding, the notion that he was under some pattern of late acceptance. He was always being bothered by Kroom to get his payments in. And I don't know, it seems like a bit of a he's asking to have his cake and eat it too by getting the benefit of having someone who's reasonable with him as far as the payments, and then turns around and says, hey, look, I didn't pay on time and they didn't take the truck from me after 5 days. Therefore, I somehow don't have, I don't have to comply with anything else, and Kroom has to give the truck to me. The next issue is the redemption issue. And again, this is a summary judgment issue, I would say, but the crux of the redemption issue and the surplus issue is really one of more just straight up rational thought. What Bradford is asking for is show up, pay 159 on 159,000 for the truck on the allegation that he somehow, as a guy who didn't have any money to fix the truck, had 159,000 in an offer that he never documented anywhere, and my client says never happened. But he wants to now pay that 159, roll the clock back to September of 24, and not pay for $135,000 in engine replacement and repairs. Redemption under RCW 62A 9A 623 references RCW 62A 9A 610A1. And it says that the redemption amount would include expenses of preparing for disposition. And was Kroom supposed to take a loss and sell the truck at the time for $100,000 and then chase Bradford for the 59? No, he has the right to prepare the truck for disposition, and he turned a pig's ear into a silk purse here by taking this truck and putting an engine in it and turning it into a $315,000 truck. And if you take the two numbers, about 160 and 135, you've got 195 that Kroom is into it and is owed. He's in a position then to perhaps have paid some surplus. But that's all gone now because the expenses of everything have now exceeded that, it would seem. Additionally, on redemption, Bradford bases his argument on the claimed lack of notice, but there shouldn't even be an issue of fact regarding that because he had notice clearly throughout the texts. And I guess I just went over the notion that he claims he offered payment, but he doesn't say, hey, I tried to give you 159,000. What gives in a text to Kroom? Nothing. He just makes it up now, it seems. Next, regarding the surplus. Again, a summary judgment issue, it would seem, but the sale is conditional. The sale to Dale Lebanon, as stated in the interrogatory responses, is waiting to see what happens with Bradford. And, Kroom's not cashing, well, he's not doing anything with the money. It's sitting there. He could complete that sale and be satisfied perhaps at this point and just walk away from this. But Bradford won't let that happen by filing this lawsuit and increasing everybody's expenses and so forth. So there shouldn't be any order on this hearing other than denial regarding redemption or surplus. The cost of repairs issue that's raised in the motion. What Kroom has done to preserve his collateral is 100% commercially reasonable, and that's borne out by the fact that a truck that sold for, was it $260 or whatever, is now worth $315. And he turned something that was worth less into something that was worth enough to pay for everything. And Bradford has failed in terms of recognizing that. The damages issue is a summary judgment issue, shouldn't be ordered in this instance other than to be denied. I suppose the point to make there, or the landscape issue for Bradford, is how does he have damages? He was in a position where he couldn't make money because he destroyed the truck. He didn't have the money to pay for the truck, and he couldn't do anything but give it back to Kroom. So that's what he did. And I guess I find it hard to take serious when Bradford says in his declaration, I have a logger friend who can front me the money. I mean, I have a buddy who's got some great tools. You know, that's the kind of thing that shouldn't hold much credibility under the circumstances. So at this point, we're just asking that the court deny all of the motions. And if Kroom decides to sell the truck, he has that non-judicial right. And if he doesn't sell it, we either go to trial or have a judge hear this on summary judgment. Thank you.
Counsel?
Just briefly, with regards to the restraining order, defendant would like you to treat it like a request for a preliminary injunction, which is a different standard. This is a request to restrain disposition of collateral under the UCC specifically. The request made by defendants in their prior motion was for a preliminary injunction, and yes, those standards aren't met, but those aren't the standards that apply here. This is a request under the UCC to restrain disposition of collateral when a party is not acting in compliance with the UCC. That's a different set of standards entirely. So we believe there is an appropriate basis to restrain the disposition of the collateral. However, we have the issue of the truck has been sold, and defendant keeps saying this is an issue for summary judgment, but I don't think there's an issue of fact there that they've admitted we sold the truck, but we are holding the money. We didn't finalize it because this action's going on. Money has changed hands and the truck has been sold. So we have the issue here of whether repossession was wrongful. They say no because it was voluntarily turned over, and plaintiff has said it wasn't voluntary. I felt I had no choice because he was threatening me and he was telling me he'd make it impossible for me to work. I didn't know what to do, so I just took the truck to sit there to figure out what to do next. Wasn't just, hey, yeah, I'll bring the truck to you and you can do whatever repairs you want and then I'll pay all of them. That never happened. So whether it was wrongful repossession is at issue here, and that's an issue that has to be resolved. And then we have plaintiff saying he offered to redeem prior to repairs being made and that offer was denied, and then repairs were made, and their own receipts show repairs were made late September, and plaintiff's offer was made at the end of August. So redemption includes expenses of preparing for disposition, but not if those expenses haven't occurred yet. And those expenses hadn't occurred at the time he made his offer. The defendant, in their response, makes many statements about how plaintiff treated the truck or what plaintiff did, what plaintiff didn't do. None of these are accepted facts. These are all at issue in this action. So plaintiff is prepared to pay the redemption amount if that's the choice, if that's the route the court takes. He's asked the court for several remedies, alternative remedies. But I think at this point it is appropriate to restrain any further disposition of the collateral unless the court accepts the sale and orders payment of the surplus.
Well, first of all, I want to thank both counsel for giving me the UCC bar exam question. So the question today, and I think part of it is I really need to draw a box on what we're dealing with today. Today, the issue is the plaintiff able to proceed with a non-judicial foreclosure and sale? The question is not whether I'm approving a non-judicial foreclosure and sale. And I think that's important. The prior ruling was on one method of proceeding. And I agree that summary judgment kind of raises its ugly head throughout all of this. But I think the prior finding was that the court couldn't find that the defendant had an absolute right to sell, that there were contested facts. So defendant per the UCC has another option. Should I prohibit that today? As I see it, the factual issues that still need to be sorted out that are relevant here, or did the plaintiff offer the full amount owed and did he do so timely? Did the plaintiff voluntarily turn the collateral in or did he not? There are listed about 131,000 costs of repair. Are those appropriately recoverable as expenses of preparing for disposition? And I think there's some other kind of subsets under that, but those are the three broad categories that I see. And those issues still remain. I'm not resolving any of those factual issues today. I am not making any kind of a ruling on the propriety of a planned sale, not ruling on the propriety or timing of repairs, not making any ruling on the circumstances, whatever they were, of the defendant coming into possession of the vehicle. I am going to not, I don't know how to say this in anything other than somewhat stilted English. I am not going to prohibit the non-judicial sale. I am not providing any kind of judicial approval of that sale, both because it would be contrary to the prior ruling of Judge Hahn and because that's not what's in front of me today. I'm not finding that the sale is proper. All I'm saying is I will not prohibit the defendant from proceeding with a non-judicial sale. And I think the most salient point in this, or the one that makes that the proper direction to go, is that assuming plaintiff's claims are meritorious, allowing or refusing to prohibit the sale does not impact the plaintiff's ability to recover damages. He still has an adequate remedy at law if it's later determined that the defendant's conduct at any of those levels was improper. So the order should indicate that I am not prohibiting the non-judicial sale, full stop. And all those other issues still remain. And plaintiff does has an adequate remedy at law if the sale is later determined improper. And so, counsel, because I'm not here on a regular basis, if there are any issues about the language of the order, if both sides agree, I'd like to be able to try and sort those just by email. We can put it on for presentation if that doesn't get us there, but that usually works out. That okay with both of you?
Yes.
Yes, that works for me.
All right. Thank you very much.
Thank you, Your Honor.
Thank you. I'm just trying to find where he is. Oh, there he is. Okay. Okay, let's do Anderson. And Anderson's here for Tomar. Yes, thank you. All right, Mr. Anderson, if you could please unmute.
Good afternoon, almost.
I don't even know. Good day. Good day to you, sir. All right, so we're here for Armand Tomar, 5A02696884. If you want to begin with any preliminary motions.
Yes, Your Honor. I have one that goes way deep into the weeds.
Perfect.
So I'm going to avoid that one first and see if the other one is dispositive. It is a unfortunate issue that's kind of proliferated throughout the entire certification scheme of the Washington State Patrol. I believe the ILJ 6.6 certification is invalid. It's signed in 2021 for the CV only. It's not signed with present intent for any other portion. The device is purported to be tested years later. There's no signature for the testing portion or date. So for that reason, we asked for a suppression and dismissal.
All right, let me go ahead. So L1492.
And Your Honor, are you currently pulling that one up from the Washington State Patrol?
Yes, I am.
If you, before you go into that one, if you look at the details tab instead of the certificate, you're gonna see the standards device, standard in which the device in which the standards are derived from is S040. That becomes another issue later on.
Holy moly. Okay. All right. Let me just look at this really quickly because I think that your motion will be fine. Okay. Now let me go ahead and look at the police report and just see if there's any impressions. Okay, yes, all I have here is I observed the defendant traveling at a visibly high rate of speed. So yes, I'll go ahead and suppress the information obtained from L1492. So I'm suppressing that the reading, and as such, I don't find any other observations in regard to specific speed. So I'll go ahead and dismiss this infraction for lack of foundation. What was your next argument? I'm almost like morbidly curious.
So S0, I've raised this issue before, but I've actually found it's actually going, it's worse than I thought.
Okay.
So S040, normally we're seeing it as something like S009 as a DB Innovations Vocard model, and it's purported to be the technician to be Steve Rosario on that 83 or 87 or 82 or 81 page document. But unfortunately, when we look at the device itself, S009, for example, or any DB Innovations, it's signed by a guy named John. So there's perjury throughout that entire actual certification scheme itself. But beyond that, in this one specifically, S040, when you look it up, they're testing other devices that aren't DB Innovations using DB Innovations. So basically S040, the entire place where the standards are derived from for L1492, comes from actually S046. S046, the entire certification is again signed by a guy named John. It's not even it's not a speed measuring device, so it doesn't need to be, you know, under the same 6.6 standards. But bottom line, they're using perjured standards to test other devices to say now this standard's valid. The reality is the original standards were invalid in the first place and untrustworthy, unreliable, completely using perjured information. And then they use that to daisy chain it onto one and call it clean and safe now. And they use it to test every other device. Basically, this is an issue that I believe probably, if I look into it even further, probably proliferates through every single speed measuring device in Washington.
Are you gonna get everything thrown out?
That's basically my goal at some point. Because bottom line, this is one of those issues where if you simply print off ILJ 6.6 and fill in the blanks, there should be no problems. But when you try to reinvent the wheel, that's not what the legislature has stated or the court rules or anything, and you try to do your own thing without guidance of likely not an attorney anywhere in the Washington State Patrol, you get horrible standards and horrible results. And we see them keep reinventing their wheel, but unfortunately what they're doing is they're reinventing a broken wheel to make it more broken or broken in a different way.
Watch, everyone's gonna be speeding like crazy because of you. No devices. Just
Well, I can tell
visual
you
estimations.
the different devices, all these different manuals and all of that, they're actually supposed to be safe from distribution and not supposed to be provided and supposed to object to any subpoenas or anything like that if you're watching State Patrol or, you know, and that information comes directly from Steve Rosario in a conversation I had with him personally. I do have those manuals from other places, however. Interestingly enough, Cam has provided them to me. So if I ever actually contacted Custom Signals, for instance, and be like, hey, they didn't object, they can go ahead and yank back those devices and I can make speeding legal in Camas.
Dang, look at you causing chaos.
But I mean, bottom line, it seems like Day Wireless, for instance, they test all the municipalities. They're doing great. Unfortunately for me. But for some reason, Washington State Patrol having many more resources can't figure it out.
That's about how it goes, isn't it?
Yeah.
Just another day.
Yeah. No, it's I've got an email from Steve Rosario about this issue. He indicates I need to be educated further. But it appears to me that perhaps he might be the one who needs to be educated further.
That's funny. He told the person who like literally knows more about speeding tickets than anyone in the world that you need to be educated further. Wrong person to tick off, Steve Rosario. Wrong person. All right. Well, challenge accepted. Good luck. Don't make me go out of a job because of your work.
One of the other issues I saw on this one, that it's an untested argument that I haven't tested yet, but I think it holds valid. You see a lot of times in speed measuring or speeding tickets, you see that it's I'm 100% certain it's from this vehicle. It's the only vehicle in the radar beam or laser beam or whatever. Laser dispersion, however, at 1,500 feet, it's 4.5 feet wide as a laser beam. An average car is 5.6 feet wide. So at 2,000 feet, however, you're at 6 feet. If you notice, this one's 1,821 feet. The beam's likely wider than the actual vehicle. So how can you say you're certain it's 100% from that vehicle when you're picking up any other vehicle in any other lane around it?
That's a great argument. That's actually, yeah, very valid.
Sorry, laser dispersion.
You're good at this. Good for you. Good argument.
I wish I was good at like murder cases like this, because I would be retired in like 3 years.
Right. Well, you can always get a lot of these cases. I feel like people should hire you. You're doing an awesome job.
Yep. No, yeah, I know a lot about these.
No, you do. It's scary. Every time I see your name, I'm like, ugh, I'm screwed. So yeah. Oh.
Well, I can tell you that I've been hired by prosecutors, judges, judges' sons. Basically, when it comes to this area, they hire me because they know.
Yeah, you're good at what you do.
Yeah,
you're absolutely great at what you
if
do.
a judge is hiring you, you're probably doing a good job.
And that's a pat on the shoulder for you. So good pat on the back. You're doing a great job.
Yep.
Okay. Well, thank you for your time and yeah, good job.
Thank you. Enjoy your rest of your docket if you have any more, and enjoy lunch.
I have a ton more. I'm very excited. Thank you.
It was good seeing you again. Thank you.
Good seeing you as well. Bye. Do you think that Lesh is here for your check? Oh no, there's your check. Here, let's get your check. Process. All right, Mr. Your check, if you could please unmute. Hello, if you could. So we're here for Paul Rosas de process. All right, Mr. Your check, if you could please unmute. Hello, if you could. So we're here for Paul Rosas de la Torre, 580211711188. I apologize. If you could please begin with any preliminary motions.
I had a motion under 550-103E for lack of agency or department in the signature block. In addition, this was a cell phone use by a CDL driver, which is permitted per the statute.
Mm-hmm. All right. I do find a lack of agency in the signature block. As such, I'll go ahead and suppress the report and dismiss for lack of foundation. I believe this is a sole. Yes. Go ahead and dismiss the sole traffic infraction.
And that's all for me. Thank you very much.
Thank you. There you go. We can do Shapiro, just get it out of the way. Ruben. All right, hello, let's get going on your cases. So you have, who is it? Yoel Undemescal, 5A02711182. If you could please begin with any preliminary motions.
Correct, Your Honor. Motion to suppress the police narrative. Looking at the citation, our client was cited for using a handheld cell phone, right hand with the right thumb. Oh, that's just what the police officer says, but using an electronic device. Your Honor, the state bears the burden of proving that each element of the infraction, while the officer, he does state in his report that the defendant was not using the device to contact emergency services. One of the lawful uses of that statute, or the exceptions, is if you're using it for commercial purposes. And here the officer does not state anything that the client was not using it for commercial purpose. I know that he was driving a commercial motor vehicle over 10,000 pounds, and he was identified using his commercial driver's license. But without that affirmative evidence that he wasn't using it for commercial purposes, I don't believe the state has met their burden of proof here. And so we'd ask the court to subsequently dismiss.
I agree. There's a statute that says that CDL holders can use their phone while driving. So based on that information, I'll go ahead and dismiss for lack of specificity in the police report. And also because CDL drivers are allowed to use their phone.
Thank you, Your Honor.
So is this a sole charge? Yeah. So I'll go ahead and dismiss.
Thank you, Your Honor.
And then you have one more matter.
That is correct. This one's for Jennifer Stevenson.
Stevenson. Okay, please begin with any preliminary motions.
Your Honor, motion to suppress the speed reading here. It looks like I'm looking at the police narrative, and it states that the speed measuring device was L-514. No such speed measuring device certificate 6.6 affidavit exists for this kind of speed measuring device. And so we have no way of verifying the accuracy of the speed. And so subsequently asked to dismiss.
Absolutely. So L-1514.
Does it say 1514 for you?
Yeah, what does it say for you?
It just says L-514, and I can hold it up to the screen.
No, as an officer of the court, I'll go ahead and trust you. That's actually been happening a lot. And I have discussed with my clerks why I would have it on my end and why you wouldn't have it on yours. I don't know why that happens. I do give the benefit of the doubt to the officers of the court because I don't think you'd be making those arguments if that's not what you had on your end. So even though I have a different SMD number, I will go ahead and give you the benefit of the doubt, and I will go ahead and dismiss for inability to find the 6.6 certification based on the lack of the correct number. So is
Thank
that
you, Your
just a sole one? Sorry.
Believe so.
Yeah. Okay. All right. So yes, I'll go ahead and dismiss that one as well.
Okay. Thank you so much, Your Honor. I
All
believe
right.
that's it.
Thank you. Thank you for your
Have
time.
a good day.
You too. All right, there you go, Mr. Clerk. All right. So let's do Burnett. What does Burnett have? Thank you. Burnett is very. Hey, Mr. Burnett, if you could please unmute. All right. Hello, sir.
Good morning, Your Honor.
Good morning, sir. So you have two matters today. I believe your first one is Patrick Curie for A0842491.
Yes, Your Honor, I have a preliminary motion in that matter, and I because I don't know how the court rules on it, I'm just going to throw it out there and see what happens.
Let's do it.
All
Sounds
right.
great.
There are several signatures, Your Honor, but there's no agency listed in the signature block as required under 5500103E.
So yes, those are valid arguments. I grant those motions all the time. So I'll go ahead and grant your motion. I'll go ahead and find that there's a lack of agency in the signature block. And as such, I'll go ahead and suppress officer's report and dismiss for lack of foundation.
Thank you, Your Honor. I have a couple for my next one. That would be Mark Richards at the court's convenience.
All right, please begin with your preliminary motion.
Thank you, Your Honor. There are a couple of things here. The thing that hit my mind was that the trooper's report, the narrative that is dated 11 March of 25. However, he indicates in the narrative that that all of these events happened on March the 22nd of 2025.
Joke's on us. It goes back to this ridiculousness.
Yeah, I grew up here. I'm used to it.
That's true. You're like, this is nothing out of the ordinary.
Right. If it's not sunny after the 4th of July, then I'll feel cheated.
And then it just rolls into bad weather again.
Yes.
All right, sir. So Patrick Mello is your first 580022496. If you have any preliminary motions.
Thank you, Your Honor. I believe that you're familiar with this argument. It's to suppress the narrative in its entirety under 5500103E. That requires the officer to indicate a department or agency in the certification. I received a total of 5 pages. I'm looking at the 5th of the 5 pages.
All right, sir, I do see that there's lack of agency in the signature line. As such, I'll go ahead and suppress the traffic violation affidavit and dismiss for lack of foundation.
Appreciate it, Judge. And before we move on, I note that the respondent, Mr. Mello, had paid the fine inadvertently. I think we asked the court to place it in trust, and I'm hoping the court will go ahead and refund that to him.
Absolutely. So has it been placed in trust, Mr. Clerk? Yes, we'll go ahead and refund that amount then.
Thanks, Judge. Appreciate that.
There you are. Okay, and then James Richards, 5A02138844. Please begin with any preliminary motions.
Thank you, Your Honor. Mike Sheehan for the respondent. And again, Your Honor, looking at page 3 of 3, I don't see any agency or department in the certification block as required under the statute 550-0103E.
I see WSP
Okay,
in the signature line. Do you see that?
I do.
Okay.
I do now. It's cut off, but I do. Yes, I
Okay.
see 1030 WSP. Thank you so much.
Yeah.
I missed that. It looked like it was part of the badge.
Frustrating. Good day for you, bad day for me.
Thank you, and I should know myself by the next time we're in front of each other.
I'm sure you will. You seem very eloquent with your law arguments, so I'm sure you'll be able to school me next time you're here. Okay, so Durden is your next matter. Robert Durden, 5A026719.
Thank you. We have a motion to suppress the speed reading for lack of authentication. The report states that speed measuring device LiDAR serial number L1591 was used. However, the 6.6 certificate for this speed measuring device is not sworn to under RCW 5.50.050. There is a date of testing the device for this speed measuring device on page 4, but there's no date of attestation. There's no place that it was signed as required under RCW 5.50050, such that the 6.6 certificate is considered an unsworn statement lacking sufficient reliability.
Let me go ahead and pull that up. Oh, this is 15. Okay, yes, I did look at this one earlier. So yes, I will go ahead and suppress the information obtained by laser SMD L1591. And then in this situation, it just says, I observed the vehicle appearing to be exceeding this posted speed limit of 70 miles per hour. I don't find that sufficient to have a speed statement by the officer that would counteract the suppression of the SMD speed. So as such, I will go ahead and grant your motion and dismiss this sole count for lack of foundation. All right, and then your last one is Andre Horpinch, 5A00222474.
This case has 2 counts. The first count is an electronic device while driving. In the first count, we have a motion to dismiss for insufficient evidence under the cited statute. The defendant was cited for electronic device while driving, RCW 46.61.6721. However, subsection 2 explicitly states, quote, subsection 1 of this section does not apply to, and then.
All right, Mr.
Hello.
Scow. Hello, sir. So you're here for 9 cases today. So you have quite a lengthy docket for you. All right, sir. So the first matter I have is Vladimir Belyavsky, 5A00777831. Please begin with any preliminary motions.
Yes, Your Honor, and for the record, my name is Matthew Scout, Roberto Urnella's office, and while I do have motions for each of these 3 counts, I did notice that there does not appear to be any department or agency in the signature block of this narrative, nor any signature at all on the supplemental virtual waste station vehicle record details document. So for those reasons, we move to suppress the narrative and the waste station details and dismiss for lack of evidence.
I will go, excuse me. I will go ahead and suppress for lack of agency in the notice. So based on that information, I'll go ahead and suppress the additional information and dismiss for lack of foundation. This is 3 counts. 1, 2, 3. All right, sir. And then your next matter is Roman Chaika for A0828061.
Yes, Your Honor, and I have the same motion on this case. It doesn't appear to be a department or agency in the signature block of this case.
I will go ahead and grant your motion. I see that there is lack of department or agency in the signature block. As such, I'll go ahead and suppress the information provided by the, I believe it was, sorry, by the officer, and go ahead and dismiss for lack of foundation.
Thank you.
All right, your next matter is Gleb Chumuk, 5A0271168. If you could begin with any preliminary motions, please.
Yes, Your Honor, and although this is the first time I've seen this particular charge ever, the motion is the same. There doesn't appear to be any motion or department or agency in the signature block, and so would move to suppress the narrative and dismiss.
I will
I
go
think
ahead
it's the same officer as the previous case. Apologies for interrupting him.
No, not at all. I'll go ahead and grant your motion. I do see that there's a lack of agency in the signature block. As such, I'll go ahead and suppress the traffic violation affidavit and dismiss for lack of foundation. I've actually been seeing this infraction quite a lot lately.
Oh, the radar detector infraction?
Yeah, I think that maybe they're catching on to it. This maybe the second or third time that I'm seeing it. It is more of a novel one, but it is coming across a little bit more often now for some reason.
Huh. All right. Well, I'll keep my eyes open for more.
Yeah. Peter Fuentes, 5A02198847.
Matthew Scout, Roberto Urnella's office. For the record, this is also a motion to suppress the narrative for lack of department or agency in the signature line. He does use the title trooper. I don't know if this court finds that sufficient or not, but he doesn't indicate department or agency.
Yes, no, I haven't found that sufficient. There is lack of agency in the signature block. As such, I'll go ahead and suppress the officer's report and dismiss for lack of foundation. In Fuentes, there is actually 2 counts. Next one is Alina Hildebrand, 5A02198895. Please begin with your preliminary motion.
Yes, Your Honor, this is a motion to suppress all evidence, if any, for a violation of IRLJ 3.1b. We made our timely request to the state back at the end of February and have not received any discovery materials.
I do see your request for discovery filed with the court on February 28th. Did you file an affidavit of service? Go ahead and set this over in due course. I do want to confirm, sir, that I do have your request for discovery, but I have also checked with my staff and we don't see a proof of service attached to that. So if you could please send that in, but we do have the request for discovery. So yes. And then Mikola Kabish, 5A0271169. If you could please begin with any motions.
Yes, Your Honor, this is also a motion to suppress the narrative for lack of department or agency in the signature block.
Okay. All right, I do see that there's lack of agency in the signature block. As such, I'll go ahead and suppress the traffic infraction affidavit and dismiss for lack of foundation.
Thank you, Your Honor.
Sorry, it's a little far. John McCormick, 5A02138859. Please begin with any preliminary motions.
Yes, Your Honor, this is a motion to suppress all evidence of speed for defective 6.6 affidavit. In this case, I looked at the Washington State Patrol's online archive where they maintain those documents, and I looked up LiDAR device L1492.
Oh, yes, those are valid arguments. I grant those motions all the time. So I'll go ahead and grant your motion. I'll go ahead and find that there's a lack of agency in the signature block. And as such, I'll go ahead and suppress officer's report and dismiss for lack of foundation.
Thank you, Your Honor. I have a couple for my next one. That would be Mark Richards at the court's convenience.
All right, please begin with your preliminary motion.
Thank you, Your Honor. There are a couple of things here. The thing that hit my mind was that the trooper's report, the narrative that is dated 11 March of 25. However, he indicates in the narrative that that all of these events happened on March the 22nd of 2025.
March 22nd, and then he's, yeah. Oh, yes. Okay. Yeah, I'm going to go ahead and dismiss that. That's a good catch. So yes, absolutely. I'm going to go ahead and grant your motion. I think that there was no present sense in regards to the signature block. And so I'm going to go ahead and suppress the affidavit for lack of foundation. So that will be suppressed and dismissed.
Thank you, Your Honor. And I don't believe I have anything further for the court this morning.
Well, then thank you for your time, sir.
Thank you, Your Honor. Talk to you soon.
Bye.
Bye-bye.
So this was James Richards, correct? This is James? No, not James. It should have been Mark Richards. There's a Mark and a James. I think I grabbed the wrong one. There's two Jameses, right?
There is Mark Richards and a James.
That's where it got confusing because I was like H-I-J.
Appreciate it, Judge. And before we move on, I note that the respondent, Mr. Mello, had paid the fine inadvertently. I think we asked the court to place it in trust, and I'm hoping the court will go ahead and refund that to him.
Absolutely. So has it been placed in trust, Mr. Clerk? Yes, we'll go ahead and refund that amount then.
Thanks, Judge. Appreciate that.
There you are. Okay, and then James Richards, 5A02138844. Please begin with any preliminary motions.
Thank you, Your Honor. Mike Sheehan for the respondent. And again, Your Honor, looking at page 3 of 3, I don't see any agency or department in the certification block as required under the statute 550-0103E.
I see WSP.
Okay.
In the signature line. Do you see that?
I do.
Okay.
I do now. It's cut off, but I do. Yes,
Okay.
I see 1030 WSP. Thank you so much.
Yeah.
I missed that. It looked like it was part of the badge number. And Your Honor, then the motion is going to be to suppress the speed reading contained in the report. The officer's claiming that he or she obtained a measurement using tag number L1492. I went to the State Patrol website to look at the design and construction certificate pursuant to 6.6B and also Seattle versus Peterson. And this is not properly certified. You've heard this argument before. It was signed in 2021 by Steve Rosario, but the actual testing was not done until 2023. And that information is not certified.
Yes, based on that information, I'll go ahead and suppress the speed reading based on your 6.6 motion. And then I'm just looking through the police report and I see no statement of speed from the officer other than I observed the defendant traveling at a visibly high rate of speed. So I will go ahead and dismiss this charge for lack of foundation.
Judge, I appreciate your time. I hope you have a good finish to the week.
Thank you. You as well. There's that, and then let me just pull. So Gallinger. All right, Ms. Gallinger, if you could please unmute.
Good morning, Your Honor.
Good morning. So the first matter I have is Ricky Ash, 5A027111. She's here for 3 matters. Says the first one is Conover. So Ms. Lesh, if you could please unmute.
Good morning, Your Honor.
Good morning, Ms. Lesh. So you're here for 3 matters. The first one is Ryan Conover, 5A01563323. If you could please begin with any preliminary motions.
Thank you. For the record, this is Celia Lesh with Guard to Law. We have a motion to suppress the speed reading for lack of authentication. The report states that speed measuring device serial number L514 was used. However, there's no 6.6 certification on file for that serial number. Under City of Bellevue versus Lightfoot and Bellevue versus Maktulski. Evidence of the speed measuring devices unit. Its accuracy is a prerequisite to the admissibility of the speed measuring device evidence.
Okay. Go ahead, look that up. All right, based on that information, I'll go ahead and suppress the information obtained from the SMD. I am looking through the police report to see if there is. It says, based upon my experience and training, I visually estimated the speed of the defendant's vehicle to be 70 miles per hour and it clearly posted 55 miles per hour zone. Do you have anything to state in regards to the police officer's observation being in excess of the the speed allowed in that zone.
Mere observation without additional information, that being either radar or tracking the device, and referring to the officer's speedometer on his vehicle, that is insufficient to establish what's necessary for a speeding ticket.
Wish I had my case law in front of me. There's actually case law that says that it is sufficient for an officer's observation based on his years of experience to state, do I have my, sorry, 1 minute, Miss Lush. Or do I not have it here? Can't remember the case off the top of my head. All right, well, today's your lucky day because I cannot remember for the life of me what the name of that case law is. Actually, there is supporting case law that does state that an officer's observation of speed is sufficient to hold an individual accountable outside if the speed measuring device information is suppressed. However, I can't remember the case law name. As such, I'll go ahead and grant your motion and dismiss this matter for lack of foundation.
Thank you, Your Honor.
And that's frustrating. It'd be good for you to know as well. I'm sorry. Next time I see you, I'll tell you what it is. It's escaping me right now, but there is actually substantial case law on it. Jeez, that's frustrating. Good day for you, bad day for me.
Thank you, and I should know myself by the next time we're in front of each other.
I'm sure you will. You seem very eloquent with your law arguments, so I'm sure you'll be able to school me next time you're here. Okay, so Durden is your next matter. Robert Durden, 5A0267. Such, I will go ahead and grant your motion and dismiss this sole count for lack of foundation. All right, and then your last one is Andre Horpinch, 5A00224774.
This case has two counts. The first count is an electronic device while driving. In the first count, we have a motion to dismiss for insufficient evidence under the cited statute. The defendant was cited for electronic device while driving, RCW 46.61.6721. However, subsection 2 explicitly states, quote, subsection 1 of this section does not apply to, and then under 2C, an individual employed as a commercial motor vehicle driver who uses the device within the scope of the individual's employment, provided such use is permitted by 49 USC section 31136. 49 USC section 31136 does not prohibit use of a personal electronic device for commercial motor vehicle drivers, provided that their ability to operate the motor vehicle is not impaired. Here, the defendant is employed as a commercial motor vehicle and was at the time he was operating a commercial motor vehicle, Volvo Semi. The officer states that he observed the defendant using his personal electronic device, which was in a mount on the dashboard, and that there appeared to be a video chat on the device. A commercial motor vehicle driver within the scope of their employment needs to communicate with supervisors, other carriers, warehouses, etc. So I'd argue that it's certainly within the scope of his employment as a commercial motor vehicle driver to be using his phone in that manner.
I'll go ahead and grant that motion. What do you have to say about the second violation?
Thank you. On the second count, we have a motion to dismiss under State v. Lee for failure to properly notify the defendant of the charge. Cited statute RCW 4632010 has 7 subsections. Subsection 3, 5, 6, and 7 each describe a different traffic violation, and there's no subsection stated, so it's not clear what the defendant is defending against.
Go ahead and grant your motion. I'll go ahead and suppress both and dismiss.
Thank
Suppress
you, Your Honor.
information for both and dismiss. So there was, is this 2? Yes, 2. Okay. All right. Thank you. Thank you for your time, Ms. Lush.
Thank you, and have a good afternoon.
You as well. All right, you're now right, Mr.
Hello.
Scow. Hello, sir. So you're here for 9 cases today. Traffic infraction affidavit and dismissed for lack of foundation.
Thank you, Your Honor.
Sorry, it's a little far. John McCormick, 5A02138559. Please begin with any preliminary motions.
Yes, Your Honor, this is a motion to suppress all evidence of speed for defective 6.6 affidavit. In this case, I looked at the Washington State Patrol's online archive where they maintain those documents, and I looked up LiDAR device L1492. It appears that the 6.6 certificate is not signed by anyone at any point. It used to be just the SMD expert's credentials would be signed and dated, but the actual testing document wouldn't. I guess they decided to fix that problem by not signing any part of it, which seems to be the opposite direction in my opinion, but nonetheless, it's not signed by anyone, and for that reason, we move to suppress speed and dismiss.
All right, that's funny. Well, good for you, bad for them. So based on that information, I will go ahead and suppress the information obtained by the SMD device based on insufficient 6.6 certification. I'm just looking over the police report to see if there's any statement of speed by the officer. No, it only says I observed the defendant traveling at a visibly high rate of speed in excess of the posted speed limit. As such, I'll go ahead and dismiss this charge for lack of foundation.
Thank you, Your Honor. And this case also proves that officers are capable of including their department or agency if they really want to.
You know, I've seen a few included. I guess that what I've just heard is that it auto-populates the signature, and if they need to go back and put in their agency, they have to go back and retroactively fix that. And so it's just not something they like doing, which would solve, because I always ask, why isn't this being done? But, you know, not my problem, I guess. Actually, it is my problem, but ironically, it is my problem, but makes it easier for everyone. Julio Muniz, 5A0271144.
Yes, Your Honor, this is also a motion to suppress the narrative for no department or agency in the signature block.
Okay. All right, I see that there is lack of agency in the signature block. As such, I'll go ahead and suppress the traffic violation affidavit and dismiss for lack of foundation. This is just a sole infraction. All right, sir, and your last one, Gurpreet Singh, 5A0007773. Please begin with any preliminary motions.
Yes, Your Honor, this is also a motion to suppress the narrative report for lack of department or agency in the signature block.
Marcus Hogan. Okay, yes.
Every day in the USA, people find themselves in court.
For the court, I was being, respectful and solemn for the administration of justice.
When did that change happen? You've never been that way.
Woke up this morning.
Yeah, I woke up this morning and said I'm going to be solemn. Okay, all right, very good. They're in custody
Yes.
on Zoom. Court calls the case of the people versus Timothy Haslam.
Good morning. Is this the public defender Lauren Perry on behalf of Mr. Haslam? Mr. Haslam, please state your name for the record.
Timothy Haslam.
Your Honor, Mr. Haslam is obviously in Macomb County. I have been trying to meet with him. They use an online system that is just not functioning correctly with my computer. I've had IT working on it. So I haven't met with Mr. Haslam. I know this is a time-served recommendation. However, there is a discussion about HIDA. And I would like
in this case.
Right.
Oh.
And I would like to explain that to him. He is being held in Macomb County on I think a $50,000 bond. an exam is scheduled for, I want to say June 6th, but I'm not sure if that's correct, in the next couple of weeks. So I asked for an adjournment of the sentencing. I apologize to Mr. Haslam. I'm working on trying to get out there. Or I might have to go there, but their online system is giving me some issues.
Mr. Haslam?
Yes.
You've got another case here. Another misdemeanor complaint that alleges that on or about November 25th, 2024, location in Pittsfield Township on Carpenter Road, that you did operate a motor vehicle while your license was suspended, denied, and or revoked. Do you understand the nature of that charge, sir?
Yes.
Okay. That's a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court cost, 93 days in jail, $500 fine plus court cost. You understand that, sir?
Yes.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes.
This is a public defender case.
Can
Do you need the case number on that?
No, that's okay.
All right.
We'd waive formal reading and stand mute to the charges.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea in this matter. Tracy.
Yes, sir.
All right. I will set his bond at a 1,010% bond, so he gets credit. That was his warrant amount. Now, what's my next sentencing day?
May 28th at 12 p.m.
Do you think, Ms. Perrini, you'll get whatever needs to be solved by May 28th?
I think so. If I can't get the online system, I think I can request an in-person and go out to my home.
All right. And I don't want to bring him back twice on this pre-trial, so let's do this. I'll set your pre-trial, Mr. Haslam, on the one that I just arraigned you on, that case. I'll set that for a pre-trial. Well, problem's going to be I won't have Siller here on the 28th.
It's a trial docket in morning, but yeah.
The sentencing would be in the afternoon.
Yeah.
Give me my next. Let's do it this way, because this other one is, give me my next pre-trial date, and I'll just set the sentencing at a special time.
Okay, so pre-trial would be June 4th.
All right. I'll set the pre-trial in your other matter for June 4th, 2025 at 9. Okay. And then I'll set your sentencing on this case also for that June 4th, 2025 at 9. That'd be a special time for a sentencing, but that way you don't have to come back twice. All right. All right. Thank you. Court does call the case of People versus Jenny Liu.
Good morning, Assistant Public Defender Lauren Perrini on behalf of Ms. Liu. Ms. Liu, please state your name for the record.
Oh, she's unmuted, I think now.
Jenny Liu.
Okay, thank you.
Your Honor, today's date and time set for sentencing. We have reviewed the pre-sentence report and don't have
Department payable through the court. That will be due 90 days after release. And I'll order 180 days in jail, credit 180 days, sir. Okay? Thank you, sir.
Thank you,
Take
Your
care,
Honor.
Mr. Kyler. Have a good day.
Thank you, Mr. Kyler.
I think. Court does call the case, People versus Yolanda Woods. That's all my in custody.
Yes.
Hello.
All right.
Yes, good. Good morning, Your Honor. Bruce Davis, P 76203, appearing with Yolanda Woods, who's present via Zoom.
So Woods, could you identify yourself, please?
Yes, Yolanda Woods.
All right. Go ahead. This date and time set for sentencing, counsel.
Yes, it is, Your Honor. I had a chance to review the pre-sentence report. No corrections, deletions, or additions. And the recommendation is in line with what the prosecutor and I discussed. I think the deferral program is good for her. She doesn't have any prior criminal history, no thefts or anything like that. She's 54. She's working. She's working for Eastern Michigan in a clerical position. We asked the court to adopt the recommendation as is.
Ma'am, anything you want to say before I impose sentence?
No.
All right. Sentence of the court, place you on 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $125 probation oversight fees. When can you get that paid, ma'am?
I can pay half today and half on the 13th of next month.
Okay, so $300 today.
Yes.
All right. And then the balance, you said you could pay it by the 13th, so I'll make it the balance by June 16th,
Okay, thank you.
2025. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. No going to any Walmart store in the state of Michigan. I will set a review hearing September 10th, 2025 at 9 a.m. I'll order 90 days in jail that is suspended. All right.
Okay, thank you.
Thank you, Judge. Have a good day.
Thank you. All right, take care.
Yeah.
Calls case, People versus Jonathan Weber.
Morning, Judge John Shea appearing with and on behalf of Mr. Weber for sentencing.
Go ahead.
Judge, Mr. Weber's before you on his first offense. He's 63 years old. The BAC was not low, but not hugely high either. It was 0.156. It was a very minor accident. And by that, I mean, it was a very slow speed rear end. And it's a matter of him being drunk and not adequately giving himself enough room to stop at a red light. Very little damage, both cars drivable, that kind of thing. He was completely honest with the police. When they asked him if he had been drinking, he said yes. When they asked how much, he told them. When they said when, he told them. So there was no screwing around. He's been responsible since this case. He's sober. He's enrolled in an IOP, complete it next week. He's had negative tests through community corrections. He's had negative tests in the IOP program itself. They ETG him every week. He's prepared to pay his fines and costs today. He's reported this to the bar. He's doing everything that he's supposed to do. And he looks great and he feels great. So in a sense, I'll let him tell you this himself, but in a sense, this has been unfortunate that it happens in this way, but he's happy to be sober. I'd ask the court follow the recommendation. I think it's fair.
Mr. Weber, anything you want to say before I impose sentence?
Yes, Your Honor. I am very sorry that this happened. It has been something I've been very careful about in the past, and I blew it. The only positive thing is being in the IOP, those people are really good, and I don't think I'm ever going to drink again. I think 40 years of drinking is enough, and I have every intention of never drinking again. And thank you for your patience.
Sometimes it's all I have, right? All right. All right. And Mr. Weber, as I indicated, I do know of you, and sometimes bad things happen, sometimes for a good reason, right?
That's exactly what I said to my sister.
Pardon?
Right after the accident, after I spent the night in jail, I called my sister. I said, I was in an accident last night. It might be the best thing that ever happened.
Okay. And the other thing I was going to point out is that also being aware of you, there's a lot of good things that you've done throughout your life and career. And certainly this, I think the important thing to note is that doesn't erase any of that, right?
Thank you.
All right. The court does acknowledge that this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol assessment, screening and assessment identifies the benefit of an IOP program, as well as random testing. Therefore, I will follow probation's recommendation of a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. It's therefore the sentence of the court that I would place you on 12 months probationary term. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is going to be paid today. Is that correct? All right. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete your IOP treatment program at U of M with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. I'll continue the sober link for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended.
Thank you.
Thank you.
Thanks, Judge.
Thank you.
See you soon.
Court does call the case of the people versus Sequandala Middleton. I messed that up again.
Covered on behalf of Miss Middleton. Good morning, Judge. Miss Middleton, please state your name.
Sequandala Middleton.
I always want to put another, I want to break the syllables apart in a different way. I apologize again, man. All right, go ahead, counsel.
So thank you, Judge. So we are here for sentencing. We have reviewed the report.
The May 16th. Well, I'll make it May 19th.
I appreciate that.
All right. And then 90 days in jail that is suspended. All right. Thank you. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Your
I
Honor.
appreciate it.
Thank you, sir.
Court
You can
calls
have
case people versus Juwan Wilson.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Wilson. Please state your name for the record, sir.
Juwan Wilson.
Your Honor, we did review the pre-sentence report. We don't have any material changes, additions, or deletions. We did also review the recommendation. We believe that it to be fair, and we ask that you adopt it.
Sir, anything you want to say before I impose sentence?
Oh, sir.
Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $120 probation oversight fees. When can you get that paid, sir?
I say before the 4 months is up.
Pardon?
Before the 4 months is up.
Okay, but how are you going to pay it?
Do you have like an amount monthly you think you can pay?
Yeah, $50 a month. I could pay 100 today.
Okay, that's a good start. 100 today. And then how much are you going to pay each month? You're going to have to actually get it done in 3 months if we're going to do the 4 month.
Yeah, before the 4 months. I'm not sure how much that is.
I can't do the math off the top of my head, but it's
He'll have 500 due
after the 100.
after the 100.
250 on.
That's something you can do?
Yeah.
Okay.
All right, then $250 per month until that's paid. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. You're not to go to any Walmart store in the state of Michigan. I'll set a review hearing that's to be held on September 10th, 2025 at 9 a.m. I'll order 90 days in jail. Credit 3, balance is suspended. Thank you. Court does call the case, People versus Frederick Warden. Oh.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Warden. Warden, please unmute and state your name for the record.
Frederick James Worden, II.
Your Honor, today's date time set for sentencing. Mr. Warden still needs to complete Von Schwartz.
$125 statutory fee, 93 days in jail, credit 93 served. You're all set.
Thank you.
All right, thank you.
Thank you, guys.
Thank you. Court calls the case, People versus Willie Henley.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Henley. Your Honor, not.
Hello, what's your name?
Willie Henley.
Okay, there he is.
Great. Your Honor, we were not able to speak prior to today's hearing. We did provide him the information. I'd ask that he provide the court with some information on his financial situation. I believe he owes $600.
I have $600 owed. How are you gonna get that paid, sir?
I've been trying to make payments, but the court over the phone don't allow me to make payment. It wants the whole thing at once. I'm a DoorDasher and I DoorDash on the bike, so it's hard for me to come up with exactly 600 at one time. So I've been trying to make payments, but over the phone. I don't live down Ypsilanti
I don't
anymore.
think you can make a payment over. You may not be able to make a payment over the phone.
I mean, yeah, I've been trying to do it over online on the thing, but they wanted the whole thing at once. On doc.
Well,
I'm doing it on
Mr.
doc.
Henley, how about this? Call the public defender's office, update your contact information, and I'll get with you and see if I can assist you on making the payments.
Okay, what's the number to the public defender?
222 69.
You can you can Google it.
Google it. Okay.
Got it?
Yeah, I can Google
You got a
it.
pen?
No, I don't have a pen. I'm outside, so I have to run to a building and try to find a pen.
You got somebody that can write this down?
No, I'm outside. I'm outside dancing. So I don't. I'm running over to a restaurant right now, to the nearest one. Grab me a pen. Sorry about that, Judge.
All right. You ready?
Yes, sir.
222
222
6970.
6970.
Yes, sir.
We want that's 616 734.
734.
Okay.
All right, 734-222-6970. Call them, make sure they have a good phone number for you and an email address if you have one, okay?
All right, thank you, Judge.
All right, I'm gonna adjourn your matter to June 11, 2025, 9 a.m. Take care,
All
sir.
right. Thank you.
Court calls case, People versus Carlos Hicks.
Assistant Public Defender Natalie Pate for Mr. Hicks, who may be present in Zoom. Sir, you're there. Can you please let me state your name for the board?
Carlos Hicks. You got two cases?
So one can be
It's a new felony. Yeah, I got it. $1 referral fee. He's to pay that today to the court. I'll adjourn his sentencing to June 11th, 2025, 9 a.m. That sentencing will be in person. All right. Thank you.
Aaron.
Court calls the case, People versus Jessica Duff.
Or Your Honor, Dan Garrett on behalf of Jessica Duff stepping forward.
Jessica Duff.
Thank
Your
you.
Honor.
Your Honor, we've reviewed the pre-sentence report. It is accurate. I'm asking Your Honor to follow the recommendation. Of note, financially, my client paid the restitution entirely today, has brought cash to make sure the victim's made whole on that, as well as her fines and costs. I want to point out how proud I am. Ms. Duff has proactively completed her Dawn Farm program, and she's been on the scram now, I think, almost 6 months without one violation. Tribute to her sobriety and her commitment to doing what the court asked her to do.
Yeah, Teresa Claire on behalf of probation. Your Honor, the victim, Amy Hudson, is present. She would like to make a statement.
All right. Oh, I just have it.
Good morning.
State your name, please.
My name is Amy Hudson, AMEE. Last name's Hudson, HUDSON.
All right, go ahead.
So on August 31st, you changed my life forever. You made the decision to get behind the wheel of a car drunk. You drove into the back of my car. I was sitting at a stoplight. Not only did you drive drunk, but you were speeding. I will never forget the sound that haunts me to this day. By throwing me around in the car like I weighed nothing after the pressure of your vehicle blew out the back tire sitting in the driver's seat, which broke, by the way, along with the seatbelt. The airbags burning into me and the pain. I honestly don't remember much about getting out of the car, except for the look on the passerby face. The driver's door was broken. It took both of us to get me out. He stood there with tears running down his face, telling me not to swallow due to the blood pouring from my mouth and face. From my nose and mouth, excuse me. The pain from my left side and hip was worse than pain I'd ever described, that I could not even realize I was bleeding, burned on my elbow. My left hand was completely damaged. I ended up going to the same hospital, to the same ER as you. You did not know it, but I was in line in front of you. As I cried in pain, I listened to you laughing and joking with the officers. Not once did you ask about the other driver or what you did or what was going on. There was no remorse. For nearly 7 weeks, I was on crutches. This did not include the 7 days beforehand that I was completely bedridden. I cannot drive past that street without shaking. If someone comes up behind me too fast at a stoplight, it's hard for me to even breathe at times. You did this to me. You made the choice to drive drunk. The permanent effects from this vehicle accident that I have to live with the rest of my life, just to state a few. I have permanent scars from the burns from the airbags. I will never get to feel what it feels like to put a ring on my wedding finger again. It is damaged to be unfixed. I walk with a limp. I have permanent damage done to the side of my face, to the right side of my face. I have permanent damage done to the left side of my whole body that will never be able to be repaired. After grueling months of physical therapy, which I'm still going through, multiple surgeries, I will never get any of that time back. The only income that came out of this was that I learned one thing about the justice system, and that is that they're not always your friends. The victims are the ones that pay, and the criminals are the ones that are made to look like the heroes. I have fought every single day for my voice to be heard. I have fought every day for the insurance companies, for justice to be served as today, and for you to be sentenced for this. I am asking for the court to give you the highest recommendation can be, including having it be to where anytime you get into a vehicle, you have to blow. I'm also asking for the restitution, which does not even cover half of what I've lost or what I've had to pay for. It's only for what I could find the receipts for of the rental vehicles and for the towing, which is $2,700, I believe $40.21. Thank you.
Well, first of all, I have $2,720 $20.80.
I did not have the amount in front of me.
Oh,
Is the reason why I was saying that. I did not have that. And that does not include, that's only the receipts I could find of the rental. It was I had a loaner vehicle. So that's what I was driving. So while the insurance companies were fighting, I had to rent a vehicle until he could get his money back. And then he proceeded to work on my vehicle. So but that was.
Are you telling me that there's additional restitution?
Yes, there is, but I'm not charging for that because I could not provide the receipts. I only had until May 7th. And unfortunately, one of the places that I rented the vehicles from closed their doors at the end of last year. So I was not able to get the original, the receipts for that one.
Okay. All right.
Thank you.
Your Honor, if I may, I'd like to make a direct apology to Ms. Hudson.
May
May I turn and face her?
Okay.
I'm so sorry. I'm so sorry. I take full responsibility. And I'm so sorry for the damage that I caused to you and to the hurt that I caused to you. If I could take it back, if I could undo it, I would. I would completely undo it. I will never do anything like this again. I'm sorry.
Thank you. I appreciate that. Thank you.
Is there anything you want to tell the court before I impose?
Same, Your Honor. Sorry, and I'm deeply regretful. I've learned from this. I think about this every single day. I do have complete remorse. I do have complete regret. And I intend to never repeat anything like this experience again.
This is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, AA meeting attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, I will place you on 18 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees, $2,720.82 restitution that is payable to Amy Hudson, but that is payable through the court. What can you pay today?
We're prepared to pay that in full today.
Pardon?
We are prepared to pay in full today, Your Honor.
Everything today?
Yes.
All right. And you do have then the restitution in cash, correct?
Yes, sir. We
Okay, very good. All right, all of that is payable today. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Dawn Farm outpatient program, including all aftercare recommendations with status reports to probation.
Yes, Your Honor.
You are to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation that has, to my understanding, been completed.
Your Honor.
I will continue to scram tether for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. You guys outside.
Court does call the case, People versus Naji Kahala.
Good morning, Your Honor. Dan Guerin on behalf of Naji Kahala.
Good morning, Your Honor. Naji Kahala.
Thank you.
Your Honor, Mr. Kahala and I have reviewed the pre-sentence report. It is accurate. We are
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $3,500. Give a 10% privilege on that warrant will issue. Court calls case People versus Paula Johnson.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Johnson. Your Honor, do you mind if Ms. Johnson sits while we
Not a problem.
call her hearing?
How are you today, Your Honor?
I'm doing okay, Ms. Johnson. How are you?
I'm here. Thank God for that.
Oh, can you state your name, Ms. Johnson?
Yes, Paula Johnson.
Your Honor, we are here for a show cause. I think Ms. Johnson owes about $218. She did,
Just didn't pay so she can come back and see me.
That's
I know why she didn't do it.
See, he knows.
I know.
Cause he just don't ask me. He try to get all the way.
What?
That's it.
You said what?
Nothing.
No.
No, I said, cause he's so handsome, he think all the women be trying to get in to see him. That's what I said.
I did not say all.
No, I said that.
Oh, okay,
No.
okay.
You
I-
said,
I
I
did not
said
say
those
that. Yeah, they come here to see Alan. They don't come here to see me. I'm just.
I don't get you in trouble. You know your wife
Yeah.
will hit you.
What?
You know, I know your wife will hit you, so you better, yeah.
Okay, Miss Johnson.
Look, see, hindsight, you know I'm telling the truth. Look at you. You just smiled knowingly.
Nothing else.
Okay.
I'm just gonna leave that.
Right. There you go.
All right. So
I didn't know I still owed you money though, first of all.
you didn't know?
I was the God I didn't. I would
I was shocked there was only one case left.
now you know that was so, how do you do?
I
Okay.
just said it. I just said
Okay,
I was just surprised only
touche.
one case came in.
Touche. Okay. We do go way back, don't we?
Yeah, it's been a while.
Yeah,
All right.
that's a blessing, right? I'm in school, doing really good. Yeah, I am.
You're in school?
Yes.
What are you doing this time?
Criminal justice, he say this
Oh,
time.
man.
Yeah, I know. I knew it. I knew it.
You're in the criminal justice?
Yes, sir, I am. Doing quite well, by the way.
What?
I said, I'm doing quite well, by the way.
Yeah. Given how you operated, you're probably an expert.
Little bit. On certain levels. You're right.
Yeah, I'm just saying.
I know.
All right. So how are you gonna get this paid?
I don't know. I was hoping you was just gonna let me not have to pay it because since I'm in such a dire strait right now. I mean, I paid the majority of it. I thought maybe you could say, well, she did so well.
Could I speak for my mother?
There go my baby.
I just have a few.
You wanna talk, this is your mother?
That's my baby, yes, sir.
I'm so sorry. No, I'm kidding. Come on.
By the way.
Daughters myself and my mom, we are all obsessed with her. Just recently.
What's your name, first of all?
My name is Jolita Addison.
Okay.
So just recently, my mother has had a lot going on. She had a bout of double pneumonia. And she spent about 4 days in the hospital for that. She got out and was out for about 3 days. Whereas they had a car accident, her and my dad. They had a very bad car accident, which totaled their car. She had bruised her kidneys and was in the hospital for another 4 days at that point. Then at that point,
Let him know,
she got
no
out.
fault of mine. Hold on.
It was no fault of her own. Yeah, someone lost control of their vehicle on the highway.
And ran into.
And she got hit twice.
Yeah.
So she had spent about 4 days in the hospital. Then upon getting out from that, she was still very sick. And we had to take her back to the hospital for another 4 days. Because she just wasn't doing very good with the pneumonia. She was still struggling with that. She's still having to recover from that car accident. She's got to now try to figure out how to get another vehicle. I just asked that, kind of similar to what she's asking. She just doesn't really have the funds at the moment to try to come up with that. Even trying to do a payment would be a lot for her. She is in school, like she stated. She's doing her absolute best. She's been pulling in almost all A's and B's, and I'm so proud of her. She's been doing really good. As you see, like you said, the Stone case, she's been doing really good, and I'm very proud of her. That's all I have to say.
That's all?
That's all.
Okay, no, yeah, I was gonna let you keep going.
She believe I bet.
Well, no, because you know that there were not a lot of people coming up speaking good things about you before.
Well,
So
that's-
you must have changed something.
Well, yeah. Yes, I
Man,
did.
180, so she's doing really, really well.
Why you stick your tongue out at really?
So there.
Really? So there?
Yeah, I'm sorry. I couldn't help it. You bring out the worst in me. What do you?
What? Whoa! 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 What?
I don't know. Miss Teresa, what is going on here? What?
How did I bring out the worst in
I'm
you?
just kidding. Just listen. Okay, what are we gonna do here?
I bring out the worst in you.
No, you don't.
I think they're doing a great job, honestly. I don't even need to be here.
Yeah.
I will add though, Ms. Johnson is on a fixed income. She gets a social security disability, is that right?
Yes, it is.
And she did do 92 days on this case.
Oh, I know. I know.
Yeah.
And it was not because I wanted to get, she just,
I kept on till I just had to do it, huh?
huh?
I just had to be here with you, huh?
You just would not do anything I asked you to do.
That's true.
You decided, I'd say do something this way. You decided you were gonna do something else.
You said right. You
And
I
then
know.
finally it just came down and like,
And I had no qualms with that, and you know it.
well, at the time you did.
Well, no, I didn't actually. I did what I needed to do and came on up out of there. It wasn't your fault, so I.
Oh,
kinda
I
like-
know it wasn't my
I
fault.
know, so why should I have any animosity or ill feelings against you? You're just doing your job.
Thank you.
You're welcome.
It was very nice of her to say. She was not like
As
this
if you could do
before.
any-
I don't know what's happened.
What is wrong with you? What do you
This is
mean?
not the person I remember.
You know what?
Miss
and that's
Valera,
saying- that is
Miss
not
Valera,
right.
is this the person you remember?
You know, Your Honor, I do have to say, I don't know what time, that Paula came around to me. Probably the second or third. She did really well.
Thank you, Mr.
She did get her act together per se and was compliant with me on a later case than that. And she did do probation. She checked in with me. She was in school then and she was doing really well when she ended there. I do have to say that.
See?
So everybody gonna stick up.
Oh, no.
It's about something.
You know what? You just
like
do
that.
not
It's
believe.
like a Paula festival.
You know, you're so wrong today.
What?
What did I do, T? What did I do? I've been doing really well here.
I would tell
Come
you,
on.
Judge, I would tell you if she was not doing what she was supposed to do, but she did. She did really well towards.
And you know she'd tell. She would tell you. Yes, she would.
Oh, I know she would.
There you go, see?
Because we had a lot of conversations like that, didn't we?
Yeah, we did. On many occasions.
But
Isn't it true? I don't have no qualms with it. You know, you're wrong. You have to own up to it. So that way you can move forward, correct? At least that's the way I see it.
You got all A's and B's?
I've got a C. I ain't gonna lie to you, okay? I'm working on it.
What do you have a C in?
What do I have a C in? I have a C in, what is it? Right now, all I have is, I have, my math class. It's been a while, so I'm working my way back up to the B, you know, but it's different, you know. I haven't had math in a long time, so. I'm just saying, I'm working on it though. I don't have a defeatist attitude. I am going to get my degree this time. Bam, bar none.
This person that I see now, I have no doubt in my mind that she will.
Yes, sir. I guarantee you. Lord willing, I'll come back and show it to you. I was looking forward to that one.
None of that I have to hold to. She already made a mistake. When is she gonna pay me my money?
You still,
You know, it's been nice chatting with you, but
I mean, I just don't have it. I'm honest with you. I don't.
so he's still here with you?
Yeah, I actually
In fact, they're
married
being
him.
quiet this time.
Yeah, I married
was
him.
jumping up and down last
maybe
time I
that's
threw
what
you
got
in.
him quiet, huh?
Huh?
I married him, so maybe that's what got him quiet.
Oh, y'all got married?
Yes, we did. What you look like that for?
I just,
You didn't think?
I thought he was gonna run at one point.
Now, you know, that's bad.
I'm just
So
saying.
bad.
I'm just saying, one day,
Oh, you
in
didn't
here,
think
he was
I
looking,
was gonna
he
run.
was
You
looking
thought
like,
he
he
was
was
gonna
like looking, winking at me like, take her so I can run.
run.
That's what I was getting from him. I'm just saying.
See, that's not the memo I got.
Well,
See,
I'm just saying,
I get it. I understand.
he and I were communicating.
Clearly.
And
Yeah.
so that's how I saw it.
I
I guess
that.
I was wrong.
I can see that. You know,
All right.
that's a guy thing. It's okay.
It is a pleasure seeing you. It is
Always
a
a pleasure
pleasure
seeing
to
you,
see that you are actually doing well and
Thank
doing the right thing.
Yes, sir. I'm doing my best.
So here's what I'm gonna do.
Yes, sir.
You already have paid the state fees, so I'm just gonna waive the entire balance.
Oh, God
I'm
bless
gonna
you. Thank
just
you.
get rid of everything. I'm doing that mainly because of, you know, if you have a daughter that will come up and say those great things about you, then I have to, and I believe what your daughter's saying.
Oh,
And
she's
so,
not gonna lie, trust me.
well, but that, in a
Just
lot
like
of
she'll
ways,
say good, she'll say bad. That's what
it's a lot of ways, that's what life's about. You raise kids, and when they can say good things about you,
Yes,
you've done your job.
it is. Thank
So
you.
here's what I'm gonna do on your promise, because
Yes, sir.
I would,
Oh, you got to worry.
so I'm
Trust.
gonna waive that entire balance
Okay.
on your promise that when you have that degree, you come back here and you show me that
You
degree,
think I'm not when I am? Oh, my God. I can't.
right? If you don't,
Okay.
Alan,
Well, okay,
if
I
you
tell you
don't
what.
come back and show me the degree and I find out that you got the degree, Alan and I are getting in the truck, we're gonna find you,
Oh, my God.
okay?
Not you and Alan.
Yeah, both of us,
Oh,
both of us.
okay.
All right, fair enough?
Well, Alan for sure.
I don't know what that's about. All right, you take care of yourself.
God bless you. Thank you so
welcome.
much, Justin.
Fella, you take care of yourself.
It's good to see you again. You do good. Yes, ma'am. Thank you so much, guys.
Glad to
God
see you.
bless you.
We'll see you again.
All right. Take care of yourself.
No sovereign citizens, right, Judge?
Yeah, it is. Yes, sir. Court calls the case, People versus Aaron Piccini.
CNA District Court for County of Washington, State of Michigan is now back in session. The honorable judge.
You may be seated. Court does call the case. Case of the People versus Jason Stevens.
First Assistant Public Defender Clint Anderson, with on behalf of Mr. Stevens, Your Honor, submitted a form he's requesting to have the Public Defender's Office appointed.
Okay, your name, sir?
Jason Stevens.
All right, and is that correct, sir? You're wishing? Yes. All right. All right, this is a public defender case. I have, yes, Ms. Valerico.
Your Honor, I was just going to state for the record that Mr. Stevens is before the court today for a violation of probation hearing. There is an alleged violation of the contact order dated April 25th, 2025. Probation did provide the court with this report for that incident.
I think we can approach before we begin.
Yes. And
And Your Honor, the victim, Kashmir Morley, is present should the court.
yes, well, I have the report. And I guess, Ms. Morley, if you could come forward to the podium, please. Can you state your name, please?
Kashmir Morley.
All right. Can I have her sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Kashmir Morley.
All right, Ms. Morley, the report that I have in front of me indicates that Mr. Stevens appeared at your place of work and waited in line to speak with you.
Those are two separate events, but that's correct.
What do you mean they're two separate events?
There was a workplace event where he showed up at my place of work, and then when he was waiting in line to come to me, it was to a networking event that I was putting together, that I was hosting.
Okay. So, well, now, I mean, I'm looking here and it just says Stevens appeared at Morley's place of work, waited in line to speak with you. When you refused to have contact with him, he waited around the venue for 10 more minutes before leaving. So now you're telling me, that sounds to me like that what they're describing to me is one event, but you're saying there are two. When was, okay, which one occurred first?
The workplace event. That was in March.
And where do you, the workplace event where he came to your place of work?
Where do I work?
Well, in March, you're saying he came to your place of work. Where do you work?
I put some hours in at the Ann Arbor Art Center.
Pardon?
The Ann Arbor Art Center.
Okay. So, and that was on March.
Probably would have been mid-March sometime.
And that's kind of where you would work every day?
Not every day, but I'm part-time there, so I'm there frequently.
Okay. In your mind, did he have a purpose for coming there? If he was there?
It was my understanding that there was, excuse me, I have allergies going on today. There was an exhibition, I think, that he was supposed to help out with. That's as far as I know. But the times that he showed up, there was nothing work pertaining going on, according to the people that I spoke with.
So where are you, he shows up there and then what does he do vis-a-vis you?
One of the people that I work with said that they saw him just wandering around the building, not really with a purpose, and nobody knew who he was or why he was there.
Okay, did he see you?
No,
Well,
I didn't see him. And I don't think he
did not see him.
Mm-mm. But I knew he was in the building because of email correspondences that were going on.
What email correspondence?
In the workplace, I'm on like an all staff email chain. And so I was told that he was going to come into the building for an exhibition.
So, and correct me if I'm wrong. So you're told via this email that he's coming into the building. And at least according to that work email, he was entering that place for some legitimate purpose.
The email said that he had showed up. Nobody knew who he was, but apparently he was putting on an exhibition. So they were talking about him coming randomly out of nowhere and saying that he was there for an exhibition. So they were discussing that. And then the email said that there was an exhibition to take place in March that apparently he was supposed to be a part of, but nobody knew who he was or why he was there. That was the email.
Okay. I guess if nobody knew who he was, did they know his name?
Well, I'm sure he's probably told them his name because they said his name in the email, but in the correspondence, they said they didn't know who he was at the time that he appeared.
Do you have copies of those emails?
Not with me, no.
Do you have access to copies of them?
I could probably get some, yeah.
And then the other event took place, what was that, May 5th?
That was April 25th.
April 25th was the second thing?
Mhm.
Okay, and where did that allegedly happen?
I was hosting a networking event at Venue by 4M in Ann Arbor. And he appeared and he stood in line and I was checking people in and he stood in line so that I could check him into an event that I was hosting and stood longer in line than he did at the actual event.
So you're hosting an event?
Mhm. Me and the crew of other people, but I was on the hosting committee.
So he comes there, or do you?
Mhm.
Would he, in going to the event, would there have been another way, assuming he's there, that he would have been able to access the event without checking in with you?
That was the only way, was to go through me. And I was an organizer on the event. So if you were paying attention to the event at all, my name was all over that. There was no way you couldn't have known that I was part of it.
Okay, but I could know that you're part of an event. Can go to an event, avoid you, but prior to coming to the event, would he have known that you were at the desk or wherever it needed to be checked in?
I don't know if he knows that or not, but he had at least 10 minutes waiting in line to get to me to turn around and leave the event. And he chose to come and approach me instead.
Okay, so when he approached you, what did he say?
He said good morning and tried to have me check him in. We have a no contact order, so I didn't speak to him. And the person next to me who was helping check people in then took over because she didn't know the situation and checked him into the event. And he stayed less than 10 minutes and left at a networking event.
Okay, so he comes to the event. So it's not a circumstance where you're the only one checking people in.
Correct.
There's somebody else there.
Sitting right next to me. Yep.
Okay, so he comes up, he says good morning. Is that the only thing he said to you?
He tried to have conversation at the desk and I
What do
didn't
you
have
mean
anything.
have conversation?
He checked himself in and then started talking about a hat that he was wearing and started trying to have conversation with me. And then when I didn't say anything, the woman next to me ushered him into the event and he wasn't signed up for this event either.
Well, did you have to be?
You were supposed to be, yes.
Okay, but did you have to be?
We were letting people in anyway, but that was not the intent. Because it was the first event that we were throwing.
So those are the two events.
Mhm.
So are you claiming that there are any other events that took place?
I'm here because of the April 25th event.
Okay. Are you claiming that there are any other events of contact? Okay. So in mid-March, after, let me, just so that I'm correct, mid-March, he never comes in eye shot of you, right?
That's correct.
All right, and so you don't see him.
Mhm.
The April event, it's basically a public event,
Mhm.
right? He's entering, and you're saying he said good morning. You didn't check him in. And then you're saying he tried to engage you in conversation, but that didn't happen.
No, with me, I mean, he spoke, but I didn't speak. And then the person next to me who was helping me check people in took him into the event.
Okay, after that event, or right at that point, did you contact the police at that point?
No, because I was there checking people in, and it was also our first event, and I didn't really feel comfortable having the police come to this event right when we were starting to host things, so I didn't know what to do.
Okay, so when did you contact the police about this?
I believe it was the following week. It might have been the week after. I can't remember the exact date. But I was speaking to the probation officer and she told me to file a police report, which is what I did.
Okay, but here's what I'm indicating, or trying to figure out. This occurs April 25th, which would have been a Friday,
Mhm.
right? Approximately what time?
The event ran from 8:30 to 9:45. So I think probably around 8:45, 9 o'clock is when he showed up.
All right. And so, and the event ran how long that day?
Until 9:30
Till 9:30 PM?
AM.
AM. So from 8:30 to 9:30 was the event. It's basically an hour.
Mhm.
Okay.
There might have been 9:45, 9:30, 9:45-ish is when it.
Okay, that's fine. So it didn't go all day.
Correct.
And then so when did you then contact the police about this?
It was either the following week or the week after. I can't remember the exact date.
Would May 7th?
I'm not sure of the exact date, sir.
Have you read the police report on this?
No, I have not.
Jordan, would you like me to give her my copy?
Yeah, if you could, I'd just like her to read the victim statement.
Okay.
Is that statement correct?
No, this is not correct. This is jumbling the events together, and it's also not what happened.
I'm just talking about the victim statement.
Mhm.
How is it jumbling the events together?
It says that this is the second time that he tried to speak to me. He just tried to speak to me when he came into the event. There wasn't like a time he came back to talk to me. And also placing a hat on so that no one would recognize him. That's not how that occurred.
Okay, so how big was this event?
There was probably 100 people there.
Okay, so he went into the event, he didn't stay long and then left.
He waited longer in line to check in than he did at the event. Than he was at the event.
Okay, it's the second time you said that. So what am I supposed to take from that?
That he waited in line longer to get to me than he actually stayed at the event. If he was there for work, for networking, I don't know why you would say there to network.
How many of these events have you done, say, this year?
This was the first one we had this past April.
Okay. How often are you at your part-time job?
20 hours a week.
Okay. So other than this March date, I'm just talking this year at this point. Has he come into your work?
Not that I know of. I have not seen him.
Okay. And then after July of 2024, were you also participating in events?
I was not hosting them, but I was going to networking events. Yes.
So you did, so this is the first event you hosted.
Correct.
Full encounter between you and him on April 25th, is phrase it. How long was that encounter?
Him speaking to me?
Yeah, I'm talking.
Probably like 3 to 5 minutes.
Okay, anything else you want to tell me?
No, I think that's it.
Okay, and I guess not that I've made a finding, what do you want the court to do?
Something so this doesn't keep happening. I'm sick of being contacted by him.
Okay, so ma'am, you've only told me of one incident.
This is at least the third time I've called the Ann Arbor precinct about no contact violations.
But
Your Honor, I believe that she's referencing the two others that was well on that.
that were from, that I've already addressed because he was sentenced after.
Correct. That's what I believe, and I'm, okay.
You're correct.
That it was a December 8th and January 5th.
All throughout the time.
December 8th of 2023. And a January 5th of 2024.
The time period between December and then July, there were emails, there were letter he left in my mailbox. There was dozen times.
Right, I recall all that, ma'am, but the reason I'm using the July date is because that's when he was sentenced, right? And you're saying that so between July and this July of 2024 and the April date, has he been in contact with you?
He drives by my house all the time and says he's going to his rental unit.
One thing I remember about this case is I think he has a rental property in the same neighborhood that you're in.
I
We had
would like to know the
with
address of that, but yes,
What?
I'd like to know the address to it, but yes, that's what he's claimed.
Well, I don't think that was ever disputed at the time of sentencing, that he has a rental property up that way. And that he would go to we had a whole discussion about it.
Does he need to park in front of my house to get to his rental unit?
It's like right there. I mean,
If it's on the same street, it doesn't mean he needs to park in front of my house to get there.
So how many times are you saying that happened?
Countless times.
When that happens, does he engage you in any way? Does he heads off someplace else?
No, he sits in his car. He doesn't head anywhere else.
So when that happens, did you call the police?
Yes.
When?
I called the police as early as this week when that happened. Like Monday.
Hold on.
And they told me there's nothing that they could do about it because it's a public street.
So what day did you call the police about this?
About the April event?
No, about April event, you didn't contact him till May 5th. But about him being out in front of your house.
Monday.
This past Monday? And what did they do? They did nothing?
He told me there's nothing that he could do because he had left by the time that they got there. And then he said it was a public street. So even though I had photos, it didn't matter. That's what he told me.
Did you show the officer the photos?
No, he didn't want to see them. He said it didn't matter.
What time did you call there on Monday?
6 o'clock.
6 p.m.? So other than that, when you call the police, have you contacted, you're saying, you're using phraseology like all the time and those kinds of things. And I'm trying to figure out where you're saying he's in front of your house. Other than this past Monday, right? Have you called the police about him being there?
Yes.
On how many occasions?
Probably between 5 and 10 at this point. I don't know how many like actual case numbers I have or whatever that's called,
Do you have
but
the case numbers?
not on me, no.
Do you have the request for service numbers?
Not on me, no. But I have the card from Monday, not with me, but I do have that number.
You have a rental property in the neighborhood, right? Is that correct, sir?
Yes.
Okay, and it's, as I'm recalling, it's adjacent in a sense to where she resides. It's like right in that same area.
You like me to answer?
Yeah,
Yes, from the end of the driveway, her apartment would be visible. When she says
I recall that. I was trying to make sure I was recalling that part of it correctly. All right. Okay, and so ma'am, I was at the point, what do you want me to do?
Something. I'm tired of him contacting me. He could have gone to any other networking event. He didn't have to go to one that I was putting on. And if he was actually there for work, then he should have been networking instead of just leaving 5 minutes after checking in. But he stood in line to see me and contact me, and there's a witness to that.
Why he stood in line, do you?
Why did he leave 5 minutes after then if he was there for work? And I have a witness to the whole thing.
Pardon?
I have a witness to the whole thing.
Who's your witness?
The person that was sitting next to me.
And who is that?
What's her name?
Yes.
Her name is Aylin Walters.
She available?
Not today,
How do you know?
because I asked her.
When would she be available?
I don't know.
Do you have contact information for this Miss Walters that you could share with Miss Polera?
I do.
All right. Okay, anything else you want to tell me? All right, thank you. All right, sir. And I know you're represented by, no, you're okay, come on.
You need your glasses, Mr. Stevens.
I think I know what's on, yeah.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Jason Stevens.
Stevens. And if at any point you're uncomfortable answering any of the questions the court has, then you've got counsel here. Do you recall being in the, I guess, Ann Arbor Art Center in March?
Yes.
Why? Why were you there?
I have with me the contract signed for my company to install an exhibition there in March.
Can I see that?
It also includes a timeline on the front page and correspondence with Ms. Morley's employer about the exhibition.
Hold on. So you were supposed to be there regarding an event. There's a contract regarding the event.
That is correct.
That's why you were there in March.
Yes.
All right. And then, well, let me ask you in March, did you see her at all?
I was not aware she worked there until her employer called and told me.
When did that happen?
The week before installation was supposed to happen.
She said she worked there. You were told that she worked there.
Yes.
were you told? Well, how'd that conversation go? Why, well, let me ask you this. Why did their employer then tell you that?
Apparently, Ms. Morley told her employer, the director of the Ann Arbor Art Center, that she had a restraining order against me and that I wasn't allowed into her place of work. Her employer, knowing that I was there to install an exhibition, called me in a bit of a panic, and we talked about it on the Friday before installation.
Okay, and what between the employer and yourself, what, when you say you talked about it, what was worked out regarding that?
The fact that, well, the employer asked that I not come into the building.
Okay.
Of course, that created a difficult situation because I had a responsibility in the building and an exhibition that was opening a week later. So we had to work out how that work would actually get done without me being able to be in the building. My coworkers did not want to go after they learned about this, so we had to find a surrogate to do that work. We ended up working through other people. I worked remotely. I did not go into the building, despite this being a physical job, but it all came off okay, so.
Well, hold on a second. Were you in the building in March then?
Before that phone call, I was going in and meeting with people to talk about the logistics.
That's what I'm trying to clear up.
Yeah.
The mid-March point, you heard the testimony was Morley. Had you been told at that point that she worked there?
No.
Okay, that's what I was trying to figure out. I wanted to make sure I had my timing right. So then you're told that, well, her employer or the director of the building calls you, tells you that. And even though you had contracted to do this installation, right? Did you enter the building after that?
Nope. Have not been back since.
Got it. Okay. And then what happened? Do you recall April 25th event?
Oh, yeah.
Go ahead. What do you want to tell me about that? Did you go, I think it was on South Industrial or something?
Place called Venue.
Yeah.
Used to be a grocery store, I think. I was on a podcast with a fellow. I met the fellow and learned that he was speaking at this event, a new professional networking event that was being hosted at Venue. I decided I would go check it out. Saw another colleague earlier in the week. She said she was going. I said, cool, I'll meet you there. Went to that event at 8:30. I was actually there right at 8:30. When I walked in, I saw that Kashmir Morley was checking people in, but she was one of two people. I stepped aside, waited for the other woman's line to empty. I went up to her, I checked in. She complimented my hat.
Who did?
The woman that I checked in with. Apparently her name is Alin Walters.
Okay.
She complimented my hat. I said, thank you, I made it myself. And then I went into another room where the actual event was taking place, grabbed a glass of water, went into that room, saw the friend that I had agreed to meet there, saw another couple of people. And I did leave before the event started, before Hein actually began talking. I left through a side door because I didn't want to be in the same room as Ms. Morley. And that was it.
So you didn't, I guess it would have been the front is where you came in.
Yeah, right by the front.
You didn't leave out the front.
Nope.
So what you're telling me is the reason you left is because she was there and that at some point, and correct me if I'm wrong on this, at some point, given that she was part of that event, she was going to be in that same room as you. And you were trying to avoid that.
Yes, I would say generally her presence was making me uncomfortable.
Okay.
I should add, I don't see her name on anything related to the event. She said she was hosting it, but that's not clear.
Do you have that with you?
So that I can explain. I added a page that's the podcast we were on. The next page is the LinkedIn post where I learned about the event. Her name is nowhere in that post. There's another internet article about the event. Her name is nowhere in that article. So.
But the reality is, you're not learning about this event from the internet or anything like that. You learn about it from somebody that you did a podcast with.
Yeah. Yeah. He was
basically verbally learn about it.
Yeah. And then I saw it on LinkedIn.
Got it. Okay. And when you saw it on LinkedIn, her name is not here. Is that what you're telling me?
That's correct.
So prior to your arrival, you didn't know she would be there.
No idea.
Anything else you want to tell me about this?
Not really.
On this one. Thank you.
Or anything else? I have no other violations or anything.
Your Honor, Ms. Morley indicates that the LinkedIn posts indicate her name on the notice. On LinkedIn.
Yeah, and on the events page, my name is listed as an organizer.
Okay, I got a question. Why do you think he was trying to get to you?
Because he's been trying to do this the whole time he's been doing this. That was why he left a letter, that's why he emailed me, he's trying to contact me, that's why it shows he.
Ma'am, hold on, I just asked you. What other contact has occurred with the credit here between June or July? Just make sure I get my notes right. Between July 8th of 2024 to present. Any direct contact that he's had?
I don't understand how many times I have to be contacted in order for it to matter.
You need to answer get up to the podium. You need to answer my question. You keep saying it keeps happening. You keep using these large phrases, but never giving me any specifics. So what I'm trying to figure out is how many other times from the time that he was sentenced, that's the date I'm using, up to say March or even April, how many times has he contacted you?
This has been the first direct time he's contacted me since July.
Okay, so then my question is, from that date you didn't see him, but heard about him in the building at work in March, did he appear in the building after that at your work?
After what date?
You said it was sometime in mid-March that you heard he was in the building. Did that occur again?
I don't know, not that I saw.
So I'm to understand that between the time I sentenced him and this day, or the April 25th date, there's been no contact.
Okay. Yes.
And on that date, at least as I see it, we can at least agree that he entered. You're saying it was because of your actions. He's saying it's because of his actions. But regardless of that, you were not the person that checked him in. Somebody else, as Miss Walters, checked him in.
He tried to get me to check him in, and when I did
How did you
contact him,
know?
because he walked up to me and said good morning to me and looked at me and said good morning and tried to have me check him into an event that I was hosting. That's how I know. He didn't look at Miss Walters, he looked at me.
And the other thing that we can, well, you're not agreeing to that, but the other thing that we can agree, he did go off and the event was taking place in another room. And then, at least as I listened to both of you, he left shortly thereafter.
That's correct.
He didn't, would you agree, didn't come back out the front where you were? He somehow or another left the event.
Yes.
And your thought is, well, what is your thought about why he left the event?
I don't know why he left if he was there for work, there to network. Doesn't make any sense to me.
Okay, so your belief is that he came to the event to see you,
Yes.
saw you, went into the event that, by your understanding of this, he really had no intention really to be at, because his sole intention was to see you.
I think his intention was to show up and show me that he can be around me no matter what, because nothing is getting done about this. That's what I think his intention was.
Where do you get that from?
The fact that he stood in line longer to see me, to get me to check him in than he was at the event. That's what makes me feel that way.
All right, thank you. Ms. Anderson, anything you want to say on behalf of your client at this point?
Your Honor, I haven't heard anything that gives rise to any direct or indirect contact. She's referenced the events, two separate events, the March 2025 event. Doesn't appear that she even knew that he was in the building. I don't see anything that gives rise to any contact. She didn't see him, he didn't speak directly with him, and my client has presented information that he was there for work purposes. Once he found out that she was there, he found ways to work remotely, which would indicate to me at least, that he was trying to comply with the court's orders with regards to that. The April event, again, he's there for networking. I mean, it's almost in that situation a lose-lose for Mr. Stevens. She's complaining that he stayed only 10 minutes, and if he had stayed the full event, that also would have been a problem. Your Honor, I don't see anything that gives rise to any violation of probation, and I would ask the court to dismiss this.
I'm gonna step out for a moment. Miss Valera, can you call AAPD and ask them
Yes, I will.
about requests for service from Monday and those before?
Yes.
And what, yeah,
I will.
can you? If they can get us a list, and guys, give me about 15 minutes and let her do that. And you got the contact information from Mr. Walters, Ms. Valera?
I will get it from her.
Okay, and can you see if you can reach out to her too? I know I'm giving you a lot.
That's okay.
All right, and then we'll reconvene. I'll come back on short. Thank you. Court's in standing recess.
All right.
Nobody else. No, you're okay. Don't worry. Ms. Anderson, we're close. And I need, oh, she talking to Teresa. Together. Yeah, that may, okay. Yes, please. Okay. Watch yourself with that microphone as you're talking. No, you're okay, but you got a hot mic in front. You want to see?
We'll do it.
We're back on the record in the case of the People versus Jason Stevens. He's present with counsel and so is Morley present. The court took a brief recess and I asked for Miss Polera to check a couple things for me, Miss Polera.
Yeah, sure, and I do have that information for the court. As far as reaching the witness, Ms. Alders, I did leave a message, there was no answer, so I wasn't able to get through with her. As for the calls for service to Ann Arbor PD, they had 3 that they were able to provide. One was on May 5th, which is the probation violation report from today's hearing. There was one from May 12th, this past Monday. They indicated there was no report, just notes for that call of service. There was notes say, saw the defendant drive by one time, no violation because he owns property down the street. They had nothing other than that since July of 2024 with a call for service, no report, notes were possible harassment, no action taken. Probation also wants
just, and so we can clarify, the July date would have been right around when he was sentenced.
Correct.
Okay.
Correct. And probation also wants to make the court aware, Mr. Stevens did report to probation the incident that happened in early March, where he was in the building doing work. He reported that to my office, indicating the same that he testified today, just so the court is aware.
That he was in the building, then informed later that she worked there.
Correct. And so he wanted that known and reported. So Mr. Stevens did report that to my office.
Okay. Court's ready to rule. And I'm just gonna maybe be painfully blunt regarding this. I, because of my docket, have numerous people reporting incidents of contact, incidents of harassment, incidents of those kinds of things, and have to try to deal with them and sort them out. sometimes it turns on the little things as to what transpired, because I'm not there. But other times it's real clear that somebody has had contact. Other times, it also is clear in the opposite direction that there was no intended contact. Some contact may have been incidental, or very short-lived. As I listen to the parties in this case, I'll just say this. Ma'am, I don't know why you have this belief that Mr. Stevens is spending his life trying to be near you. I don't think that's the case at all. Certainly not by any of what I've been shown today. And quite frankly, you've lied to this court. Yes, ma'am, you have. I don't want you shaking your head because you're playing with the wrong judge. You are playing with the wrong judge. I am dealing with people's liberty, with their freedom. And it is with sometimes a heavy heart that I have to restrict people's freedom, or I have to take somebody's freedom and their liberty. And I don't want to do it where I don't have to. I particularly don't want to do it where somebody comes before the court complaining of something that is just so unbelievable and at times twisted as to what's going on. Mr. Stevens, quite frankly, if he were not one to want to tell me the truth about what happened, the very fact, and I'll just deal with the March date, the very fact you never see him, but somebody says he's there, he could have gotten up before me, he could have said, I was never in that building. And just say that. There's not going to be anybody that's going to show that he's in that building necessarily. He'll just say, I wasn't there. He doesn't do that. And in fact, gets before this court, explains the entire circumstance of when he's in the building, then does the right thing once he's informed that you work there. He does two things right. One is he doesn't go back to the building and has to logistically try to figure out a way to fulfill his obligations under his contract. But he does that because of this court's order. He purposely doesn't violate that. He doesn't try to use the contract as some excuse to then go back into the building saying, well, I had to go there and I was just going to work. He doesn't do any of that. He just stays away. That's the first thing that he did that was right. The second thing that he did that was correct in that regard is that when it came time for him to report to probation, understanding he had had no police contact regarding that event, nothing really comes out of it, but he reports it to his probation officer that this transpired and that this is what I had to do. I've read that report that he submitted. It is almost verbatim what he told me today, not knowing that today was going to even manifest itself in this. He already reported that that's what happened and that this is what then actions he took to make sure he wasn't there. So your indication, and it's just misguided that it is that he came there looking for you, is just wrong. It just simply is wrong. He was not looking for you. He was just trying to do his job or do his work, found out he couldn't because you were there, and then stayed away and had to figure out some other way to do it. Then we get to the April 25th date. The April 25th date, I guess the only thing I can say regarding Mr. Stevens' behavior is I wish he had done something different. And that is that upon getting to the door, seeing you, I wish he had turned around and walked back out. I don't know, quite frankly, that would have prevented us from being here, but certainly I would have wished that he did. But I understand what he did do. And what he did, and this is again identical to what he indicated to probation, but he also said it to this court today under oath. He goes in, you don't check him in. I believe him when he says, I stepped to the side to wait for the other one, because I think you have some fixation on him or his, or what he's thinking. And you can keep shaking your head all you want, because I can go all day. Because I think there's something wrong in this whole thing. I believe him that he stepped to the side, checked in. You then take some and make some nefarious argument about him coming there to see you. Why? Because he didn't stay for the whole event. Well, he didn't stay for the whole event, as he reported to probation. And the other thing is that he went in, gave his greetings and goodbyes basically to the people that he was supposed to meet there, and then left. And then made the conscious decision, because you were there, not to go back out the way I came in. He just left out a side door and said, I'm out. As I said, the only thing I wish he had done, but again, I don't know that would have prevented us from being here, is to just at the front door have turned around and left. But I get why he didn't, because he had told people that he was going to be there. He was just going to go in, do this, get out. He wasn't going to stay there. I believe him when he says, I was going to be uncomfortable if she was in that same event. And he got himself out. That is consistent, quite frankly, in a lot of ways, with what he did in March. There's absolutely no, this court sees it, no violation that this court could take any action. But then when I look at it, you kept saying, and I was cautioning you on this one, ma'am, or you were addressing the court, that you keep saying these sort of grand statements about him, that it's always, I want this to stop, I want whatever. And I'm saying, well, what other events have there been? And I specifically recall us dealing with his rental property and the fact of its location vis-a-vis where you live. I remember looking at a map, because somebody telling me where it can be seen and where he goes up. And you knew he had rental property there, and then had the nerve to say to me today, well, I want the address because I'm not. We went through that whole thing in July in excruciating detail. You know he has it there. And how do I also know that you know he has it there? The Monday call to the police, which, by the way, is really suspicious, because I don't have any calls for service except at the time of his sentencing, just this general harassment thing, which they didn't take any action on. And then Monday. Here's the interesting thing about Monday. That call comes into the Ann Arbor Police Department at 6 p.m. on the same date that my staff set this hearing. We set the hearing at approximately a little after 12 that day, but via email to Ms. Blair. By 6 o'clock, I then all of a sudden have some complaint against this gentleman with the Ann Arbor Police, as though you had to sort of bolster some issue against him. Then you exaggerated, if not perjured yourself under oath before this court when I'm asking, how many calls have you made? Well, here's the thing you may not realize. Any police department you call will have detailed notes of what they did in their response to service, which is when you said how many times you had called, I asked Ms. Polaire to check that out. There's only 3. Since the time of sentencing, there's only 2. One being your report of this April 25th date, which didn't happen until the 5th. And then a week later, another call to the Ann Arbor Police Department, frankly, in response to this court setting a hearing and trying to drive and make a case against this gentleman. You lied to me. Just out and out lied. You haven't been calling the police. You haven't been doing any of that. And quite frankly, because there are serious cases of victims that come before this court that are harassed by people, they may not get the facts right. They may not understand certain things, but they will tell the court from their perspective what happened. But one thing I've never found, while I may not quite, they might have the facts a little off, I've never found just a blatant lie like this, ever. Saying that somebody has harassing you to such a point that, yes, I've had to call the police this many times. You haven't called the police. He wasn't there at that April 25th incident to see you. He was there to go to that event. Your weird belief that somehow or another his reason for going there was because he saw your name and decided to just gallivant down there, let me see if she's there. Seriously? I am not finding a violation. And young lady, I'm going to tell you, and I just have to think about it, but I may end up sanctioning you for lying to this court. If you got something real to bring this about somebody, I don't mind you coming here. But we've been sitting here for the last almost an hour and 45 minutes trying to deal with this. All of this being mistruths and just lies about him. So while you may try to turn him into something evil, you may think he's the proverbial devil in terms of who he is. This court does not view him this way. He has been a model probationer. He has done everything. He's gone way beyond what most probationers do in reporting things that weren't crimes, but certainly something that he thought probation should know of. And the great thing about him doing that, certainly it saved him today, just by putting it out there. So the court's going to find no violation. I'm done with this. And if there's something else that comes up, then we'll deal with it. Thank you.
Thank you, Your Honor.
Yes.
Every day in the USA, people find themselves in court.
Enter a not guilty plea after I arraign you and let you talk to the prosecutor. Okay, we'll give you a lawyer, go out in the hall and just be patient. They'll be with you momentarily.
Thank you.
Paula Pitts, Paula Simone Pitts, 24B146982 A and B.
Thank you, Judge, and good morning. For the record, Your Honor, House Counsel, Attorney Mike Bolden, P65417, on behalf of Ms. Fitz. Ms., can you just please state your full legal name for the record?
Paula Simone Fitz.
Judge, according to this docket, we're on a show cause for the expired plate civil infraction. I do believe that she is not in default under the driving while license suspended, and reportedly is going to start making payments on that.
She's in default on the expired plate.
Yes.
We've never resolved the misdemeanor, which I'm gonna send you to them today.
Okay, I wasn't aware of that, Judge.
She showed up November 20 of 24, she was arraigned. They asked for an adjournment, I adjourned it to December 4th. They asked for another adjournment, I adjourned it to the 18th. She didn't show up on December 18th. We rescheduled the show. We rescheduled the show cause for January 15th. She didn't show up then.
Your Honor, what I can do is.
Hang on a second.
Yes,
You
Judge.
stand mute. Does she stand mute, wait formal reading?
On the DWLS, yes, Judge.
Where you been, ma'am?
I didn't have a car to get here.
That means you may not have a car next time. That means I should have to set a cash bond, so we'll give you a ride. The police back there can give you a ride. Don't play with me. I didn't have a ride. You live in Taylor. You know what I'd do if I didn't have a ride? And I'm serious. If I got a seatbelt ticket and I needed to be there, I'd walk to Taylor. Don't play games with me. You have some money with you?
No.
You better. What made you come in here today out of curiosity? You haven't been here in months. What made you come in today?
Because I had a warrant for my arrest.
We've had a warrant for your arrest for a long time.
I got paper in the mail, so I decided to show up.
I decided to show up.
I'll go take care of the DWLS. We'll come back and we'll recall the case if that please the court, Your Honor.
You don't endear yourself to judges when you pull this nonsense, Ms. Pitt. Do you understand?
Mrs. Fitz, Your Honor.
Fitz, I'm sorry, I mispronounced it. My apology. You still, Ms. Fitz, do not endear yourself to judges when you do this. Do you understand that?
Yes, Your Honor.
I'll go take care of it.
$500 personal bond, ma'am, you miss again, you better bring a lot of money with you. You cannot leave the state without consent or violate a law. You must appear in court as directed. You go talk to them, and then I'll work with her on this one, Mr. Bolton. If you resolve the initial one, I'll work with her on a payment plan on that,
All right, we
okay?
have that worked out.
Thank you.
Yes.
Abigail Gideon, 25W83533.
I need the Fitz file.
Who? Yeah, I do.
It's not on the docket.
I know, but I'm gonna talk to him about something that's sobriety court, so somebody needs to get the file for me. Ma'am, your name?
Abigail Gideon.
You're charged with drive while unlicensed. I'll be glad to give you a lawyer if you want one. Do you want a lawyer?
No, I'm just gonna plead guilty.
Well, don't do that. Don't rush into it. It is alleged that you did to pay the extra $375 on the allowing an unlicensed driver to drive. You don't have the money? Call the court, we'll go on Zoom or come in here on it before the due date. Just don't ignore me. I hate that, okay? Good luck. Thank you. People against Paula Simone Pitts. Or Pitts, I'm sorry. I have to keep.
It looks like
4B146982 A and B.
It does look like it's typed as a T on the file.
Counsel, if this isn't resolved in it, I'm setting it for trial.
I understand, Judge, thank you. For the record, House Counsel, on behalf of Ms.
Your name?
Can you just state
Your name?
Call Simone Fitz.
So, Judge.
And I apologize. He's right. It looks like a P, and I apologize to you. It really does. So at any rate, what are we doing here?
Thank you, Judge. So we have a payment resolution worked out on the.
I'm not worried about that. I want to resolve the misdemeanor.
So what we need to find out is in 2015, she had a controlled substance matter that was not affiliated with driving as far as we can tell. And the prosecutor and I both feel that it would be.
Her license is expired.
Correct, and I think it's because that 2015 has not been resolved because that suspension entered because there was a controlled substance adjudication of some sort, which triggered an abstract to the Secretary of State during that era when Secretary of State would suspend a license on a drug possession case, regardless of driving. What we're asking the court to do is to allow a brief adjournment so that.
She's already had adjournments. I mean, I don't want to, I'm sorry. I'm not going to do that. I'll set it for jury trial. I'll set it for bench trial.
That's fine, and then we.
But it's been going on since October, and
I
she's had
understand.
multiple court appearances, and then she didn't show up a couple times. I'll be happy to do whatever you want, if you want to set it for jury or bench.
Can we set it for a bench with a final pretrial, Your Honor?
I'm not putting it out that long. I'm telling you right now, it's been going on too long.
I want my client to go to the Secretary of State and pull a tab and ask questions about what she needs to do to make sure that she gets her driving privileges, her clearances, so that we know how to address the ticket. Even if we just get a week, I just want her to go to Secretary.
Well, I don't have a problem with that. I mean, but let's, if there's gonna be a waiver, let's do the waiver. I'll work out a payment plan with her on the expired plate.
And we'll do a bench waiver.
If that's what you guys wanna do,
And then, okay, let's do it that way.
I don't have a, look,
You want to keep it on the docket and keep it.
correct. And I'll set up a payment plan with her on the expired plate.
Okay.
I don't have a problem with that.
Okay, and then, we have a resolution on that, she would like to make.
Well, we'll talk about that when you
That's in
figure out what you're doing with the other
Yes,
one,
Judge,
okay?
yes, okay, thanks,
All right,
I'll
thanks.
go take care of that. Yes. Oh, wait, there also.
He wants an attorney.
I got it.
Thank you.
Yeah.
Where's Mr. Caressi's file? Was that your lawyer, the gentleman that was just in front of me?
No, Mr. Crawford.
Okay.
Attorney Crawford.
Paula Fitz, 4B146.
Good morning, Your Honor.
982A, well, I went on to another case now. 982A. And, B. Counsel, your appearance.
House Counsel Attorney Mike Dolan, PC 5417 on behalf of Ms. Fitz.
Ma'am, your name?
Paula Fitz.
All right, so she's gonna execute this waiver. The prosecutor executed the waiver. We're gonna go to a waiver bench trial, right?
Correct.
Is that what you want to do, ma'am?
Yeah, she does, Judge.
You have a constitutional right to a jury trial. By waiving your right to an exam, that means you're waiving the requirement that you're waiving your right to a jury where 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt. In order for you to be convicted, I will be the one who will solely decide your guilt or innocence. Do you understand that? Ma'am,
Yes,
you still wish to give up your right to a trial by jury?
yes,
Anybody force you to do that?
no,
And that's your signature on this document?
yes.
I'll accept the waiver. We'll set it for a bench trial.
Judge, can we push this out a little bit? We're going to send her to Secretary of State, see if she can get a resolution to her driving privileges short of coming back, and I trust we're gonna have this matter resolved. And, do you?
Hang on
wanna
one
handle-
second. Hang on
Sure.
one second. Lisa, why don't you give me a date about 4 weeks, 3-4 weeks out for the bench, and we'll have a final pretrial in 2 weeks.
Final pretrial June 2nd at 1:45. Bench
Okay.
trial June 18th at 1 o'clock.
Okay, Judge.
Wait a minute. June 2nd.
At what time is that?
You're not here on June 4th, you're Brown's.
Oh, I see, okay. June 2nd, I got it. June 2nd at 1:45 will be the final pretrial, and then June 18th will be the bench trial, and that'll be at what time?
For which date?
June 18th? You said the
1
bench?
o'clock.
1 o'clock.
Yes, Your Honor, I will be the arraignment attorney on June 2nd.
All right,
And I will not be a docket attorney, but if the court wants me to step out of that role and assist Ms. Fitz on that day.
yeah, you can talk to,
I will continue
Please about
working
that.
with Ms. Fitz and stay with her.
let's talk about the B file. How much does she have today?
Yes, thank you, Judge. Here's what we worked out.
Okay,
$71 each Thursday, starting tomorrow for 3 Thursdays in a row. And
okay, hang on one second. $71?
Yeah, I broke it down into 3. It's 200 and something, 35. So she'll pay, and she knows how to go online, 71 tomorrow, and then the next 2 Thursdays, 71 and 71.
All right, so she could pay 71 by May 15th, 71 by May 22nd, balance by May 29th,
Yes,
correct?
please.
You can do that, ma'am?
Yes, Your Honor.
If you don't have the money, all you have to do is call the court, we'll roll on Zoom, or you come in here on or before the due date. If you need an extension on one or all those days, I'll get it. Please don't ignore me again, okay?
Thank you,
Understand
Judge.
everything? Do you have any questions?
No, Judge,
Ma'am?
thank you.
I can't hear
No,
you.
Your Honor.
Okay, so you're gonna go down the hall and get your notice. Good luck.
Thank you, Judge.
Thank you. Let's do Horn first, Mr. Crawford. Nicholas J. Horn, 25T7042225FY. Mr. Horn, your name.
Nicholas Horn, Your Honor.
Mr. Crawford.
Good morning, Your Honor. Mike Hill Crawford, representing Mr. Horn.
All right, so what are we doing on this one?
Your Honor.
He's got 2 counts, by the way.
2 counts, Your Honor.
He's got an attempt to renewal, which is a 1 year, disorderly, a 90-day misdemeanor. So I filled out, I'll swear you in, and then you can go ahead and sign it once I authorize, all right?
Yes, Your Honor.
All right, have a great day. Thank you very much, Corporal.
086. 186.
It's a lot. Come on up here, Mr. Makunovich.
I highly apologize.
Derek Allen Makunovich, 24T642916. Your name again?
Derek Allen.
Well, why would you lie to me?
I didn't mind. I told you I drank last night. I didn't get to sleep.
If you drank, what time did you stop drinking?
I didn't get to sleep until
What time did you stop drinking?
about 10 o'clock.
All right, that was nearly 12 hours ago. Now, I just want to let you in on a secret. If you have an would you say 086?
086.
And that was 12 hours ago, you can add about another 1.18. So you're somewhere around 2.6 when you went to sleep. I'm just telling you.
Yeah, I drank quick.
Looking to chastise you here. Ma'am, come on up here. Please.
Stand for the-
Your name?
Board comment?
I'm not gonna ask if he drove here. Do you have a valid license? Do you drive?
Yes,
You still drive?
yes,
I'm gonna assume you drove him.
yes.
All right. Now, this is problematic for me because I could lock him up right now, probably should. Under what authority? Nah, I don't really know if I have any, to be honest with you. I didn't order them not to consume alcohol. I'm not gonna make my own rules. But I have a concern here when I got somebody who's legally intoxicated. Bring the victim in. Just let me finish here. Your name, ma'am? Ma'am, what's your name, please? So I have concerns here. I can't go into it except to say that Mr. Makunovich has been drinking. He's still legally intoxicated as of this point. I'm going to set this for another hearing date. I'm not going to go on and deal with a case where somebody's intoxicated. But I'm really concerned, ma'am, just relax. Just relax. I'm talking about you, Mrs. What's your name again?
McConnell.
What's your first name?
Lori.
So I hope no alcohol is a condition of your bond.
No.
No illegal drugs. No marijuana. I'm not going to even arraign you right now. I'm just telling you, I'm gonna set this for a hearing, but I'm adding a bond condition. I suppose I could get you a lawyer, but I'm not locking you up, and I'm not gonna set a cash bond. But no alcohol, no controlled substances, no marijuana. You're to continue to comply with all terms and conditions of probation.
Yes.
Now, I worry about this. Ma'am, you're gonna drive home?
Yes.
I have your word on that.
Yes.
Because if I see him or I have a court officer tell me that he's driving out of the parking lot, I will call the police. Stop, Mr. Makunovich, stop. Do you work today?
I took off work today.
Is that true, ma'am?
Yes, he's not.
So you're not going out of the house, right?
I do all the driving.
Okay. So that's what I'm doing, and I'm rescheduling this. Now, Lisa, why don't you give me another date? I'll just make a note. Defendant appeared intoxicated. Court added bond condition of no alcohol or controlled substances. And again, it's not my practice to order no alcohol if it doesn't have anything to do with this incident. But in this case now, you've shown up here, you're drunk. You can tell me all you want.
May 22nd at 11.
May 22nd at 11. No alcohol, no marijuana, no controlled substances. But this is a big alarm, I hope, for you, sir. Because if you're showing up and you were drinking to the tune of a 2.6, the overwhelming majority of people would be vomiting long before that, okay? Or at least very ill, so that's what I'll do. Ma'am, is that date good with you? Sure, May 26th, you said, Lisa?
May 22nd.
Oh, I'm sorry.
What day is that?
That's a week from tomorrow, so that would be next Thursday.
Yeah.
At 8:30, Lisa?
11.
Oh, at 11. Okay? I have your word, you're driving.
Yes. I see. I do.
Okay. Do not go out and drive a motor vehicle, sir. Good luck. Thank you. Thanks, ma'am. Go down the hall. We're going to give you a notice too, and we're going to give you a notice, sir. Abigail Gideon. Abigail Nicole Gideon, 25W838533. Your name?
Abigail Nicole Video.
Sorry, I didn't realize you were back there still. My apology. Okay, come on up to the podium. Can you turn that podium toward me, please? There you go. Your name? Mr. Mahdi? Mr. Mahdi, you out there? Wendy K. Augustinus, 25W8378876. Where is Wendy K. Augustinus? Come on up.
Right to the podium, man.
Your name, ma'am?
Wendy K. Augustinus.
You're charged with violation of the parental responsibility law. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? Okay, so you're charged with failure to ensure the regular attendance of your son at Bates Elementary, April 4 of 25 at 1:56 p.m. So they're saying you, hang on. So they're saying over a period of time that you failed to send your child to school. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? All right, you still wish to waive your right to a lawyer? It's up to you. It's up to you. If you want to represent yourself, you can. If you don't, it's up to you. I can't. Wait a minute. Hang on. Slow down. Slow down. Just slow down. I can't go on this unless you tell me, Judge. Are you sure? All right, so I'm gonna enter a not guilty plea for you. I'm gonna give you a $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Defendant to ensure child attends school with no unexcused absences. Okay?
Yes.
We know how important it is to get through school. If we don't get through school, I don't know what we do. You know what I mean?
Yeah, there were a couple notes. He was there on days, it was like 4 days. They didn't give me a note from my other son. It was only like 3 or 4 days over the limit.
Well, there shouldn't do, kids should never miss school unless they're sick, right?
I know, we did get.
But the kids should never miss school unless they're sick, right? Just like adults should never miss work unless they're sick, right? Okay, you go talk to the prosecutor. If he doesn't give you what you want, you could come back in and tell me you want a lawyer, and I'll be happy to give you one, okay? All right, good luck. Makunovich, Eric Allen Makunovich, 24T642916. Good morning, Derek Allen Makunovich. So we have a problem. Who's this with you? My wife. You're charged with violations of probation. Who's Danielle Lawler?
My ex-fiance.
Okay. Hang on, slow down. So they left a note for me. I never like these notes. Smells of booze. Listen, they don't just come in and tell me that just to make up stories. If you want, I'll give you a PBT.
She does.
Listen to me.
I have.
Listen to me. She does what?
She has been trying to keep me out of my
Did you
daughter's
hear
life.
what I said?
What's that?
Did you hear what I said?
Yes.
We're not going on this case if you're under the influence.
I'm sure I'm not gonna.
Well, then let's get a PBT. We'll give it to you. And I'll see whether or not you're being truthful. Now, I want you to understand, while it's reprehensible to have somebody come to court that's intoxicated, there must not have been alcohol involved in this incident because just let me finish.
I wasn't,
You're starting to shake your head already.
no, I'm listening.
Okay. While it's repulsive for somebody to come to court intoxicated, I didn't order you not to drink. This incident of this MVOP must have had nothing to do with alcohol, or I would have ordered. So you don't need to get all uptight and start acting like I'm gonna lock you up. But I am not going on this case if you are at all intoxicated. Now, maybe a couple people just thought you smelled the booze and you weren't drinking. So you May 31, I'll still give you, okay?
Yes, sir.
If you need more time, because you don't have the last $35, call the court, we'll go on Zoom or come in here on or before the due date, they'll give you an extension. I wish you well.
Thank you.
Good
Do I
luck.
pay here?
Yeah, right down the end of the hall to the cashier. Shauna Lisette Johnson, 24T643302. How you doing, Ms. Johnson?
Okay, how are you?
Pretty good. Come on up here if you would, please. Your name?
Shauna Johnson?
All right, okay. You want a lawyer?
No.
You're charged with 2 violations of probation. You sure you don't want a lawyer?
Yes, Your Honor.
Okay. I mean, I'm right?
You're correct.
Okay. You're charged with failure to attend your scheduled probation visit on April 17 and again on April 24. You don't have any technical violations now. If you pled guilty, or if you plead guilty, you could get 10 days on this. Do you understand that? I don't want to make you panic. I just have to tell everybody the maximum sentences. That's the most I could give you. I have to tell you that. If you had an expired license, I'd have to tell you you could get 90 days. So I don't want you to lose, to panic here, okay? So do you understand what I said?
Yes, Your Honor.
All right, did you sign, read, and understand the advice of rights?
Yes, Your Honor.
You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right, now, do you still wish to waive your right to a lawyer?
Yes, Your Honor.
To the charge, you failed to attend your scheduled probation visit on April 17 of 25. How do you plead?
Guilty?
Did you fail to attend your probation visit on that day?
Yes.
Is the count 2 that you failed to attend your probation visit on April 24th? How do you plead?
Guilty?
Did you fail to attend on that day?
Yes.
Anybody force you to plead guilty?
No.
Okay, I'll accept your plea. I'm gonna get Ms. Tassino over here. I'm gonna go on to another case. And we're gonna call her and I'll be right back with you, okay?
Should I sit down?
Yes, and I'll be right with you, okay?
Okay.
And I want to take that one with you after this little speeding ticket. Is your case ready, sir, the interpreter?
Yes.
Good. Can you tell, which case is that? Is it Hernandez?
Yes.
Okay, I'll call that next.
Judge, Mr. Mahdi's ready also.
Yeah, I saw him. Maman Jamal Ahmed, 25W378665A and B. Good morning, counsel. How are you?
Good morning, Your Honor. How are you?
Good. Your appearance?
Zach Ahmad, on behalf of Mr. Ahmad.
All right, so you worked with the prosecutor. You're going to plead to 5 over on his behalf. And let's see, they're going to dismiss the no insurance, right?
Correct.
All right. And they're also going to dismiss the failure to yield, right?
Correct.
All right, to that charge of 5 over, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the failure to yield, dismiss the no insurance, fines cost $200, and I'll give him until the 21st to pay that, okay? And that's
Thank you, Your
on
Honor.
file A. Have a good day. Thank you.
Thank you.
People against Hernandez. Yormi, Miguel Hernandez Boulevard, 25W38353A and B. Do I have a lawyer here on this one? We don't, do we? Okay, your name? How are you? All right, and you are a certified interpreter in what language?
Spanish.
All right, raise your right hand. You solemnly swear or affirm under penalties of perjury that you'll make a true and accurate translation between the court and the parties.
I do.
All right, Mr. Hernandez, state your name, please.
Jordi Miguel Hernández Bolívar.
All right, good morning. You're charged with driving on a suspended. If you want, I will give you a lawyer to represent you. Do you want a lawyer?
No.
Okay, I'm sorry, ma'am. We'll get your case. I'm gonna ask you to take the child out in the hallway. We'll call you when your case is. You are charged with driving on a suspended. This allegedly occurred on West Road near Allen and Woodhaven, April 14 of 25 at 11:28 in the morning. That is a misdemeanor. It is punishable by up to 500 fines, 93 days jail. Court costs are all those in 2 points. You understand that? Did the interpreter read you, or did you read the advice of rights in Spanish here?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
No, porque lo que necesito es pagar la multa y la licencia la tengo suspendida por una multa que no deja el ticket.
Hang on a second. What's he saying?
No, Your Honor, I just would like to pay a ticket.
Okay.
My driver license is suspended because I didn't pay a ticket.
Okay, good enough. So I want to make sure of something. Tell him that. I do not know. I do not want to know whether it is, and tell him not to say anything. I want him to hear me out. I want to make sure he understands there could be, if he's not a legalized citizen, that there could be immigration consequences as a result of this plea. Do you understand that?
Yes.
Do you still wish to proceed without a lawyer? Okay, I am going to enter a not guilty plea. I'm going to give you a $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand all that?
Yes.
All right, I'm going to send you to the prosecutor with the interpreter. You can negotiate this with the city attorney, and then you'll come back in front of me. And by the way, you also have a civil infraction charge of no insurance. Do you understand that? Okay? Any questions?
No.
All right, good luck. Shauna Lizette Johnson, 242-643-302. Your name is Sino. Johnson pled guilty to both counts. Ms. Johnson, come on up to the podium again and tell me your name if you would, please.
Shauna Johnson.
All right, you still wish to proceed without a lawyer?
Yes.
Okay. How's she doing besides missing these appointments?
Otherwise, she's doing well. I was gonna talk to her. She needs to put the court on her release for her treatment, just so we get her attendance reports. But other than that, things are good.
Why did you miss twice, Shauna?
So when I'm at home, I really zone out, and days go by, I don't realize the amount of time. I talked to my mom, I'm gonna give, Ms. DeCino my mom's phone number and email, so my mom can,
She can't really talk direct to your mom. I'd really rather that you give the information to your mom, okay?
Okay.
So if she emails you, you can tell your mom, make sure that I get here, okay?
Okay.
You're doing your mental health treatment?
Yes, I met a really nice psychiatrist.
Good, good. Are you doing better?
Yes.
You seem better. Okay, I'll tell you what I'm gonna do. I'm gonna let this go. Okay? If you're progressing, and it sounds like you are, and she is, right?
I have to get the release, but it sounds like it, yeah, they were limited on what they could tell me.
Sign the release so we can get your records. I'm gonna let it go. I'm not gonna assess any costs. I'll simply, let's just get you in order where your mom can help you out here, okay? And she can get you to these appointments or remind you to get to these appointments.
Yes.
I'll keep you on probation, no fines, no costs. Sign the release and we'll go from there, all right?
Thank you, Your Honor.
Hey, keep doing what you're doing. You seem a lot better to me.
I feel better.
Okay, all right.
Thank you.
Smile. Can I see you smile?
Yeah,
All right,
thank
good luck. Thanks. People Against Augustinus. Wendy K. Augustinus. That's the one we need to get from the outside. If you want to call Will or what have you. All right, 96-50. All right. People Against Augustinus, Wendy K. Augustinus, 5W83776. Your name?
Wendy K. Augustinus.
All right, so counsel, your appearance on this.
Your Honor, Josh West appearing on behalf of the city of Woodhaven.
So we're just gonna plead her the municipal civil infraction under 96-50 with agreed upon fines and costs of $250, the two of you agreed upon, right?
Yes, Your Honor.
And then the misdemeanor will be dismissed, right?
Yes, Your Honor.
Is that what you want to do? You're all set. Thanks.
Yes, sir.
To that charge of violation of municipal civil infraction code section 96-50 of the Woodhaven Code of Ordinances, how do you plead? Responsible?
Yes.
Ma'am, I want to talk to you a second. Why isn't the child getting to school? How many times and I don't want you to mention any names. I don't want you to mention names. Hold your child and why isn't he getting to school?
He's 9.
Why isn't he getting to school?
He was sick, very sick. He has an inhaler now.
Was he in the hospital?
No,
How many times has he missed?
I believe it was 18, 3 over. I have notes.
To me, that's a bad thing to say to me, because to me, 3 absences is 3 too many unless they're sick.
I believed him also.
Pardon?
He was probably not as sick as he claimed to be.
We'll make sure, because you know what? Back when Abraham Lincoln was alive, I don't think they needed high school diplomas. We do now, or we don't have a chance. I mean, I don't know anybody that succeeds that doesn't have a high school diploma. So let's make sure he gets in school, okay? I'll accept the plea, fines cost $250. The original charge is dismissed, okay? Can you pay that now?
Yes, I can.
I wish you well. Good luck. Keep the child in school though, please. Thank you very much. Good luck to you, ma'am.
Thank you.
All right, where is, let's see here. Branch, Corey Wayne Branch, 25W838-565A and B. All right, good morning again, Mr. Baldwin.
And good morning to you as well, Judge. Attorney Mike Baldwin, House Counsel, 65417 on behalf of Mr. Branch, sir. State your legal name, please. Judge,
So he's gonna, does he stand mute, wait formal reading?
he does.
And then we're gonna have a plea here to allowing an unlicensed driver to drive and impeding traffic, and the no insurance will be dismissed, as well as the drive while licensed on, drive while unlicensed, right?
That is correct, Judge.
All right, so sir, if you plead to impeding, that's on count 2, the no insurance, that's 0 points. I'm gonna fine you. If you plead to allowing an unlicensed driver to drive, that's not getting reported. I'm dismissing the drive while unlicensed. The possible penalties on this charge are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right. To the charge allowing an unlicensed driver to drive, how do you plead? On April 27th of 25, were you in control of a 1997 Ford that was being operated on King, New Allen, and Woodhaven?
Yes, sir.
Did you allow somebody to drive that was unlicensed, and was that you? Are you licensed, you been licensed at all?
Judge, there's a reciprocity in Tennessee where my client has a lawyer working out something dealing with insurance suspension in Tennessee. And it appears that once that reciprocity issue is resolved, it appears he's clear for his driving.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
To the charge of impeding traffic, how do you plead? Responsible or not responsible?
Responsible.
I'll accept the plea to allowing the licensed driver to drive, accept the plea to impeding, dismiss the drive while unlicensed, and dismiss the no insurance. You ready, counsel, for sentence?
Yes, Judge.
Okay, what would you like to say?
Thank you, Judge. We all have our story to tell the court regarding our driving privileges. Mr. Branch, his mother's vehicle broke down. It was sitting on a road system for about 2 weeks, a dirt road. Mr. Branch went out, identified a brake line issue, thought he had it fixed. His objective was to drive it back to his mother's place, and in doing so, to test it out to make sure that it was in good mechanical order for his mother. He did lose brakes because it was not aligned. He did impede the flow of traffic by having to make a quick defensive maneuver, and lo and behold, there was a police officer right behind that saw it, and that's what triggered the stop. So I explained to Mr. Branch that today the prosecutor and the defense and the court are all working in conjunction to make sure that this is resolved so that he can get this driving issue taken care of out in Tennessee and get his driving privilege.
Yeah, you gotta have your license. You've been driving around here for 3-4 years at least without a license.
Last time I drove, Your Honor, was the last time I seen you.
Well, that
That was a little.
23. All right, anything else?
No, but in 23, he didn't know what was going on in Tennessee, and then he figured it out, and he actually believes that they're gonna have a resolution this week in Tennessee with the attorney.
Yes, sir. I paid thousands of dollars to get this back. I paid everything up. I have a license number down there I could give, just to show. I'm just waiting on Secretary of State here, waiting on him to send a letter here to Secretary of State that lets me know what's going on here.
All right, 100 fines, 150 costs, 75 victims' rights, $50 justice assessment, 40 in attorney fees. Well, no, I'm not gonna charge attorney fees. This has only been a single appearance, my mistake. So your total here is $375 or 90 days on the allowing an unlicensed driver to drive, and 100. I'm gonna charge you on the impeding traffic $160. So your total here amounts to $535. Can you pay all that?
Not today, Your Honor.
How much can you pay today?
Nothing right now. I put all my money.
Can you pay the impeding by May 31?
I should be able to. I should be able to. I'll call it now.
Call the court, we'll go on Zoom, I'll be glad to give you an extension, or you come in here on it before the due date. So you pay that one by May 31, and I'm gonna give you until June 21 to pay the extra $375 on the allowing unlicensed driver to drive. You don't have the money? Call the court, we'll go on Zoom, or come in here on it before the due date. Just don't ignore me, I hate that, okay? Good luck, thank you. People against, Paula Simone Pitts, or Pitts, I'm sorry. I have to keep.
It looks like
4B
a
one
P
four
on
six
the
nine
file.
eight two A and B.
It does look like it's typed as a P on the file.
Counsel, if this isn't resolved, then I'm setting it for trial.
I understand, but thank you. For the record, House Counsel, on behalf of Ms. Chip.
Your
Can
name?
you just state
Your name?
Oh, Simone Fix.
So Judge.
And I apologize. He's right. Go down the hall, pay $100 on the 305B, that's the no insurance, and then come back on June 11th. They'll give you the notice. Good luck. Thank you. Who do I have in here?
That's Warthen.
All right, let me take Wilson Tallison real quick. People against Salitha Chanel Wilson Tallison, 25W837860. Ma'am? Your name? Did you meet with a lawyer today?
That's right.
Your Honor, Josh was appearing on behalf of the people. She did not want to meet with the lawyer. I advised her to write to the lawyer. She
Okay.
proceed forward.
Okay, so you're gonna waive the reading of the formal complaint, and I'm just gonna go into this. Is that okay? And I'll take this plea as you agreed upon with Mr. West?
Yes.
Is that fair?
Yes.
So I'm entering a not guilty plea, and then you're gonna plead to the municipal civil infraction under 96-50, and you're gonna keep that child in school, right? Right?
No, I'm saying, you know what, he has behavior problems, so, I'm going to the school after I leave here to talk to the principal and the superintendent, to take him out and to see about putting him in the school for kids with bad behavior.
Your Honor, the child has been currently suspended from school for allegations of assault of another student and assault of a teacher, so the child is on suspension.
Jeez. You gotta get him through high school. He's gotta behave. Is his father in his life?
Yes, my husband's present.
All right, so I'll take this plea under 96-50, municipal civil infraction violation. Do you plead responsible or not responsible? I'll accept the plea, dismiss the misdemeanor, 250 is your total. Do you work, ma'am, at all?
No, I'm not working right now.
How are you gonna pay this?
I was gonna ask if I can get on the payment plan.
I know, how are you gonna pay it though, if you're not?
I can pay it, I get paid like once a month, so.
How are you supporting yourself?
Monthly, I get a check monthly.
Okay. All right, so how about if I have you pay $125 on June the 7th? And then the balance you can pay by July 7th? Can you do that? Yes?
Yes, sir.
Now, ma'am, if you don't have the money, no problem. Just come on up here and talk to me. I'm really not that bad. If you show a little respect on her before the due date, I'll give you all the extensions you need. Just don't ignore me. Fair? Good luck. Wish you well. Thank you, counsel.
Thank you, Your Honor.
Is Ricky Lee Worthen here, or was that a warrant? What are we doing on Mr. Worthen?
He's on the docket, Judge. I was,
Ricky Lee Worthen, 21W8288077. Mr. Worthen, your name? You're on mute. You're muted. You have to unmute. May the 21st. So
You have to pay for the sober link too, you need a little bit.
I'll give them till May 28th to pay the costs. And you can go over and get the sober link. It troubles me that right after that, you're out there doing it. No more. Good luck. People against Pryor, Khalil Lamonte Pryor, 25W837702. Your name, Mr. Pryor?
Attorney Mike Baldwin, House Counsel for Mr. Pryor.
Name?
Khalil Pryor.
This can be a plea to driving on a suspended, true?
Yes.
Is that what you want to do, sir?
Yes.
If you do that, the possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yes,
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes,
To the charge driving on a suspended, how do you plead? On February 6th at 25 at 9:19 a.m., were you operating a motor vehicle on Allen or Van Horn in Woodhaven? Was your license suspended? Are you on probation? Paroled?
No.
Anybody in the world force you to plead guilty?
No.
Please accept it to that charge. I find it to be an accurate plea made voluntarily and understandingly. Counsel,
Judge, we went through his driving record. He has a host of warrants. I've counseled and advised him on the importance of not driving without this license. It just keeps compounding the situation. He knows his business. He knows when he needs to take care of. He has a speeding ticket out of Georgia with, I believe that's going to be a warrant as well. So he's got a host of things.
who's the third party poster here? Who posted the bond for you?
So is my girlfriend, sorry.
I hope she's gonna post the bond or apply the bond today, because if you don't have the money, if she's not willing to do that, you're gonna have a problem with me, okay?
Understandable, sir. Can you get her down to post that?
Today? It probably won't be today. She at work. It'll be sometime this week.
Well, I don't know if it can be. Let me see what he's got.
It's enough.
It's what?
It's enough. There's enough in there.
I'm sure there is.
Permission to speak, Your Honor?
No, just no, please no.
Okay, no, I was just,
What do you have to say?
no, I was just saying that, I'm currently working on 2 real estate deals, and they should be closing around the 1st, so I was hoping to just definitely kind of take care of it.
Good enough. 100 fines, 170 costs, 75 victim's rights fee, $50 justice assessment. Attorney fees of 40. 435 or 93 days, and I'm gonna have you pay this by June the 6th. Do we understand one another?
Yes, Your Honor.
If you don't have the money, come talk to me. Don't ignore me again, all right?
Yes, sir.
Okay, good luck to you. I wish you well. Griggs, Aaron Griggs. Aaron, David Griggs, 23W832-565A and B. So we're gonna go ahead and adjourn this. They didn't put the guy in front of the camera. Can we set this pretty quick, Lisa, you think? I don't know what's going on
Is it
this.
Oakland County? So that's the issue.
We have 2 adjournments, I believe. These individuals who are co-defendants. I'm not, I thought the files made it up to you. And they did.
All right. Corey James Browse, 25W838594, and also Hannah Faye Souls, 25W838601A and B.
Attorney Mike Baldwin, House Counsel, on behalf of the defendants with permission, on behalf of the attorney of record, Mr. Crawford. Correct. Yes.
Sir, your name.
Corey James Browse.
All right, and ma'am, your name.
Hannah Faisals.
All right, so, and these 2 are co-defendants, correct?
That is my understanding, Your Honor. I have not reviewed the file.
And for purposes of arraignment, do they stand mute and waive formal reading?
They both stand mute and waive formal reading for purposes of arraignment.
So I'm entering not guilty, please. Now, there's gonna be adjournments for discovery. I'm gonna go ahead. Mr. Viola, I don't know who that is, but Mr. West, your appearance,
Josh Westbury on behalf of the people, Your Honor.
do you happen to know what Mr. Viola's first name is or not?
I can ask Lieutenant Toller, can I step out real quick?
Sure.
I had the reschedule, I was supposed to get surgery. I understand, what's the date on this one here? 24th. I understand, so we watch.
Your Honor, again, Josh Westbury on behalf of the people, Your Honor, the complaining witness in this matter is Thomas Viola, Viola.
Okay. So here's what I'm gonna do. Do the people have any objection to a personal bond?
No, Your Honor.
All right, so let me just, give me 1 second. All right, so I'm gonna give both of you a personal bond. It's going to be a $1,000 personal bond for each of you. I'm gonna sign the orders granting discovery. Here are the bond conditions, 1,000 personal, so you don't have to post any money. Excuse me, but neither one of you can leave the state without the consent of the court or violate a law. You must appear in court as directed, no contact with victim Viola, Thomas Viola. You cannot write, phone, see, text, email, or communicate with him or have anybody else do any of those things for you or on your behalf. You're not to have any contact with prosecution witnesses except through your lawyer. You're not to possess firearms. You're not to possess dangerous weapons. And both of you have to go over to Woodhaven Police Department today by 2 p.m. to be fingerprinted and photographed. That's today by 2 p.m. Do you understand that?
Yes, Your Honor.
All right, so we'll give you a new date, and then you'll fill out a petition for a court-appointed lawyer if you cannot afford one. Do you work, ma'am?
Yes.
Where?
I work at First Watch in Woodhaven.
How much do you make there?
20 an hour, I work part-time.
How about you, sir?
I work at Beer Haven,
How much do you make?
19 an hour.
Plus tips?
No, sir.
What do you do there?
I'm a cook.
Okay, we do go into the 28th, Lisa?
Yes, 9 o'clock.
May 28th at 9 a.m. Okay, guys?
Judge, one moment, please. Judge, my client goes in for his surgery on May 27th, so he will be under.
Okay, we can give him another date later.
Thank you very much.
What will that be? June, what, 11th, Lisa?
June 11th at 8:30.
June 11th at 8:30 will be your court dates, both of you. We're gonna have to make sure we give them separate lawyers. June the 11th at 8:30 will be the court date, okay?
Yes, Your Honor, thank you.
And I wish you both well.
Thank you very much.
And I've signed the orders granting discovery, and you do have to go over again today to Woodhaven to get printed and photographed. All right, best of luck to each of you. Any questions, Ms. Souls? Any questions, ma'am? Sir, do you have any questions?
No, sir, thank you.
Anything else, counsel?
No, Judge, thank you.
Thanks a lot. Good luck. Thank you. So we should give them these orders too, Lisa.
Okay, folks, can you go to the counter? They're gonna have some paperwork for you.
Okay.
Thank you. You bet. That's what I. That takes us fine.
Will you come in here on or before the due date? If you need an extension on one or all of those days, I'll get you that. Please don't ignore me again, okay? Understand everything? Do you have any questions?
No, Judge,
Ma'am?
thank you.
I can't hear
No,
you.
Your Honor.
Okay, so you're gonna go down the hall and get your notice. Good luck.
Thank you, Judge.
Thank you. Let's do Horn first, Mr. Crawford. Nicholas J. Horn, 25T704225FY. Mr. Horn, your name.
Nicholas Horn, Your Honor.
Mr. Crawford.
Good morning, Your Honor. Mike Hill Crawford, representing Mr. Horn.
All right, so what are we doing on this one?
Your Honor.
He's got 2 counts, by the way.
2 counts, Your Honor.
He's got an attempt to renewal, which is a 1-year, disorderly, a 90-day misdemeanor. So I filled out 2 of these. First of all, for purposes of arraignment, does he stand mute and waive formal reading?
Yes.
All right, so now what's he doing on these?
On these probation violations, Your Honor, he's going to plead guilty.
Okay, I'm gonna need Emily Tessino on this and on Caressi. Is that what you want to do, sir?
Yes, Your Honor.
You plead guilty here, this would be a first technical violation. And you could get 5 days on this. Do you understand that?
I do, Your Honor.
Did you sign an advice of rights revocation and probation form here today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
I completely understand, Your Honor.
All right, as to count 1, the only count, Actually, he's got multiple counts.
Well, Your Honor, I was.
Hang on one second. He's got 7 counts. That's my mistake.
Yeah, Your
So
Honor.
he could get, let me see here. I mean, I'll,
Your Honor, he's on a rise out of one alleged drinking event. He just tests every 15 minutes. So
well, he's got April 24th, April 25th.
well, if you check the time, Your Honor, it goes like 11:45, it becomes midnight.
I get it. So it would be considered at least 2 violations is what I'm saying though.
All right, well, thank you.
So he's gonna plead guilty?
Yes, Your Honor.
You understand this would be 2 technical violations, correct? I can't hear you.
Yes, Your Honor.
So you could get 10 days. Do you understand that?
I do understand, Your Honor.
All right, it's the count 1 that you failed to refrain from consuming alcohol, testing positive on a sober link on April 24, 25. How do you plead?
Guilty, Your Honor.
Did you drink alcohol on that date?
I was exposed to alcohol, so yes, Your Honor.
What do you mean exposed?
Well, Your Honor, we're going to explain that. He's pleading guilty, he consumed alcohol, but there's an explanation. It's unique to his particular profession, so I look forward to trying to explain it to you.
Is he admitting that he consumed alcohol or not?
He is admitting it, Your Honor. Isn't that true, sir?
Yes, Your Honor.
Okay. So, to the charge you failed to refrain from consuming alcohol on April 24th to 25, how do you plead?
Guilty, Your Honor.
Did you drink alcohol on that day?
Yes, Your Honor.
What did you drink?
Aqua.
What in the world is aqua?
Aqua is a peppercorn cognac sauce that we serve at my job, sir. I was saucier, I was called.
Sir, exactly what you drink.
What do you do? What do you do for a living?
I'm chef. I work at Les Supreme downtown. It's a French cuisine restaurant.
Did you know that was alcohol when you consumed it?
It's supposed to be cooked out, but yes, I understood what it was. Yes, Your
Okay,
Honor.
maybe you can't be a chef anymore.
Well,
hang on. I need to hear more.
Well, again, Your Honor, this particular day was his off day, but he was asked to come on in and asked him to cover the saucier duties in particular, which is trying various sauces before they go on the fancy meals.
And he's trying to tell me that he somehow consumed it.
Well, he consumed it because going through the process of doing his job, but the alcohol should have been cooked out. So again, my client is taking responsibility.
Wait a minute. What do you mean should have been cooked out? I gotta know more about this.
Well, you explain how this stuff is mixed together in the process.
When you cook with alcohol, it's supposed to get cooked out and you only get what's left after the alcohol is cooked out and the flavor and everything that binds the sauce together. This particular day, unfortunately, I wasn't the one making the sauce. I'm just the one that tries the sauce prior to it hitting the plate. Therefore, the line cook that was working and making the sauce did not make it correctly. And when I tasted it, I immediately disposed of that sauce and I had the cook remake
You
it.
tasted it. Hang on a second.
But I tasted.
Hang on a second. How did you taste it?
With a spoon.
How many spoonfuls did you have of this?
Well, it's
Mr. Horn.
it was a consecutive times that.
Mr. Horn. We're gonna just have a hearing on this.
Well, Your Honor, my client isn't denying consuming it. That's not in contention at all, which is explained.
There's no way in the world that he got to these levels. Let me double check. Did he tell you the cognac? Did you hear the cognac story?
He told me that it was from, he was whitening his teeth is what he.
Whitening his teeth. Well, now it's cognac from being a chef story. I'm not really in the mood. I just got back with my first day back. I'm just not in the mood to hear this nonsensical garbage right now. So here's what I'm gonna do. First, he told you he whitened his teeth.
That's what.
Oh, man. mean, I don't mean to sound like I think I'm so smart. I just don't want to hear nonsense. I really don't. I'm not gonna hear nonsense anymore. These guys, I'm telling you, I must look funny, I must look like I'm not very intelligent, I must look, again, like I can't add 7 and 3 without a calculator. I get tired of hearing this. Mr. Horn,
Yeah, sure.
you want to have a hearing? If you want to have a hearing, we're gonna have a hearing. I'm gonna hear your whole cognac story, and we're gonna go from there.
I would rather not.
Mr. Horn. I don't understand. How old are you?
28.
Okay, well, I'm 66. And you'll learn a little bit in those 38 years that I got on you. You follow me? And look, I was able to do that without a calculator. Cognac. Couple of teaspoons of cognac, or just tasting it. You go get that cognac for me. We're gonna have a hearing. I want the bottle of cognac. And then you're gonna testify.
Would you like me to have house arrest present?
Nah, I don't need house arrest. I can do this one on my own. I want the bottle of cognac. In fact, I don't want you to take the bottle of cognac, but you can certainly take a picture of its contents, its alcohol content. Now, why don't you go back and confer and see if he still wants a hearing? If he does, that's fine. But I'm not gonna listen to this nonsense. I'm just not. It's like, and by the way, I'm gonna swear him in if he's gonna testify. Okay, and that's fine. If he wants to testify, he can. If he doesn't, it's, but I don't know why he'd tell her he's whitened his teeth. And then come in here and tell me he's testing some uncooked. I mean, these guys gotta drive themselves nuts going on, trying to research how they could put one over on the judge. Mr. Horn?
Yes, sure.
Oh, boy, oh, boy, oh, boy, oh, boy, oh, boy.
I'm not trying to pull anything.
Mr. Horn, Mr. Horn. Did you tell her that you were waiting? No, I don't want to say nothing. I shouldn't ask that. We're gonna have a hearing. You're gonna go out and you're gonna talk to him and you're gonna see if he still wants a hearing. And if he does, that's fine. We'll have the hearing. Maybe he can get somebody from his work to take a picture of the ingredients in the cognac to see how much alcohol content in there, so then we can calculate how many guzzles he has to take of it to get to this level. I mean, this wash stuff I hear all the time.
Before Mr. Crawford takes him out there though, before I came in here, I just went to print his testing. And I just had a lab come back from May 5th. He tested positive for THC and he has been since he was sentenced. You know, we kind of give him the 30 days. But this lab went up from his initial one. So I don't know if we want to address.
We're gonna have to do a show cause on that.
Okay.
So you can go out and talk to him.
Do you want me to do?
No, I don't want you to do anything right now. I want Mr. Crawford to go and talk to this young man. And then again, if he wants a hearing, I don't have a problem. If he wants me, if he needs more time to go take a picture of the cognac bottle, it's fine. But I don't know, we go from teeth whitening to testing uncooked cognac. Mr. Horn,
Yes, Your Honor.
this is not a bar, this is a court. And I expect people, when I address them, to be honest with me. If they don't want to say anything and they don't want to testify, that's entirely up to them. But when I ask a question, I expect them to be honest with me.
Understood, Your Honor.
Good. We'll talk then. Again, I have no problem if he wants to hear. But we're going to go on to Mr. Caressy first. Joseph Caressy. 23R712054.
Michael Crawford representing Mr. Gillespie, so station name for record.
Joseph Caressy.
Emily, I think I need you on this one. Oh, this is Beth.
I'll grab that for you.
Mr. Crawford, get Mr. Crawford in here, will you please, on Horn? Gosh. Nicholas J. Horn, 25T704-225FY. Come on up to the podium, Mr. Horn. I need Emily in here on this one again. I don't know. I can't keep him in here.
He's unmuted, Judge.
I get it. Ricky Lee Worthen, 21W8288077. Hang on a second, I'm going on to another case. You gotta. Your name, sir? Mr. Worthen, your name? I can't hear a word.
Lee Worthen?
There we go. You're charged with failure to pay fines and costs. Balance owing 1448.19. Where are you right now? You're in custody of MDOC?
That's correct.
How long are you supposed to be there?
My earliest release date is April 11th, 2026.
Congratulations. How old are you?
I am 36.
You had a mess of your life, huh? Shocking. Well, I'm not waiving I don't mind waiving I'm not waiving I'll waive the fines, but I'm not gonna waive the restitution. So what do you want to do? You want me just to keep the file open forever? I mean, I'm not gonna waive the restitution. You owe them restitution amount of $823.19. Can you come up with that and I can waive the balance and then we'll be done?
I can get a hold of my girlfriend and see if she can't come up there and pay it.
All right, I'm gonna adjourn this, Lisa. I hate to do this. I don't know what to do with you, Mr. Worthen. Why are you doing this to yourself? Nice man, you seem like a nice man. How long do you need? I'm gonna adjourn this. Lisa, how can I do this again?
How long do you want to give him?
Well, how long will it take, Mr. Worthen?
I'm going to try to get on the phone this afternoon and see if I can get a hold of her. See if she can come there in the next few days.
MDOC likes a little bit of a notice. So if we can go out like 2 or 3 weeks.
That's what I'll do. So she'll come up here. I'll waive the balance of the fines and costs if the restitution's paid. That's $823.19. That's what he still owes in restitution, right, Lisa?
Yes, that's correct.
You give me a date, we'll adjourn this. You want to go to early June? It's like he's going anywhere.
June 10th at 11.
June 10th at 11 o'clock. Okay, sir?
Yes, sir. Thank you,
Get your girlfriend to come up with that and I can waive the balance on the fines, but I wish you well. Good luck. Thank you. People against Nicholas J. Horn, 25T704-225FY. All right, Mr. Crawford, your appearance? Your name?
Nicholas Horn.
Emily Casino.
What's he doing?
My client's gonna plead guilty, Your Honor. It's not a trial.
He's going to admit that he was drinking and not this nonsense about uncooked cognac. Is that true or false?
True.
Is that what you're gonna do?
Yes, Your Honor.
If you plead guilty here, you have two technical violations, you could get 10 days. Do you understand that? Did you sign, read, and understand the advice of rights? You plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that? Is the consequence of consuming alcohol, testing positive on a sober link on April 24 of 25, how do you plead?
Guilty, Your Honor.
Did you drink alcohol knowingly before that?
Yes, Your
What kind of alcohol?
It was cognac, Your Honor.
But it was not in the course of your work as a chef?
No.
Where were you drinking at?
After work.
Count two, that you failed to refrain from consuming alcohol on April 24th of 25, testing positive on a sober link at 11:39 PM. How do you plead?
Guilty, Your Honor.
Did you still test positive at that time?
Yes.
Count three, that you failed to refrain from consuming alcohol, positive on a sober link on April 25 at 11:55 PM. How do you plead?
Guilty.
Count four, that you failed to refrain from consuming alcohol, testing positive April 25th at 12:11 AM. How do you plead?
Guilty.
April 25th at 12:26 AM to the charge of failed to refrain, testing positive on a sober link that day.
Guilty, Your Honor.
Count six, failure to refrain from consuming alcohol, testing positive on a sober link on that day, April 25th. How do you plead?
Guilty, Your Honor.
Count seven, failure to refrain from consuming alcohol, April 25th, 12:58, positive results for sober link. How do you plead?
Guilty, Your Honor.
Anybody forced you to plead guilty? And this was all as a result of drinking the cognac after, when you were out with somebody?
Yes.
Did you go to a bar?
No.
Did you go to their house?
No, I was by myself. I was not with anyone.
Where at?
I just left work. I took a little bit of the cognac that we do use in
I
the
know, where
alcohol
were you drinking it?
outside in the alley, just waiting on my ride to pick me up from work.
I'm gonna just count this as one technical violation since all these emanated from,
Thank you, Your Honor.
who's this?
My mother,
You know what you're doing to your mother?
I do, Your Honor.
I don't know if you do.
I do. I'm not happy about it, but I'm not pleased with my actions.
Well, why would you come in? Listen, did you hear anything I said before? How long you been sitting in the courtroom here today?
4 hours.
Did you hear anything about what I was talking about? I mean, this goes directly to somebody's character as far as I'm concerned.
Yes.
You come here and lie to me to my face like I'm stupid. I hate that.
I apologize, Your Honor. It was not my intention.
Well, it might. I didn't say you wanted to make me feel stupid, but you lied to me in open court. And there's nothing more, I don't know.
No, I understand that. I'm sorry, Your Honor. Go ahead.
How's he doing with everything else?
I mean, he hasn't been on probation very long.
I know, not even
but
2 months.
I don't, our appointment was supposed to be yesterday and I told him just to appear today. But as it stands right now, I don't have proof of his outpatient treatment. I don't know if he brought his 12-step sheet with him today. And then his court work program days are scheduled.
Well, Your Honor, my client, we have a report that he has registered at the guidance center. She will start tomorrow at 9 AM. He'll provide whatever documentation necessary to probation.
If I may, Your Honor, I have took it upon myself the initiative to enroll myself into intensive outpatient.
That's what starts.
Okay.
How often is he testing again right
So
now?
he turned the sober link in May 1st and then he's testing you have a bi-weekly for 4 months.
Don't lie to me again.
Yes, Your Honor.
Anything else?
No, Your Honor.
I would just like to thank you for the mercy of the court, Your Honor.
How do you know I'm gonna be merciful? I wouldn't count on it. I don't like people lying. I'll tell you what, here's what I'll do. $100 costs. You're gonna serve 1 day on the court work program. You're gonna pay $35 for that. You're gonna serve 4 hours of community service, which is to be done by July the 1st. You're to be on a SoberLink device by the end of the day until July 15th. You're also to test weekly until July 15th. Then if you're clean, I'll make it bi-weekly. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. You made this worse by lying to me. I'm telling you, you're going back on the SoberLink. You cannot do this. If you're hanging out in an alley at whatever hours at night waiting for somebody, and now you're concocting stories about teeth whitener and cognac cooking oil, cooking. If that's how you had the cognac. That's what I'm doing. Can you pay the 135 today?
I can pay prior,
I'll just say pay by May the 21st.
You
So
have to pay for the SoberLink too, you need a little bit.
I'll give them till May 28th to pay the costs. And you can go over and get the SoberLink. It troubles me that right after that, you're out there doing it. No more. Good luck. People against Pryor, Khalil Lamonte Pryor, 25W837702. Your name, Mr. Pryor?
Attorney Mike Baldwin, House Counsel for Mr. Pryor.
Name?
Khalil Pryor.
This can be a plea to driving on a suspended, true?
Yes.
Is that what you want to do, sir?
Yes.
If you do that, the possible penalties are up to 500 fines, 93 days to testify. That's entirely up to them. But when I ask a question, I expect them to be honest with me. Good. We'll talk. Again, I have no problem if he wants to hear. But we're going to go on to Mr. Caressy first. Joseph Caressy. 2-3R-712-054.
Michael Crawford representing Mr. Caressy, so state your name for the record.
Joseph Caressy.
Emily, I think I need you on this one. Oh, this is Beth.
I'll grab that for you.
Field the Smith to twice weekly testing on May 7th. And then he went the next day. I'm so ready. What is he going to do?
Our client's going to plead guilty, state responsibility, with explanation.
Joseph's been in sobriety court with us for 20 months or thereabouts. I don't think it's helpful. I don't think it's helped you. I really don't. I really don't. We are to the end of the point of no return. I'm not going to graduate somebody knowing that the day after they graduate that they're going to go out and get drunk or use drugs or both. I don't know what to do with him, Ms. Wiles. Your name?
Elizabeth Buzz, patient, Your Honor.
It's just disappointing. I don't know what to do with him.
Yeah, I'm with you, Judge.
He went and tested the next day, right?
He did. He tested it on site on the 7th. He was negative at on site on the 7th. You know, we don't do a lot of back-to-back testing. This was back-to-back testing. He did test the 6th, moving into the 7th, and not meaning to excuse his behavior, but unfortunately with Mr. Caressy's history, as far as his violations and the alcohol consumption, what concerns me is if he consumed after testing on the 6th in the avoidance of the 7th. That is my concern. We're coming off what would be considered perhaps a holiday, Cinco de Mayo, at that point in time. Just calculating his sobriety days, even at the full 24, he won't have 90, he will be shy by 5 days. So he won't meet those requirements that we have set forth.
We wasted our time. I really feel like that. Not our time. I'm not worried about my time. I'm worried about their time. And playing games. All right, so if you plead guilty, I want you to understand, with this many violations, your probation could be revoked, you could be incarcerated for 93 days. Do you understand that?
Yes,
Did you sign the advice to read and understand the rights?
yes,
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
yes.
To the charge, you failed to submit the twice weekly chemical testing on May 7 of 25. How do you plead?
Guilty.
Did you fail to submit the testing on that day?
I failed.
Anybody force you to plead guilty?
No.
Did you consume alcohol?
No.
You did not?
No.
Why didn't you test?
I made a mistake.
What do you mean you made a
I
mistake?
made a mistake on my color. I didn't get my color called.
You're testing under yellow, right?
I'm actually testing under red.
Red?
His last violation, he was increased to 3 after the alcohol consumption, Your Honor, until June 1.
How did you not hear your color?
I just made a mistake. I thought it was clear.
When did he last test?
His testing was May 3rd, negative, May 6th, negative. He missed May 7th, and then he went to onsite on May 8th.
And was
tested
negative.
negative.
Well, you tell me what you think we should do.
I'm at a loss. I like Joe. I like meeting with Joe. I think that he's always been honest about his use prior. But he was well aware of the program rules. He was well aware that after that last violation, he was essentially kind of on borrowed time, that we already kind of went against what would be the normal process for sobriety court and extended him out to his full 24 months. Which is, I believe, August 1st for him. So we've already extended ourselves beyond what would be normal in the program, even allowing him an opportunity to still graduate from it. And here we have the miss. I don't know how to make these things priorities. We've dealt with responsibility issues with Joe. We've dealt with positives. We've allowed him to retest the next day. That I really don't know. I think this is a time when I'm glad I'm not a judge, Your Honor. Because again, he won't have the full 90. And I guess I'm just as much at a loss as you. I don't want to see Joe's probation revoked and any jail time, but in the same respect, it's appropriate at this point in time. You know, we're 22 months into the program, you know, if you add bond to that. And he knew how important this was to call. We've had lots of conversations about it. Again, I like Joe, but we're in a position where it's a really hard decision.
Your Honor, my client made a mistake. It's not that he didn't call, he wasn't paying enough attention.
Well, let's find out if he called. Where's your phone?
Right.
Could you have it back to May the 7th?
Sure. May 7th, right here.
Does it show that you called the testing agency?
So I got it in my phone. It's color call, and May 7th, I don't have it in there.
Because you didn't call.
Yeah,
Why would you tell me you called?
I don't know. I thought I called.
It's kind of a big distinction, Joe. Don't you think?
This is the 8th. There's the
7th? You didn't call on the 7th because you weren't gonna go, because you didn't think you had to go. And you knew you drank on the 6th, and that's why you missed the 7th, because you just, why would you tell me you called? This was only a week ago now. Listen. I just admire people's amnesia, memory loss. I just do. How old are you?
33.
Right. How can you not remember if you called a week ago and you didn't hear your color called versus not calling at all? How would you remember that? Or unable to remember that? How could you not remember that?
I'm not sure.
I'm not either. What did he tell you as to when he showed up on the 8th? Did he say?
I actually contacted him in regards to his miss. We had a couple of email exchanges. And basically what he indicated to me is what he's stating today. In his email, he put, "I have no good excuse, just a mistake on my behalf."
But he didn't say he called and didn't hear his color.
He did not state that.
But now, you don't put that in your initial email, but now here you are saying you called. There's a big difference. I mean, that's a big distinction. It's not like we're asking you what happened on February the 3rd. We're asking about what happened within days of the violation. I'll accept the guilty plea. I'm just. I just can't justify this. And it kills me to have to do what I'm gonna do here. But I did offer you the opportunity to be honest with me, and you weren't. Anything else?
Your Honor, my client and I discussed the possibility that what will be considered some jail time. All he would ask is if the court were to jail time, Your Honor, then be allowed to finish out this week. He needs to get some personal things in order at home and work and report.
How many credit days does he have?
I would have to look, Your Honor. I know that he's had other jail days because I didn't calculate that out for today. He was given jail time previously on a violation as well.
Anything else you want to say, Joseph? I can probably check here.
Yeah, I'm just trying to go to his
We
orders
gave him
file.
5 days in jail on, looks like it's part of the April.
Part of that leaves
April 2nd.
And on this initial arrest, I think he spent a day.
I gave him 3 more days back in September, that's 8. Another day court work program back in July, that's 9. He does get credit for that. I gave him a break on the other violation. One-day court work program back in February, that's 10. And let's see. All right, death,
That's what I have as well, Judge, and then 7, he did do his community service, if you're thinking of that, the 56 hours, the 7 days of community service.
so that's 17 days credit. Plus, Judge Hessen sentenced him to, she didn't give him that credit day, it doesn't look like. I'll at least assume that, so 18, 19 days he has coming. I just can't feel good about graduating at this time. I really can't. There's nothing I can do. Probation's revoked. I mean, I'm gonna give you credit for sticking with it a long time. I'm not gonna give you the maximum. I'm disappointed you're not gonna make it. Probation's revoked. You're to pay costs of 200, serve 93 days, credit 18 for 75. If you pay 200, I'll suspend 45 of the 75 and you'll only have to serve 30. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer, and that will be it for today. You're gonna have a seat. I'm not letting you come back later. Good luck. Thank you. You have to pay $200 to get that reduced down to 30. Sean Christopher Miller, 25B 710187. You can pay now and we're gonna give you 30 days. Grow up, Joseph. How disappointing. Yeah, let's take, well, have I got Wood Brownstown out there, John?
They are out there. I just gotta bring them in.
How long is that case gonna take? Let's take this Spanish one. Okay? Good luck. Wish you well. Thank you. Thanks a lot.
Judge, is that warrant listed on?
Yes,
Okay,
yes.
thank you.
We always lift those. Isaiah Mosley. Christiane Mosley, 25B 710270. Mr. Baldwin, can you get the lawyer in on the rest of these, please? I want to resolve these. And Horn, whoever's Mr. Crawford, he's got Horn. I need him in here. Thank you. Who's got Mosley over here, folks?
Good morning, Your Honor. Detective Ronaldo Tar from Brownstown.
Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you'll give these proceedings will be the whole true self you got.
I do.
Go ahead.
On August 1st, 2024, at approximately 4:26 a.m., Officer Whitehead received a call for a vehicle that was possibly broken into at 27303 Winchester Terrace in Brownstown, Michigan, 48183. Upon arrival at the residence, Officer Whitehead met with the homeowner and registered owner of the vehicle, victim April Barks. Victim Barks stated she was asleep in her home when she heard a noise from outside. Once awake, victim Barks looked outside of her bedroom and stated she saw an unknown male breaking into her vehicle, which was parked in her driveway. Victim Barks stated she began to flicker front porch lights on and off in an attempt to scare this unknown subject away. Victim Barks stated she saw an unknown male in a gray hooded sweatshirt exited her vehicle and start running north towards Reeland Road. Victim Barks stayed inside until the police arrived. Upon arrival, Officer Whitehead observed victim Barks' 2018 white Dodge Durango SRT parked in the driveway to her residence. The rear passenger trunk window was smashed out. Upon inspecting the interior of the vehicle, the plastic on the passenger side bottom dashboard had been popped off in what appears to be an attempt to steal the vehicle. Upon speaking with victim Barks, she stated that as of now, nothing appeared to be stolen from inside the vehicle. On August 2024, at approximately 8:36 a.m., Officer Harbedian, who's a certified evidence technician with Brownstown Police, went to the address of 27303 Winchester Terrace to process the victim's vehicle in reference to this case. While Officer Harbedian was speaking with victim Barks, she said she thought the suspect left out the driver's side of her vehicle. Officer Harbedian was able to develop a latent fingerprint located on the driver's side door handle on the inside of the vehicle. On August 25th, 2024, victim Barks and her son, Kevin Phillips, voluntarily provided Officer Harbedian with elimination fingerprints. And then on November 18th, 2024, myself, Detective Attar, was assigned to this investigation. And on December 3rd, 2024, I submitted the potential suspect fingerprints along with elimination prints obtained from victim Barks and her son, Kevin Phillips, to the Michigan State Police Lab. On January 6, 2025, I received the following results from the lab. The analysis was conducted by MSP Detective Sergeant Jason Sink, who was assigned to the latent print unit. The analysis resulted in one comparison value latent fingerprint on which resulted in the identity of Isaiah Christiane Mosley, the defendant. On January 6, 2025, I contacted Victim Barks via telephone. I asked her if she knew anyone named Isaiah Mosley. Victim Barks said she did not. Victim Barks stated approximately 1 to 2 days before the vehicle had been broken into, she had cleaned the entire interior of the vehicle herself, and there's no reason for anyone's fingerprints to be inside of her vehicle other than hers or her son, Kevin Phillips. She also stated she had an oil change done recently, but however, this was a drive-through oil change and no mechanics had access to the interior of her vehicle. Victim Barks provided me with a receipt of the damage done to her vehicle, which cost her $500 to have repaired. Defendant Mosley does not have any criminal convictions in his criminal history.
Is that it?
Yes, Your Honor.
Based on your sworn testimony, I find the crime being the vehicle, damage to the vehicle was committed. There's probable cause to believe the crime was committed by the defendant. I'm gonna authorize the issuance of the complaint and warrant. And I will go ahead and that's it for him. You're all set, I think. Detective Tulas, I think, has Miller, right?
Yes, Your Honor.
Thanks a lot. Have a good day. People against Sean Christopher Miller, 25B710187. Detective Tulas, your name?
Good morning, Your Honor. Crystal Tulas, Detective, Brownstown Police Department.
Raise your right hand. Solemnly swear affirm the penalties of perjury that the testimony you give in these proceedings will be the whole truth. So help you God.
I do, Your Honor.
Okay, go ahead.
On January 9th of 2025 at approximately 11:59 p.m., Officer Walker was on routine patrol and scanning radio traffic from other departments. At that time, he heard Lincoln Park officers were pursuing a black Ford Fusion, Michigan plate DHY 100 for a traffic violation. Lincoln Park officers terminated the pursuit as the suspect vehicle got onto southbound I-75 north of Brownstown Township. Officer Walker positioned himself on southbound I-75 at Pennsylvania Road in Brownstown Township. A short time later, Officer Walker observed a black Ford Fusion pass his position and that the driver and sole occupant of the vehicle was a white male. Officer Walker positioned himself behind the vehicle and confirmed by the vehicle's license plate that it was the same vehicle that Lincoln Park had just pursued. Officer Walker conducted a lean SOS check on the suspect vehicle's license plate and observed that the license plate had expired on 12/30 of 2024. Officer Walker activated his emergency overhead lights at southbound I-75 at Dix-Toledo Highway in Brownstown Township, but the suspect vehicle failed to stop. Officer Walker then additionally activated his emergency siren, but the suspect vehicle continued to flee. The pursuit continued for 7 miles on southbound I-75 and lasted for approximately 5 minutes. The pursuit was terminated by Officer Walker at southbound I-75 and Woodruff Road, the southern border of Brownstown Township on southbound I-75. During the pursuit, Officer Walker observed the suspect vehicle traveling at speeds ranging from 66 miles per hour to 76 miles per hour in a posted 70-mile-per-hour zone. Officer Walker was able to pull alongside of the suspect vehicle on southbound I-75 after terminating the pursuit and could clearly see the driver and sole occupant of the vehicle who was talking on his cell phone. At that time, Brownstown Police Dispatcher Schillenberg advised Officer Walker that she was on 911 with the driver of the suspect vehicle who had identified himself to her as Sean Christopher Miller. Dispatcher Schillenberg stated that Mr. Miller informed her that he knew he was being pursued by a Brownstown officer, but would not stop because he wanted to return the suspect vehicle to his sister in Monroe and knew he had warrants for his arrest. Officer Walker subsequently conducted his own lean/SOS search for Mr. Miller and was able to positively identify Mr. Miller as the driver of the suspect vehicle during the pursuit by his Secretary of State photograph. During the pursuit, Officer Walker was on routine patrol in full Class B uniform, wearing an external body armor carrier with a visible badge and police written on the back of the carrier. He was operating fully marked Brownstown Police Department Patrol Vehicle 1809, which is equipped with an audible siren and emergency blue and white flashing lights. A lean SOS check for Mr. Miller showed that his driver's license was suspended on the date of this offense and that he had multiple warrants for his arrest, including one with our department.
Based on your sworn testimony, I find the crime of flee and elude fourth and drive while suspend first was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. You sign the complaint. I sign now the complaint and warrant for the arrest of the defendant. Thank you very much. Have a good day. Mandy K. Goltowski, 20F233035. A and B. Your name?
Mandy Kagelowski.
You owe money? Let's see here. You got a driving on a suspended. Have you been sitting here all morning?
I don't have to check in. I thought I checked in when I walked in at the desk.
What you got? So, Lisa, can you check this file, please? Looks like, oh, it's a surety bond. You gonna pay this? You've had this outstanding since 2020.
Yeah, how much is it? Yes, I can.
You can pay it now, today. It's a lot.
Oh, well,
Well, why?
I don't have an excuse.
I know you don't. Nobody should or does if they haven't shown up in 5 years unless they're fighting in a war. How much does she owe on these, Lisa?
She owes $414 on the A case and $362 on the B case.
I need to pay you $776.
No, I do not.
Well, how much time am I supposed to give you? Come on. Come on. You've had 5 years.
I mean, I don't know.
I don't know either. Where do you work?
I work at Dixie State Bank.
Go get the money. Do you understand?
Yes, sir.
How much money do you have with you?
I probably have 100.
What are you doing?
I mean, I don't make that much money.
Ma'am, I asked you to pay 50 a week starting October of 20. And I told you if you didn't have the money to come and see me, and you never did. And here we are 5 years, almost 5 years later.
I've never seen you before.
I sentenced you on this back on September 1 of 20.
You might have sent me through the mail.
I've gotten uglier and older, I'll give you that, but that was September of 20.
I've never been here.
Well, what do you mean you've never been
I've
here?
never been here. Not once. I've never been in this courtroom.
Oh,
The Zoom hearing, Judge. I think that was the COVID times.
I see. You were here by COVID, by Zoom.
Yes. Oh, okay, yes.
You were
That was-
still in front of me.
I remember now.
You were still in front of me.
Okay, I remember now, yes. Yeah, I don't remember. I do remember now, but that was a long time ago, so yeah.
So what am I supposed to do? Give you another 5 years?
No.
Well, come on, this is ridiculous.
It is. I don't have any for you, but I will pay it.
You live on Harris Street still?
Nope.
Where do you live now?
I live at 4369 Avenue E, Newport, Michigan.
4369 Avenue E.
Right, 166.
I don't know how I want to handle this. I'll tell you what. I'm gonna adjourn the hearing. You pay 100 on the civil infraction today.
Yes, sir.
I'll adjourn this a month. How much do you think you can come up with in a month?
I could probably come up with most of it.
Give me a date in about a month, Lisa.
June 11th at 8:30.
Is that enough time?
Yes.
All right, that's what we'll do. Go down the hall, pay $100 on the 305B, that's the no insurance, and then come back on June 11th. They'll give you the notice. Good luck. Thank you. Who do I have in here?
That's Warthen.
All right, let me take Wilson Tallison real quick. People against Salitha Chanel Wilson Tallison, 25WA37860. You seen them? Your name? Did you meet with a lawyer today?
That's what
Who?
Every day in the USA, people find themselves in court.
Okay, so the case will be dismissed without prejudice.
Appreciate it. Thank you. Have a great day.
Thank you. Thanks for being patient.
Of course.
That was Gilbert's. Okay, that's right. All right, do I have Juanita Mays present? Hi, good morning, Miss Mays. Can you come on up to the? All right, good morning. This is 251-74008 and 009, the People versus, oh, I see Juanita Mays. The tickets are written out to Andrew Mays.
Yeah, he's not here. I believe these tickets should be thrown out, but the prosecutor was telling me only one can be dismissed. And the writing officer of said ticket is not even here. I believe they really should be thrown out, Your Honor. I'm doing the best I can.
Who is Andrew Mays to you?
Andrew Mays is my husband.
Is he currently residing in the home and owner of the home with you?
No, I need to get the deed changed. He's unavailable. Never be available. In the register, Wayne County Register of Deeds, my name and his name is in there, and I have to remove his name.
So do you have a vehicle that was out of maintenance?
Yeah, the vehicle is unlicensed. It's operable, but it needs to be licensed. I can't afford that right now.
The parking, is there an allegation you were parking on grass?
Wood chip, it's a wood chip driveway, and prosecutor said I need a permit for that. It needs to be gravel. The ordinance 20 states that wood chip driveway is fine. It's not to be.
It's city ordinance.
It's city ordinance 20 counteracts city ordinance 17.
Which one says you can have a wood chip driveway?
20. If you go look at section 20.
All right, let's look at it.
Okay, thank you. I wasn't able to print. 20, section 202. The wood chip driveway is exempt per Taylor City Code, chapter 20, section 202. They updated.
20 what?
20, chapter 20, section 202, unless it's changed. It's another number.
20-02.
What's that? Maybe that's it.
No, I'm asking you. I'm not
I
sure.
have
I'm
chapter,
looking.
chapter 20, section 202. Prosecutor said he'll dismiss that one, but this maintenance of unlicensed vehicle stands. I still don't understand.
Miss Mays, can you let me handle some of these other matters real quick, and I'll take a moment to actually get through this and review it for you. Because I've got backup here, and I'm happy to spend the time to review this ordinance for you. But I'm gonna need to take a moment. I will tell you, are you on limited means?
Yes, I am. The state of Michigan Public Service are waiting for me as a community service, public service work for the state of Michigan. So I really need to go. I really do. Is there any way you can adjourn this, or?
I'll adjourn it, but you have to come back. I mean, if I adjourn it, that's what an adjournment is. You have to come back. So I can reduce the fine down to 80 on the, if you want to take the plea on the
009 maintenance of the
on the
vehicle.
maintenance of the vehicle.
Can you reduce that down?
I'll reduce it to 80 from 160.
Okay, I'll take it.
Okay, so the plea is that you plead that maintenance of the vehicle. And that allegation is that on March 11th of 2025, you had a vehicle at 15096 Kirsten. And that you failed to maintain that vehicle, which was a violation of city ordinance. To that allegation, how do you plead? Responsible or not responsible?
Responsible.
All right, I'll accept that plea. You have a fine of $80. Do you need time to pay that?
Yes.
30 days?
Yes.
30 days to pay. And then the other file will be dismissed pursuant to the plea agreement, okay?
Okay, thank you.
All right, ma'am, you're all set.
Thank you, Your Honor. Let's see, do I get a, I need,
You can go downstairs and they can print you something up telling you what you owe, but I've just written on the file, $80, 30 days to pay. So you have 30 days from today to submit that payment. You can go online to the 23rd District Court's website, and you can pay right online. You can walk in a payment as well, and they can tell you more about that down at the window.
okay, downstairs, okay.
Yes, ma'am.
Officer will direct me.
Yeah.
Downstairs, make a left.
Yeah, and there are clerk's windows. You can't miss them.
All right, thank you, I appreciate that.
All right, thank you. All right. Mr. Fanto. Mr. Sizbicki. All right, Mr. Sizbicki, come on up. And this is,
Want to do the agreement first?
yeah. Okay, this is 251393 FY, the People versus Raymond Sizbicki.
For your Jeffrey Fanta on behalf of Mr. Spicky, for limited purposes of arraignment, we waive formal reading, stand to request a warrant be recalled.
Okay, so we'll recall the warrant. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you, like Mr. Fanto was appointed today, and I've signed the request for court-appointed attorney to ensure that you have can show up as a positive drug screen, and you'll be responsible for what you put in your body.
Okay.
So read the handbook, read the forms, okay? Anything, Mr. Shemke?
No, Your Honor. Thank you, Judge.
All right, we're all set, sir. Welcome
Thanks
to
so
the
much.
program.
Thank you, Your Honor. Have a nice day.
Thank you. Mr. Chubb, David Chubb, can you come on up to the podium, sir? Oh, goodness. All right, these are tickets 25173794567 and 8, the People versus David Chubb. Mr. Chubb, good morning. Can you tell me your first and last name?
David Chubb.
All right, Mr. Chubb, okay, I do have 5. I wanted to make sure I had them all. I have an agreement in front of me that it looks like Mr. Zip, the prosecutor, you met with him, has indicated if you pled responsible to a litter, trash, and rubbish, and he has 2 second offense recreational vehicles, he's reducing them both the first offense, which knocks the fine in half. If you pleaded those 3 with a total of $480, the second offense parking and the rest, he dismissed 2, one of which is a second offense. Do you want to take advantage of that?
Yes. But we're still waiting on clarification on
Another ticket that's not in front of me today?
Yes, it says, did the following: single-family residential parking spaces shall be located on hard, pervious concrete, asphalt, or grass pavers. Lawn and yard areas you cannot park on. I mean, we know that. And I mean, I have a double wide driveway and I only have 2 cars, so I park in my driveway. And I don't understand where this is going.
Well, 2 of these are for, let's see, these are for recreational vehicles, the ones I have in front of me, the second offenses.
Right, I see that.
And then
I got my clarification on that, so.
yeah, and then these 2 residential parkings are being dismissed.
They're being dismissed?
Yeah. I have out of 5 tickets.
Right.
He's indicated if you plead a 3. So these second offense tickets, he's reducing down, it would have been a $260 fine. He's reducing them to a first with a fine of $160. And then the litter, trash, and rubbish one, that it's a fine of $160. So that'd be $480 total. And then these other 2 for residential parking are dismissed.
Okay.
And do you have ticket? Can I see what he's looking at, please? Thank you. Let me see what you're looking at. I just want to see if the ticket number matches what I'm looking at. Yeah, you have 2 of these like this.
Yeah.
They're both being dismissed.
Okay, because
And I don't know.
I don't park on the grass. No, my neighbors do, and I live on a dead end street, and they like to take advantage of, they have a lot of vehicles and a lot of people there.
Yeah, those 2 are,
So I just wanted to
they all
make sure.
come from the same date, but those 2 residential parkings are being dismissed.
Okay.
So, and you'll plead the other 3, and 2 of them are reduced to first offenses.
Okay.
So these all are alleged to have occurred on March 4th of 2025. There's an allegation at your property located at 6269 Wilkie in the city of Taylor that you improperly stored 2 recreational vehicles and litter, trash, and rubbish on your property in violation of city ordinance.
Right.
To those allegations, how do you plead?
Guilty.
Responsible or not responsible?
Oh, it's responsible.
Yeah, they're just tickets.
Okay.
Well, I shouldn't say just tickets, but they're just tickets. Okay.
I'm glad I got clarification on the trailer part. Told me what I can do.
So you know now?
Yeah.
And if you get tickets like this, you can always contact the ordinance department and see if there's not, if they can't verify or break something down for you a little bit better.
Right.
But okay, these other 2 tickets, those residential parkings are dismissed. And then you have a total of $480 Are you paying that today or you need a payment plan?
I can pay $350 today. So what's that leave me, 130?
Okay, all right, pay $350 today. Balance due in 30 days. You can go downstairs to the clerk's window, Mr. Chubb, and I'll send these files down right now. It might take them a few minutes to process, but as soon as they get them and they are ready for you, they'll let you make that payment and you be on your way. All right, you're all set, sir. Have a good day. Nathan Calton, sir, can you come on up? Good morning. This is 25173799, the People versus Nathan Calton. Sir, can you tell me your first and last name?
Nathan Dalton.
Dalton with a D?
Yeah.
As soon as I get QLE Holdings file, I'll call your case. Give me just a moment, okay, counsel? Okay, QLE. And then do I have Michael Kronk? Hi, good morning, sir. Can you step on up to the podium for me? This is 25173-707, 25174-558. 2517-4564 and 2517-4565. The People versus Michael Kronk. Mr. Kronk, can you tell me your first and last name?
Yeah, Michael David Kronk.
All right, good morning, sir. So I have these 4 tickets. You met with the prosecutor, correct?
Yes, I did.
And I have a note from the prosecutor that it says adjourn for a new pretrial so that you can talk to the building department. Is that correct?
Yeah, for the most part, yes.
Okay.
I don't know about all the litter and debris they rolled me up for, but it was barely springtime, or I don't think it was that big of a mess, but they had some garbage bags full of returnable cans and bottles.
Okay.
So I don't know if that's considered litter, but she had some old,
You spoke with Mr. Zick, right?
pardon me?
You spoke with the prosecutor, right?
Yes, yes.
Okay, so you'll speak with the building department. We'll just push this out 30 days so that everything can get in order, so he can do his due diligence and you can do yours.
Yeah, most of it's about the shed.
Okay.
It's a metal shed. It's a truck box is what it is.
Okay.
Well, I already went through this in 2023. I got the tickets, I wrote the letters, I issued them to the judge, and they all went through everything, and I thought it was good. This is a couple of years ago.
Well, when you write a letter to the judge and you have tickets, the letters don't actually go to the judge because we're not allowed to have one-on-one communication with you. So when you write me a letter and I see that it's about property, I write give to prosecutor and it goes to the prosecutor and he handles it.
Yeah, no, I dealt
So
with
if
it.
cases were dismissed, it wasn't from the judge, it would have been, even if you write the letter to the judge would send the letter to the appropriate party.
Yeah, I understand it.
So,
I dealt with Mr. Greco before. I called him a couple times. We all went through all this, but I thought they assumed that it was on the grass, but it's actually a foundation. It's an old garage foundation, so it's
okay.
it's full of concrete. And plus I put it up on blocks. They're solid blocks, they're not shingle blocks. So that's not gonna break, it's not good. But you don't want to hear the whole story, it's boring.
Well, I just don't, I think you're better off talking to the building department and Mr. Zick and Mr. Greco, the 2 city attorneys, because they're going to, I don't have the authority to just dismiss cases.
I understand. It's not a wooden shed, but it's all metal. It's aluminum. It never rusts. It's durable.
Yeah.
But we'll see.
Okay.
I appreciate your time.
All right, sir, you're all set. Have a good day.
Yeah, I'm gonna go to the building departments. Hopefully I can sort all this out.
Okay, thank you. Mr. Llewellyn's not here again.
I'm not surprised.
The never-ending saga with Mr. Llewellyn. He comes to court and then he gets a bench warrant lifted and then he doesn't come to court again. This was set for trial over a year ago and then he went into warrant status, got picked up, went into warrant status, failed to show up for a jury trial date. We started setting in-person hearings and he's not here. I know that the complaining witness is present again. Ma'am, can you tell me your first and last name?
Penny Hamilton.
Ms. Hamilton has been the most diligent complaining witness I've ever encountered. She always shows up. Ms. Hamilton, there will be an immediate bench warrant issued against Mr. Llewellyn on 2403380 OM. And he will not be given, I'm writing, no PR bond at arrest or turn in. So next time, since he's such a flight risk, that I have a case that literally started a year and a half ago, and he's been in warrant status multiple times for fail to appear, he will not be given another personal bond. He's a flight risk. Immediate warrant is issued, no PR bond at arrest or turn in. Complaining witness, Ms. Hamilton, appeared again. I'm writing a note that anytime you have to come to court again, you come on Zoom. You don't have to take a day off.
Well, you did give me that option on the paperwork.
Okay.
Zoom or in person, but I work midnights and I figured I'd have a better shot of, making it quicker if I showed up, so.
Well, I'm just writing on Zoom or in person, your choice. Okay, I don't want you to, I'm glad you're at least not taking days off work. I apologiz for the inconvenience. Mr. Llewellyn will not have another personal bond out of this court. All right, thank you, ma'am. Mr. Zick has written up a fine of $80. Your client has 2 weeks to pay.
Yes, Your Honor, and can that be paid online?
Yes, ma'am. 23rd District Court's website has a portal for payment.
Thank you.
All right, thank you. Is this Mr. Jenks?
That's me.
Sir, can you come on up to the podium? All right, this is 251-73930, the People versus Jeff Jenks. Sir, can you tell me your first and last name?
Colin Jenks,
All right, who's Jeff Jenks?
that's my father. We own the house together. But he
Okay,
doesn't
you're
live
an
there
owner on
either.
the house as well?
Yeah.
And you met with Mr. Zick, the prosecutor?
Yep.
All right, he's agreed that if you plead responsible to the litter, trash, and rubbish ordinance violation, he will reduce the fine to $80, okay?
Unfortunately.
All right, and to the allegation on March 7th of 2025 at property located at 24465 Ames Highway, or Colin, that you had litter, trash, and rubbish on the property in violation of city ordinance. To that allegation, how do you plead?
What do you mean? I don't know.
Responsible or not responsible?
I mean, I'm not really responsible because the wind blew a trampoline over. I don't know. I don't know why I'm getting fined.
Well, you're
I got
entitled to a
4 years.
hearing on it. You
No,
don't
I'm not
have to
gonna do
enter.
all that. I'll just pay the $80 and just get out of here. Can I pay it? Like, can I have time to pay it? Because
Of course.
I don't have any money.
Okay, not only can you have time to pay it, you can say, I don't want to plead responsible.
I don't.
And you
but-
can have a hearing on it.
But I don't want to just stretch it out. It's pointless. Like, I showed them pictures of my yard. And they said, oh, well, it's too bad. On this date, the wind blew your trampoline over up against the fence. And we happened to drive by. I got pictures of my yard. I showed them to them. It's a nice.
Where are pictures of your yard?
In my pocket, in my phone. You want to see them?
Yeah, I do. We're on a 10-minute recess. All right, this is 25173328 and 25173304. The people versus is it Iftikhar Ahmed?
Yes.
Right, sir, can you tell me your first and last name?
Iftikhar Ahmed.
All right, sir, I have in front of me a plea form. You met with Mr. Zick, the city prosecutor?
Yes, ma'am.
And he has indicated that if you plead responsible on these 2 tickets for failing to obtain a certificate of occupancy on rental property, if you did that, he would reduce the fine on each from 160 down to $80. Do you want to take advantage of that?
I have no other choice, ma'am.
Okay. To the allegation on February 8th of 2025, you failed to attain a certificate of compliance on rental property for property located at 11257 Morton View. How do you plead? Responsible or not responsible?
Ma'am, with my respect, that's the city mistake, not my mistake.
Did you talk to Mr. Zick about that?
I don't have. If they send me a reminder letter, I have no problem. I have property in Brownstown. They always send me a reminder 2 months before the date comes. I have never issue with there.
Yeah, I understand that. So they're not required by law to send you notice of that. So they're not, it's my understanding they're not sending out notice, but it's also my understanding that there's nothing in the ordinance code that requires them to notify a landlord.
That's fine, ma'am.
So to that allegation, how do you plead responsible or not responsible?
I told you I have to. I have no other choice.
Like, I know, but I have to have you say the word for the court
Yeah,
recorder.
that's fine, ma'am.
Responsible?
Yes.
Okay, and then the second one is on February 7th of 25 for property at 12765 Ziegler. And to that, how do you plead responsible or not responsible?
The same thing.
Responsible? All right, I'll accept those pleas. It's a total of $160. Mr. Ahmed, do you need time to pay that?
Yes, ma'am.
Can you pay it in 2 weeks?
How about a month?
30 days to pay. All right, you're all set, sir.
Thank you, ma'am.
Have a good day.
Thank you.
Do I have Benjamin Poland here? Mr. Poland, if you can come on up.
Afternoon, Your Honor.
Hi, good afternoon. This is 2517-3597, the City of Taylor versus Benjamin Poland. Can you tell me your name, sir?
Benjamin Poland.
All right, Mr. Poland, I have a plea form from the prosecutor that indicates that the case against you is being dismissed and the property is in compliance.
Okay,
So you're all set, sir. Have a good day.
thank you. Have a good day as well.
All right, this is 25174-2520N, the City of Taylor versus Kelsey Hootie. Oh, that's not yours?
No, I've got them right here.
Oh, okay. Well, Miss Hootie, while they're getting it together, why don't you come on up, ma'am? I like your shirt. Ma'am, can you tell me your first and last name?
Kelsey Hootie.
All right, I see that we're setting this matter for a formal hearing. Okay, is that a yes?
Yes. Sorry.
All right, we'll send you out notice. We'll set it for a formal hearing and you'll receive notice of the date in the mail.
But I just Because they were saying that it's a second offense. I don't understand how it's a second offense when they dropped the first offense last year.
So they dismissed it, but you had previously had a ticket issued? Mr. Greco, if you, hi, you're here. And so if you have a second offense notice on a, say you have a first offense last year, litter, trash, rubbish, and it's dismissed for compliance or for whatever reason, they can write you up on your second one as a second?
No. So the second offense only applies if there is a previous conviction in this court for the same exact offense. That's when an actual.
Yeah, that's what I would.
Correct. However, the computer program over at the, as you're aware, the city of Taylor, between the court's computer program, the police, the building department, and the ordinance department, when the ordinance department electronically issues the ticket, it counts it as a second offense because in its system, it sees a first litter trash.
Okay, let's look it up in the court system.
That's, yeah, in the court, but it would be to the court system.
Yeah,
It's
okay.
accurate.
Thank you. Mr. Greco hates coming in here. So
No.
we'll look it up, Ms. Hootie, and just see, okay?
Okay.
And if it's, yeah, thanks, Mr. Greco. And if it's a dismissal on the first one, we'll let Mr. Zick know that, and then you can go back out and speak to him and either reach a resolution or we can just continue on to a formal hearing, okay?
Okay.
But let's look it up. I didn't think it could be a second offense. It didn't make sense. If you've not had a first. How long have you lived at that property?
This will be my 6th year.
So on 5, actually it's July of 2024, litter trash case was dismissed.
Okay, so it's a first. All right. All right.
You need to print that on the way out?
Yeah, will you just print it and I'll write a note? We'll send this back out so Mr. Zick can see the printout and know. And then you can talk with him again and see if there's a resolution, and if not, the file will come back in and we'll just set it for hearing, okay?
Okay.
All right, you're all set. Well, you might be all set. We don't know if you're all set. We'll find out. Okay, this is 24 AS 3501A and 25173571 and 72, 75. Okay. 501 ABC and 22155.
The defendant. In this case, we have Mr. Henry with multiple violations being alleged, the dog getting out all the time, all the things that are in default. He doesn't seem to care about coming to the court or coming to the city to address these issues. And we have also based upon our complaint, or the complaint is based upon speaking with the neighbors that are longtime residents of the city of Taylor, that are neighbors of Mr. Henry, that have had to endure not only the unsightly property issues that we addressed in the first motion, but also this dog, Missy, that just gets out repeatedly, harasses the people and neighbors. They have, and in one case, Ms. Bedel's case, attacked her dog, that she needed a couple $100 in veterinary.
How much?
So.
1,200?
No, 200.
200.
A couple of hundred, 260, $240 in vet bills. That he's not here today on that specific misdemeanor to address whether or not he's harboring a vicious dog. Now, I can represent to the court that the dog Missy has been in the custody of the city of Taylor for, I believe, over a month now.
Just about.
Just about a month now. You know, pending these matters, because we did not return him because he's got all these issues in default and problems with the neighborhood that we refused to provide it back.
And does the dog remain held at the animal shelter?
The dog is currently at the animal shelter. And what we're looking for is an order from the court to remove the dog Missy from Mr. Henry's possession and property, and for it not to be returned to Mr. Henry or the address is 7550 Wilkie. If the court is interested, we do have some of the neighbors that are here that would like to say a few words in support of this petition to remove the dog from Mr. Henry's possession regarding what they've had to endure. I've told them that since we have no opposition, they can get right to the point with the court, if the court would allow.
Yeah, we can make a record, so
Sure.
Go ahead and call your first.
I'd like to first call Ms. Melody Inclán.
Yeah, if you can come on up to the witness stand here.
Hello.
Good morning.
Good morning.
Almost afternoon.
I know, right? Goodbye.
And if you can face me and raise your right hand. That's close, okay. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, ma'am, if you can have a seat in that chair there, and I'm gonna ask you to start by saying your first and last name, and then if you could spell your first and last name for the court reporter.
My name is Melody Inclán, MELODYYNCLAN.
Your witness.
Okay, thank you, Your Honor. Ms. Inclán, I don't want you to give your address on the record here, but you're a neighbor of Mr. John Henry?
I am.
Okay, who resides at 7550 Wilkie?
I live right next door.
Okay, all right. How long have you been neighbors with Mr. Henry?
About 7 years.
Okay, and how long have you lived at your address?
7 years.
About 7 years. How long have you been a resident of the city of Taylor?
7 years.
About 7 years, okay. All right, you heard my presentation briefly about Mr. Henry's dog, Missy. First of all, describe the dog to the judge. What does it look like?
She's a very muscular, mid-sized pit bull mix.
Okay.
Brindle.
Brindle?
Yeah.
Okay,
She weighs about 65 pounds.
okay. And have you had encounters with Missy?
Yes.
Okay. Are you able to tell, generally speaking, about how long Mr. Henry, well, first of all, is Missy a young dog, as far as you can tell?
I would say probably over the age of 3 or 4.
Okay,
Yeah.
middle age, okay. And how long, based upon your observations, has Missy resided with Mr. Henry at the Wilkie address?
That I'm not sure of, but I know I started seeing a problem about the fall of last year because she tried to attack my dog. She attacked my dog and she tried to barrel my cyclone fence. I was in the backyard with my dog and she was taking her head like this, her whole face, trying to get through my fence to get into my backyard. And I was back there with my dog doing the gardening.
Okay,
Yeah.
so it seemed to be like you're taking that as an aggressive.
Very
move toward you,
aggressive.
Very aggressive, okay.
Like out of control.
All right, so, but does Mr. Henry have a fenced-in backyard?
No,
Okay, but there is a fence?
partial fence.
Partial fence, okay. Have you had any, you said, is that the instance where the Missy attempted to attack your dog?
She didn't get through the fence. I sprayed her with the hose.
Okay,
And then about 2 weeks later, she bit my dog.
okay,
What kind of dog do you have?
I have a Labrador.
okay. So what have you observed as far as Missy in the neighborhood getting out, any things like that? Have you observed issues?
I work IT from home,
Okay,
so I'm there a lot.
sure,
So in my opinion, the dog comes and goes multiple times a day. His front screen door is left ajar and opened. People carelessly leave and they don't pay attention that the dog has left. But I've also seen John going down the street in his wheelchair with no regard to the law, with the dog trailing behind.
not on a leash?
not on a leash.
Okay, so not your opinion, really, your observation.
That's my
that
observation.
You're right,
yeah.
your observation that this dog seems to have free reign to go in
Free
and out of
rein.
the house.
Yes.
Okay, have you made any complaints to anyone about the dog?
I started complaining after my first time that she started barreling my fence.
Okay,
I made over 15 calls to animal shelter.
okay,
I also went to the city council meeting and the mayor was there. I expressed a very serious concern that I thought this dog was gonna kill one of the many lovely young kids that are on our block. But I was also representing people that can't represent themselves, like my lab and the kids. Somebody's gonna get killed.
got it.
That dog is, in my eyes, malicious.
All right, so your observation was that it looked like an aggressive dog and a dog that was not being properly cared for or restrained.
Yeah, she chased my dog around and around the front yard. And she got her by the back hind and bit her. My dog got away.
Mhm.
And then I just followed up with many, many calls and complaints, like, why hasn't this been taken care of already?
What were your calls and complaints related to the dog getting out all the time primarily?
Yes, yes,
Okay. And did that continue up until this spring?
yes,
Okay, was
pretty
it
regularly,
pretty regularly?
yeah.
Like
And other neighbors were complaining as well. I don't know how many calls
Sure.
were made.
Okay, and so really the first time since at least last fall that you have not seen this dog have free reign getting out of the property and roaming the neighborhood was when the city took possession of the dog approximately a month ago.
Correct.
Anything else you'd like to tell the judge? Is that it?
I live in a very lovely block with lovely people. And like I said, I'm just trying to keep it safe. My dog was attacked, but I'm more concerned about the kids. Somebody's got to represent the kids. So that's where I'm coming from.
Understood.
And you don't think this dog should be roaming free or living in your neighborhood?
In my opinion, absolutely not.
Okay, all right. Thanks, Ms. Incline. All right. All right.
Next witness.
All right, next witness, Your Honor, is Jillian Shea.
Ms. Shea, if you can just come on up and I'm gonna swear you in. If you could just face me and raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, if you can have a seat in that chair and same as your neighbor, start by saying your first and last name and then spelling your first and last name.
Jillian Shea, Jillian Shay.
Okay. Counsel.
All right, thank you. Ms. Shea, are you familiar with Mr. John Henry?
Very much so.
Okay, are you a neighbor of his on Wilkie Street?
Yes,
Okay, how long have you lived on Wilkie Street?
46 years.
Okay, and so you've been a longtime resident of the city of Taylor. Okay, and how long has Mr. Henry been your neighbor, as far as you can tell?
When he moved in, it's been more than 10 years.
Okay, okay. All right, so are you familiar with Mr. Henry's dog, Missy?
Very.
Okay, and it was described as a brindle pit bull?
Yes.
Okay.
Pit bull mix.
All right, when you say you're very familiar with Mr. Henry's dog, Missy, the brindle pit bull, what do you mean?
When he got her, she was a small dog.
Okay, approximately how long would?
About 3 years ago.
About 3 years ago, okay.
She was a nice dog. I had pet her before.
Okay.
In the last year and a half, she's become progressively aggressive.
Okay.
She gets out of the yard constantly. I've called numerous times because she's out running the neighbors. I've got pictures of her in my front yard. I've seen her try to get into the mail truck.
Okay.
I've seen her chase the mail truck. I've seen him go down the street in his wheelchair with the dog running beside him. He'll go all the way up to the gas station. The dog is not on a leash.
Okay.
It's a bad situation. I have a dog. I won't walk my dog down the street because of this dog. I
Okay.
have grandchildren that come over. I won't let them, my granddaughter, her best friend lives down the street. I won't let her walk down the street because of this dog unless I'm with her.
So this has affected your life and your
Absolutely.
family's life
Yes.
because was Missy the dog like out all the time, or it was unpredictable, or?
She's just was getting out all the time. The past 6 months, she had another dog that was running with her that was also at the house. The last time I called, which was in April, was when the dogs were finally both picked up.
Okay, when you say you called, you mean what?
I called animal control.
Okay, prior to that call, had you contacted the city, the police, or animal control or
Yes.
anyone about the situation?
Yes.
Approximately how many times?
4 or 5 times.
Okay.
Anytime I saw the dogs out running the street.
Okay,
We don't, none of us who have animals in that neighborhood allow our animals to run the street.
okay.
It's unacceptable, and this dog being a vicious dog. I don't know, I've heard people tell me that she's attacked the people in their own home.
Okay, but that's just hearsay, you don't know for a fact?
Yeah, it's just
Okay.
hearsay, but
But-
I have seen her viciously go after another dog.
Okay,
I have heard her barking and growling and just,
okay.
just the behavior.
All right, but generally you've considered this affecting your life in your neighborhood?
Absolutely.
And this dog being improperly cared for or attended for at the very least?
Yes, in my opinion, I consider it abuse. The dog is not cared for. The things that are happening at that house is not conducive for any animal or child.
Understood. All right, but this dog just getting out all the
The
time?
dog is out all the time. But like Melody said, the front door is constantly open.
Okay,
They just, it's a revolving door, and then people and animals are coming and going all the time.
and at the very least, since at least last fall or even perhaps longer, is this the first time that you have not seen the dog out regularly since the city of Taylor took possession of
Yes,
the dog?
yeah,
Okay.
except that Saturday, they were out searching for another dog that they let out.
Okay,
So it's.
right,
it's
we'll have to deal
constant.
with that, right?
What I would like to see would be to him not be allowed to have animals.
Okay.
They don't take care of them. It's an abusive situation all the way around. If we
Okay.
could prevent him from having, I don't know if that's a thing, but I would like to see that he does not get any more animals.
Okay, all right, thank you. Thank you, Ms. Shea.
Thank you. Next witness.
All right. The next witness that the city is calling is Chelsea Bedwell.
Ms. Bedwell? Bedwell. Bedwell. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, same thing as the other neighbors. Can you have a seat? Tell me your first and last name and then spell your first and last name.
Chelsea Bedwell, CHELSEA, last name BEDWELL.
Go ahead.
All right, thank you. Ms. Bedwell, are you a neighbor of John Henry
Yes,
on Wilkie Street?
yes,
Okay, how long have you lived in that area?
10 years.
About 10 years.
And then I grew up going there because my grandma lived there my whole life.
Okay, all right, very good. With respect, you're familiar with his dog Missy?
Yes,
Okay, now we're testifying, or I'm requesting testimony with respect to a petition, but you're actually here, noticed to appear here as a victim in a vicious dog case, correct?
yes.
Right, okay, so did Missy, well, what is your experience or what happened with respect to Missy and why you're here for a vicious dog case?
Yes, she attacked my dog 3 times
3 times over what period of time?
over about 3 years.
Okay,
Mhm.
okay. What
Can
kind
I
of
ask
dog? Yeah, go ahead. What kind of dog do you have?
I have a yellow
All
lab.
right, I think we're all dog people in
Yeah.
the court here.
Yeah.
All right, so,
Yes.
all right, you have a yellow lab, you said?
Yes.
Okay, so not a small dog either.
No,
No, okay.
she's like 90 pounds.
Yeah.
No, 84 pounds.
Okay, so explain to the court what happened, your experience with Missy and your dog.
Yeah, so the first attack, I was just gonna go walk her and the dog came into my front yard, just bolted at her and started biting her. And they flipped in the ditch, but no skin was broken, so I went to go talk to them about it.
Talk to them, you mean the house?
Yeah.
Where Missy came from?
Yes.
Where John Henry lives?
Yes.
Okay,
John wouldn't come to the door, but some other guy came to the door. And
okay.
I just said, could you fix the fence and figure this out? I don't want to have to call on your dog, but they never did. So then the bad attack, I was walking my dog, it was like 7 o'clock at night after I got home from work, and the dog bolted out of the front door. Like they were saying, they don't latch their front door, I guess.
Okay.
Started attacking her, and I had pepper spray. So I had pepper sprayed the dog and it didn't slow it down. Kicked the dog, didn't slow it down, kept biting my dog, flipping her on her side. So then I had someone pick me up at the top of the street, called animal control, made a report, and she had a puncture wound on her side, so I had to take her to the vet, but they don't stitch puncture wounds. So
Okay.
I just had to flush it out and give her antibiotics.
Got it.
She had her vaccine, so she was okay.
Okay, how is she
And then her
doing?
shoulder's really sore. Her shoulder still gets sore sometimes.
Oh,
Ever since
okay,
then,
how old is she? How old is your dog?
She's 8.
Oh, okay, okay.
Yeah.
So other than sore shoulder, you noticed, but is she doing okay? Has she recovered from her injuries?
Yes, yes, the wound finally closed up.
In addition to the attacks on your dog, have you observed similar things with respect to Missy being out all the time? What
Yes.
have you observed just as a resident in the neighborhood?
Yes, she gets out weekly, comes, runs to my fence and my door looking for Maggie, I think, my dog. And my boyfriend was bringing in groceries and she got out and ran up to him
Oh, right, okay.
viciously. And he couldn't even open the door. And
So
then
after
finally
shopping, can't even get out of the car?
can't get into
Okay.
the house. So we called on that one too.
Okay. Anything else you'd like to tell the court that hasn't been discussed?
No, that's it.
Okay, I think that's fine.
Okay.
All right, thanks, Joe.
You're welcome.
So, Your Honor, those are the 3 witnesses and 3 neighbors that the city has presented today in support of its petition to have the dog removed from the possession of Mr. Henry and 7550 Wilkie. What the city is requesting is that the court enter an order removing Missy, the dog, from John Henry's possession, that the dog not be returned to Mr. Henry or 7550 Wilkie because the city does have possession, and that the order provide that the animal control department, animal shelter of the city of Taylor, take possession of the dog and if appropriate, rehome the dog. Or seek to rehome the dog if it's possible. And I guess they would make that determination with respect to, Your Honor, just so you know, the animal shelter takes in a lot of dogs, strays, things like that. And they are the ones that they do make an evaluation on whether or not a dog is safe or not safe to be rehomed.
And if they make, just for clarification for the order though, if they make a determination that the dog is not able to be rehomed, will the order have language that the dog can then be?
Yeah, yes.
Put to sleep?
Destroyed or whatever it is, yes. I think that would be.
Put to sleep. Destroyed
Put to sleep, I say.
terrible.
Yeah, but
I
I
know
think.
that put to
yeah,
sleep sounds any better, but,
Right.
okay, all right, well, I heard testimony today from 3 neighbors of John Henry, all of whom live on his street. Miss Inclan, Miss Shea, and Miss Bedwell all testified, very similar testimony, that the dog, what's this dog's name again?
Missy.
Missy is frequently let out or has free reign. The defendant does not close his front door. It's a larger dog, at least from my perspective. Anything over 14 pounds is huge. So it's a larger dog. And it's freely roaming the neighborhood. It's unleashed. It's been seen chasing the mail truck. It's stopped people or at least one person from being able to exit their vehicle while coming home from shopping. All of the neighbors have been in the neighborhood for a significant period of time. We heard testimony that Ms. Shay's afraid to walk her dog or to let her grandchildren out. All three neighbors have called the police multiple times. They've all seen or experienced the dog, Missy, attacking either their pet or at least, I think Ms. Shay did not testify to that, but she testified that she'd seen the dog go after other dogs. It's a neighborhood with young kids in it. The dog has, from what the testimony is clear on, absolutely no supervision or training, and poses a threat to not only other animals in the neighborhood, but children. And honestly, Miss Bedwell's a brave one, because I don't know that I would just be out trying to pepper spray a pit bull mix, but you know, because that's, I don't know that the dog is above attacking a person, certainly from some of the, or an adult, from some of the testimony that I heard today. So the court will grant the city's motion. And Mr. Greco, I do not have an order.
I'll submit an order later today.
Okay, I'll sign the order upon receipt to the language that you requested.
Yep.
All right.
Okay.
Yeah. Thank you, everybody,
Thank
for
you, Your
coming
Honor.
in.
Thank you.
Yep. Have a good day. Do I have Mr. Amerdeep? Is that? Right, sir, can you come on up? All right, this is 25174-319, the People versus Amerdeep. What's your first name, sir?
Amar is okay.
Amar, okay. Can you tell me your first and last name?
Amardeep Sahota.
Okay, so I have here, there's a scheduled appointment for them.
Yeah, he now has a new appointment for next Wednesday, so we're just adjourning this for 2 weeks.
Okay, so I'll put it on record, we're adjourning for 2 weeks so
Yes.
he can attend his forensic center interview.
Right.
And I'll just put that all in the file. And Mr. Fanto, just so we're, so you know, Mr. Jackson, are you in the courtroom? Mr. Jackson, you understand you're here today to be arraigned on a felony? Do you understand that?
Yes.
And do you understand you have a right to talk to an attorney about that?
So I hired an attorney, but when I called and talked to,
Yeah, you have,
Dana,
yeah, you have to come in because it's a felony.
correct. My arraignment's not until the 9th, but I wanted to clear the warrant.
Okay, well, if I arraign you today, which we can do, but if I do that, I just want you to understand, I'm giving you bond conditions today, right? And if your attorney is not present, but you want to speak to Mr. Fanto, our house counsel, to at least get some advice before I put you on bond conditions relating to this offense, he can meet with you.
It's okay.
Okay, all right.
Thank you.
Thank you.
I have Mr. Somerville. Real quick.
Okay. This is, the People versus Conroe Somerville, 232-359 and 240-666. And there's also a civil infraction 241-66481.
Good afternoon, Your Honor. Jeffrey Fant on behalf of Mr. Somerville, who's present, wait for a reading, stand mute. The criminal matters are being dismissed, Judge, and he owes $312. We just have a payment plan of $100 a month.
Can you pay that?
Yes, ma'am.
All right, so the misdemeanor files are being dismissed. And then the civil infraction of $312. Okay. All right, we're all set, Mr.
Ma'am.
Somerville. Yeah. If you're gonna have trouble making those payments, make sure you call us.
Okay. Thank you.
Okay, all right.
Thank you.
Mr. Jackson, give me just a second. All right, Mr. Jackson, come on up. Okay. This is 251272 FD, the People versus Justin Jackson. Mr. Jackson, can you tell me your name?
Justin Jackson.
Okay, Mr. Jackson, so today's the time and date set for arraignment on a felony. It's my understanding that you walked in on this warrant. Is that correct?
Yes.
Okay, and it looks like you were originally scheduled for arraignment on June 9th, so a few weeks away. This will change your dates. Okay, because from the date of arraignment, you have a right to have your hearings within 21 days. So if I arraign you today, the hearings will move. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have an attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one would be appointed to represent you. Do you understand that?
Yes.
Okay, you have 2 days within the next 21 days. The first will be your probable cause conference. That's to ensure your attorney has discovery and to find out if there is any resolution short of a preliminary exam. And that will occur on May 28th of 2025. Following that will be your preliminary examination, and your exam will occur on June 2nd, 2025. Both of those hearings will be in the morning. On the 28th for the probable cause conference, you can appear via Zoom. But for the June 2nd hearing, your actual exam, you must appear in person at the 23rd District Court. Do you understand that?
Yes, Your Honor.
And sir, I asked you before we went on record, I had a note on the file indicating you did not want to speak to House counsel or an attorney. Is that correct?
Correct.
And you understand, and I said this to you before we went on record, that you have a right to have an attorney present. And if you couldn't afford one for today or didn't have one with you, we could appoint Mr. Fanto for purposes of arraignment, and you declined. Is that correct? Okay. So you'll have to notify your attorney that this does change your dates. The Michigan court rules said that both of these hearings are to be held within 21 days of date of arraignment. So I don't have an option. Your attorney can reach out to the court if he wants to waive the period, if you and him want to. But for now, those are the dates that we're setting if you come in today on an arraignment. Okay. So bond conditions, sir. You walked in today, so I'm going to give you a personal bond.
Thank you.
You have a $5,000 personal bond. And these are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot consume alcohol or illegal drugs, and you will be subject to random testing at your expense. You can go down to probation and they'll set up your color before you leave so that you know what you need to do to make sure you comply with my bond conditions, okay? So when you go down the stairs, you just go to the right into the probation office and tell them I sent you down to get your color for testing. Are you going to any meetings?
Yes.
Okay, you're to attend 2 per week and provide proof, so keep that with you. You cannot operate a motor vehicle without a valid license. And as long as you're complying with those terms, sir, you will continue with your personal bond. If you fail to comply with testing or have positive alcohol or drug screens, at that point, we will reassess the bond. Okay?
Thank you.
All right, you're all set. Samantha LaBelle. Hi, can you come on up to the podium, ma'am? This is 25174-274. Ma'am, can you tell me your first and last name? All All right, Ms. LaBelle, you're here today. Did you meet with the city attorney?
Yeah.
Okay, and it looks like you have two civil infractions here. One is for residential parking and one is for litter.
Every day in the USA, people find themselves in court.
Not even on my list. Just abandoned or escaped. Are they?
Hello?
Hello. Are you Destiny Ford Morse?
Yes, I am.
We haven't met. I'm Judge Middleton. With me is Mr. Keith Stickley. He's the Chief Public Defender for St. Joe County. You managed to get yourself arrested on a 6-year-old drinking driving charge. Let's talk about that. The file number here is 192067SD. The ticket says that on July 25th of 2019 at 2:43 a.m., you got pulled over at US 131 and Riverside Drive in Constantine Township. Your blood alcohol was 0.108. They also alleged you had open intoxicants in the car. They gave you an appearance date of August 12th, 2019 at 8:15 a.m. You did not appear. You sent us an email that said, I've been having difficulties. My car got repoed. Could we please have another date? You didn't show up on Monday, August 12th as the ticket directed. So they gave you another date back in the summer of 2019. And then you didn't show up for that either. So somebody, I think, must have, let's take a look. Judge Pattison issued a bench warrant. They adjourned it to September 18th. He didn't show up on September 18th, so Judge Pattison issued a warrant for your arrest. So that warrant has been out for 6 years. We have a long memory around here. And apparently you recently got arrested in Hillsdale County, Michigan, and they brought you here from Hillsdale. Is that correct?
That is correct, but I reached out by writing a couple of letters to you to try to get this warrant taken care of.
Well, let me see. I don't see him in the file here, but this is, you wrote the letters to me, Judge Middleton?
I wrote them to the court. I wrote 2 letters.
I don't disbelieve you, but I don't see it. Wait a minute. Well, you got arrested in Hillsdale in December of 24. Is that true?
Yes.
Resisting an arrest and some fraud. What happened to your Hillsdale charges? Are they done?
No, I'm there until January 15th. I'm on loan from them to you.
That's why I thought I was brought here was due to the letters that I had been sending, trying to get this matter taken care of while I was there.
Yes, you did. And so we issued a writ of habeas corpus and brought you over here. So otherwise you would have had to wait till January to deal with it. So I'm going to Mr. George would be the attorney appointed, but he's not available on May 30th, and I'm not gonna wait all the way till June to deal with this. I'm gonna show the defendant pled not guilty. So have you been sentenced in Hillsdale?
Yes, Your Honor, I'm there till January 15th.
All right, we'll get this taken care of while you're here. I'm gonna show a plea of not guilty. I'm gonna appoint an attorney. Set an attorney pretrial for, I don't even want to go that far. Well, you gotta be somewhere because you're not gonna get out from May 30th. At 8:30. Appoint an attorney. Not Tim George. I'd really like to know where you've been for the last 6 years, but I don't want to get into that now. You're here, you're obviously sober and clear-headed. But we'll get an attorney and see if we can get this resolved on or before. Your blood alcohol was 0.108, and I didn't see that you had any priors. This is a type of case they probably would have reduced to impaired driving. And today is the 14th. That's 16 more days before we have our next court hearing. I'm going to see if I can somehow move that up. Get you back to Hillsdale. Are you in any programs or anything at Hillsdale?
In Hillsdale, I am taking advantage of the NA classes that they offer when they're available, but other than that, just self-study.
Now, when you were here, you were living in Osceola, Indiana, back in 2019. Where do you live now?
I still live close to there in South Bend, Indiana. And actually, when I leave Hillsdale, I go back to incarceration in Indiana, where there I'm in a program. I'm purposefully incarcerated in Indiana. So that's the program that I'll be doing when I go back.
That's out of St. Joseph County, Indiana.
Yes, Your Honor.
You guys can leave. All right, and what are the Indiana charges?
The Indiana charges were fraud on a financial institution and synthetic identity deception.
All right, looks like similar to that. You had a fraud years and years ago. I'm not trying to be unkind here, but this sounds like methamphetamine got in the way and jumbled up your life. I'm not sure if I'm in the right ballpark or not, but this old case, we'll get it resolved. Yes, you did write to us, which caused, I'm not sure who did it, Judge Pattison, I think, but did a writ of habeas corpus to bring you over here and deal with it now rather than wait till January. So we often do that. So I guess you're stuck with our hospitality for a while. The bond was originally $500 cash or surety. I'm just going to leave it at there. You're not going to bond out anyway.
Your Honor, they had told me when they picked me up yesterday that I was only staying overnight. Wasn't able to bring any of my things. My cell was left
Oh,
unpacked.
well,
and-
all right, then maybe they're gonna take you back. They can take you back and bring you back again on May 30th, I guess.
Okay,
It's okay with me. Hillsdale's jail is very crowded. They probably like to leave you over here. But you've been arraigned, you pled not guilty. I appointed an attorney, left your bond at $500 cash or surety. Your next hearing is May 30th at 8:30. And if they take you back, that's fine with me. You've got your situation over there. This is very likely to be resolved if you're willing to enter some sort of plea. It'll simply probably be just closed out and you'll go take care of your other problems. All right, do you have any questions?
no, Your Honor, I believe that's all.
All right, you're good to go.
Thank you.
All right, so I think I'm swinging in the right ballpark. I think drugs came in and turned her life upside down. Anyway, if she goes back, that's fine. Hillsdale's not too far. You go over there a lot back and forth. Maybe you could give her a ride and
We're not.
bring her back. Bring her back.
What do we have from this morning? Anything left? No?
Just one case with Mr. Mendoza, Axel Mendoza.
We're ready?
Yeah, sure.
Come on
I was
up.
gonna just I'll get it reset to potentially do a plea, and I think we'll have it worked out, but we just need to.
Okay, we're not gonna dispose of it today then. No, Mendoza, okay, where's Mr. Mendoza? Come on up. Okay. How much time? How much time? Where's it?
Previously done 2 months.
Yes.
Is that what we're looking at?
But we might come back between now and then if it's over.
Okay, get resetting.
Yeah, it's August 6th is when it's.
Okay, thanks.
And if you want to come sooner, just
We
give us a
will
call.
almost certainly do
We can
that,
move
ready
that.
to do it. If you're. Yeah. Tell them you want to have that. Yeah.
Oh.
Okay. I mean, tell me you can't.
You're-
I'm sure you're wrong about
Joseph Duncan?
Okay. Okay. Good.
Joseph Duncan? We're gonna pass on Duncan until next month.
Sorry, Alice. Congratulations.
I'm good, how are you?
How are you, sir? Thank you for being here.
19-33323 is called Joseph Grant Duncan, that's you? The president. Mr. Crenshaw is representing state's attorneys here. Okay, what are we doing here?
This is a motion for an early termination of probation, which we're objecting to.
Okay.
Judge, if I could give you just a brief procedural history here. Originally, there was a plea agreement, I believe, for deferred, but when the client appeared for sentencing, he was represented at that time by Jared Gilthorpe. It was discovered during his PSI interview, he never failed a UA, but he admitted during the PSI interview of marijuana use. And based upon that, the court rejected the plea agreement and gave him 5 years TDC with a deadly weapon finding. My client then retained Mr. Barlow, who filed a motion, and the court ended up removing the deadly weapon finding. And I was.
Yeah, I know which case it is now.
Okay, and then I was retained, and we filed a motion for reconsideration, and the court granted and suspended the 5-year sentence and gave him 10 years probation, but also gave him some upfront time and safety, which my client successfully completed. It's now been over 3.5 years. We originally filed the motion for early termination at the 2-year mark, but at the time, the probation department indicated that they could not agree to early termination until the 3-year mark. At the 3-year mark, my client was told by his probation officer that the probation officer was okay with early termination. However, I believe that there was a policy decision made within the probation department that due to the nature of the offense, they could not recommend early termination. And even though it was the recommendation of the probation officer, the department would not recommend early termination due to the nature of the offense. So we are here today. My client again has been on probation. He was placed on probation in October of 2021. It's been 3.5 years. He has been, they also granted, just so the court's aware, they did put him on the inactive caseload status at the 3-year mark. That's the only thing the probation department would allow. So he has been on inactive probation, but we're at almost the 4-year mark. He has been exemplary on probation. He is a welding inspector and has an opportunity to get a job with Enterprise Products, but they will not allow that with a felony conviction. So our request here before the court today is that the court, under the circumstances, would please consider not only early discharging him from probation, but also granting judicial clemency in this matter, which in essence would turn the case into a deferred for legal purposes.
Am I able to do that?
Yes, Your Honor.
How do I undo a conviction from, what was the date? From 21? I have never, 19 years, done such a thing. Gone from a conviction, a regular probation that becomes final.
That,
and then changes to deferred.
It's not changing it to a deferred. Judicial clemency is just like the government.
I know what that is. No, he
Yeah.
said deferred.
I know, but he thinks that's what it turns it into, but it doesn't.
No, what it does is it says the court further orders the accusation, complaint, information, indictment be dismissed and the defendant be released from all penalties and disabilities resulting from the conviction or plea in this case, which is the exact language you see in the deferred order. And someone's discharged from deferred, except that, and this is where the judicial clemency comes in, except that proof of the defendant's conviction or plea shall be made known to the judge if the defendant is convicted of any subsequent offense. So it allows, even though the court is granting the judicial clemency, it still allows in a future prosecution for what happened in this case to be used against it. So again, it doesn't change it legally to a deferred, but it makes it like a deferred, which removes the felony conviction, which would then allow him to get the license that he needs to have the job as a welding inspector. Okay. And for whatever it's worth, I did have a previous case involving someone on straight probation, I believe for burglary of habitation, where we requested judicial clemency. It was very early in my career as a criminal defense attorney. I believe it was in 2017. I don't recall his name, Judge, but in that case, you did grant that.
What we have is a homicide.
Well, Judge, this is a.
No, it's a homicide, the killing, the causing of the death of another person. That's the definition of homicide. And I mean, those are, I have never opened that door yet. I'm just, let me look this up. What state said?
Judge, we object. He was given prison time. He was given short probation. He is, even though he's doing well, we've sent people to prison on these for just about every time we've tried one, we put somebody in prison. So he's got a deal getting out on probation, and I think that's lenient enough for the circumstances.
You're talking about terminating the probation.
Talking about, I'm objecting to terminating, I'm objecting to the clemency itself. I think he should finish out because, like I say, when we try these, they go to prison and they serve out their prison term and their parole. They don't get early release from parole. They have to serve out their whole time. So why not make him serve out his probation? And was just because he's getting a good job, and I hate that for people, but that's his mistake. That wasn't our mistake. And if we start saying if you get a good job, you get clemency, that's going to be a rule that you're going to have to follow with everybody else. They start getting good jobs, you're going to have to start getting rid of all these convictions. It's not going to be the right thing to do because there's other people who can't get a job to try.
And the only thing I would add is that all of the misdemeanor judgments now in Jefferson County contain the option for the judge to grant judicial clemency. I think it's actually required by the code now on misdemeanors. as part of an effort to help people in rehabilitation and trying to get jobs in the future. So this is becoming much more common. Also, I think the circumstances in this case are unique in that the original agreement in this case, my client expected to get, and the state was in agreement with at some point on a deferred sentence. Unfortunately, due to his admission during the PSI interview, that changed. I think by going to safety and successfully being on probation now for 4 years, he has greatly shown commitment to being rehabilitated. And so that's what makes this case unique, and that it's very rare that we have discussions of a deferred, and then it turns into the situation that we had here. And again, if my client had ever used drugs and it tested positive for it to be one thing, this was something where I would hope that we would hold it.
Was there a precinct report?
Too much against him, that he was given, that he admitted to the marijuana use freely and voluntarily. And in showing that plagiarism is the ultimate form of flattery, Judge, my order that I prepared in this case is from another matter where I tracked the exact language that had been on the books for a while. So nothing in here is unique or different.
Why do I have the agreement was a cap of 7?
The cap of 7, but I think the argument, and I think both sides were going in, and it was going to be deferred. That's what Jared Hill told me. And anyway, I'm not saying that.
I'm looking because paperwork would reflect that. None of the paperwork's been changed. It also is cap of 7. I don't remember ever operating deferred on one of these.
It was a cap of 7, and that may have been, but I'm saying that your discussions with Jared Gilthorpe was that everyone expected him to get deferred, and then when the PSI came out and had him admitting the marijuana use, it was through everyone.
We operate in multiple ports. Chris already has.
Well, what's the site on clemency? What's the site? Like code of criminal procedure?
Yes, sir. So, let me ask AI. YRB state ruled that judicial commission of discretionary measure the trial court judge can grant if the trial judge believes the offender is completely rehabilitated.
So what's a site?
I'm looking, Judge. It says judicial clemency under Texas Code of Criminal Procedure 42A 701.
Subsection F, I believe. Yeah, pitch please.
Well, it's. Oh, it's special people. I mean, between that, there's yeah, but I can still my words about. Parent accounts, there's a commercial, so we mean, I had people just trying to mix them with all the things we don't have. Same, but they're finding so much of. I think so I'm trying to. Sometimes that's all I'm doing.
The pre-sentence report, you want to look at it.
I wasn't the original.
I'm just pointing out the fact that he's got our misdemeanor resisting arrest where he got deferred probation. And then this one, he got short probation on. And the statements from the people.
One thing I'd ask Judge, and if the court's having some concerns with the judicial clemency request, if the court would at least still rule motion to really discharge and maybe in 6 months or so. I can follow request for judicial clemency, but I think I think it's either now or
No, I got 30 days.
Oh. So I withdraw that request. So yeah, that's the court consider. Like I said, it's going on quite often next door with the misdemeanor courts. Every one of their judgments now has the option on it for the judge.
Yeah, no, but it's apples and oranges, the misdemeanor cases and dispositions, judgments, convictions do not have the same ramifications.
Understood.
And disabilities that are assessed a felon.
Understood.
And it was meant to be that way.
I remember
a lesser serious matter than the felonies. And here you got a loss of life. And that compounds the concern that I had. I think he's worthy of a termination early. You're not objecting to an early.
I'm objecting to everything, Judge.
Oh, you
Yes,
are?
yes, sir.
Okay. What's probation officers?
Your Honor, excuse me, when I reviewed the case files, it concerned me that there was a victim involved, that involved death. And I thought, giving credit to that, he has done what he's supposed to do, but again, he's supposed to. You're supposed to do what you're supposed to do on probation. And given the fact that he had done that, my recommendation was at that time, it still is, inactive probation for 1 year. You approve that, and then if he remains good for the remainder of the year, I would gladly submit a recommendation for early termination at that time.
And that's why I wanted to bring this to the court's attention, judges, because it was the probation officer that supervised him's recommendation that he received the early termination at the 3-year mark. And then once it went to either a new probation officer or a supervisor, it became a policy issue where they wanted this additional year. And in the meantime, it's just, it was unfortunate for my client that, he was told that, that would be the recommendation, and they then changed it for a year. It's news to me now that they're saying, I thought it was just period inactive probation. But now that I'm hearing that they will agree to in a year.
That was on the original.
That was like 6 months ago, though, that we put them on inactive probation.
That was in January.
January, right? Well, it's May.
4 months.
4 months, okay. And so we're 4 months into that year. So, Judge,
How long has he been on probation?
Since 21.
No, how many months?
3 years and 6 months. 3 years and 7 months, actually.
Okay.
So I guess the probation department's opinion now is they're fine with early termination in 8 months.
In what?
8 months.
If everything goes well.
If everything goes well.
Right.
In this case, you're talking in 8 more months.
Yes.
In this case. Oh, yeah.
But the unfortunate part for my client, Judge, is that, this is
If you want to research
Researching
report.
them from significant advancement financially as young children. And while I, with all due respect to the probation department and their policies, you know, I just, with the facts of the situation, I don't really see a huge difference in now and 8 months. But you agree with me that his probation officer's recommendation was.
No, I do not agree.
Oh,
with
you
that.
don't agree?
No, I do not.
Who was his probation officer?
Miss Marva Carter.
Okay. Okay, and that's fine if you disagree with that, but I had this conversation with the director of your department and he said that her recommendation was, you know, overruled by supervisor. And that was their policy.
Defendant paid for the burial costs, so is that ordered?
I don't know if that was ordered or not.
In the victim impact statement, I can give you, the daughter of the victim said that the grandmother had to borrow from her bank to pay for the burial of the decedent.
We're happy to pay full cost of that. We'll just simply give us an estimate, that's all we need.
Right. This is one of those things that cuts both ways, because obviously the way the defendant, Mr. Duncan, handled his mistake initially was poor, bad. And it resulted in this indictment, and which alleges a serious wrongdoing, and not to make anybody feel bad, but the reason the law was in effect is we just don't want to have people involved in a situation where there's a car accident, and then someone is left by themselves to die. Whether it was caused by someone or not, the law, it was built so that humanitarianism is built into the equation. You help people, even if you may not be at fault. You have a duty to help a fellow human being, one of God's creatures, who's sitting there dying because of an interaction you may have with that person, right or wrong. You just don't walk off. And then, as the probation officer said, the police officer, yeah, was pretty succinct. First, he ran, hid his vehicle, lied to the sergeant when first confronted, then took steps to cover his tracks by taking a blood test. I hope that prison will convince the defendant who really doesn't want to stay on the road he is currently on. All right, not to make anybody feel bad, but we also have to put ourselves in the position of the victim's family, because the law provides as much as 20 years imprisonment So it's a second degree felony. For someone who intentionally or knowingly leaves the scene of an accident, knowing that it had occurred, whether or not they caused it or not, without giving their name and address and the vehicle they were driving and to any person, and without, most importantly, providing reasonable assistance to the complainant who was injured in the accident, including transporting and making arrangements for transporting to a physician or hospital for medical treatment when it is apparent that the complainant is in need of medical treatment. In other words, they're saying, don't let just somebody lie to die and drive on. But it's not that's not exactly what happened here, but it's still, we don't know how long that person lived when you left and whether or not they could have survived had you done first aid and called immediately. We're not sure. It's not clear. So it has its importance. And if I was the victim, I'd go, victim's family, I'd go, where's the justice here? Now, on the other side of the coin, what you have accomplished here is what I've been talking about today. I do it most days. People are here who make mistakes. It's how you deal with your mistake, that you handle it. That is the test. You handled your mistake poorly at the scene, which resulted in this situation that you're in, this official proceeding that you've been dealing with. But wherever, soon or later, whatever, you seem to have gotten the gist of the importance and appreciated this, and the regret, the conscience, which I'm glad people have, because if you're numb to it, then you're not human. You're just sociopathic. If you're you have that sentiment toward others, then you have remorse, thus you have achieved what you want, and that is selflessness rather than selfishness, taking care of your fellow man, which I think you're doing here. I think you understand that, and that's behind you. The question for me is, what is the right way to reward you on your path that went from this night to where you are today, which is in the right direction. I like the probation officer's suggestion of some additional time here, although I know you're anxious. Well, I've got things I'd like to do, and that I have an opportunity that I'm going to lose. We can't forget this person's gone forever. He lost his opportunity. So we're going to make a decision that is just for everybody involved, victims and defendant. I want you to successfully complete this in the way your attorney has suggested it ought to end. I don't think yet. I think we need a few more months here, that as suggested by the probation officer. Also, it would make a real simple for me if what they requested, that was the funeral, even though it's been years, the cost, if there's something that can be done to pay for maybe something at the graveside, or some costs to the family for the reimbursement for the funeral expenses and other expenses in because of this incident. Then they said $6,000, and Mr. Crenshaw has suggested that can be done. That would certainly go a long way to showing your humanitarianism in dealing with this. And I think we all would agree. And if I was the victim, I go, we requested, and he's going to get early release, but yet we're still out.
That's right.
We have requested. And if those What is the time period that you had suggested?
1 year, and we signed that in January, so in January of 26, he could apply for early termination, and if he's not gotten in any trouble, and now he's paid this restitution, he could get on probation. We will send you something at that point, requesting that his time.
And
Sounds very
and up and until then, is there any reason for active probation?
It's not, he's
No,
already in.
he's already inactive.
Inactive. Is there
Yes.
anything else that can be done to
Long as he-
reward him?
Long as he doesn't get in any trouble, he could, he
He
could travel, he can.
doesn't even report?
No, he doesn't report.
Okay. What were you?
If we could just hold in my motion in advance until, I would ask that we come back here just right before the holidays. If we could please. we'll have the
Which,
money
what do you mean the
ready by then.
holidays of Christmas?
Well, I would actually ask for maybe the week before Thanksgiving. I think the court's usually in a better mood right before Thanksgiving. Than Mr. Laird.
I'm actually in a better mood after I eat Thanksgiving dinner.
Okay, so how about the first week of December?
But nonetheless, why don't we the first week in December, and all things being the same, we can. I can say this is what we are going to do. Because it's still in this direction that we all dealt with. Would you be so kind to memo what has happened and for the file, so you should
Sure.
remind us all what we decided here on this day in May. What happened in this May, day in May, so that we remember. What else does he need to do?
All I need, Mr. Laird, if you'll please email me the name of the cashier's check.
Okay. I'll do that.
Okay, thank you.
Thank you.
I feel better about that resolve.
Report back for the probation.
Judge, my son just reminded me, I think in order to get him released from, in October, y'all demanded the money be paid and we paid it. My client just reminded me of that. This issue came before we paid.
Already paid.
Yes.
Okay. If you did, that's fine.
I think that was.
I don't know whether,
Court,
I'm not.
We'll double check.
Okay.
previously, when we said we were gonna, when the court said out.
It would have made, I don't, yeah, it would have made sense. I can't imagine us, I read that thing and I wouldn't have missed that. That's why I was going on. What did I do?
They got sent to prison first, Judge. And then there was a short probation, and I'm not sure, I don't remember it coming up short probation, but it might have. I don't remember.
Is that in the probation file? Because I think we paid it while it was.
I bet, I'm sure they would have noted it because,
We'll confirm that.
sir, can you get some verification?
Yeah, I'll have it in my record.
Okay, thank you.
But either way, it will be paid if it hasn't, Judge. And we'll see you the first week of December.
Yes, sir.
Thank you.
Thank you. Yes, sir.
Wow.
I've got,
Thank you, Judge.
yes, sir, thank you. Christopher Wyndham,
Thank you, Mark.
That was reset, Judge.
yes, Brittany Sylvester.
Yes, sir.
And David, did you have a plea from earlier that needs
No,
to be?
we reset it.
We reset that?
Reset it to next week.
Okay, what are we gonna? All right, let's go to Sade Bobineau. Is this an MTRP here?
No, we have agreements.
Okay,
About to send it to you.
I've got two cases, correct? Two cases she's on
Yes, sir.
probation for?
Yes,
And
sir.
there's a first amended motion to revoke probation on each case filed, same day. Okay. What are we gonna do?
We had
5 years on each case, Your Honor, to run concurrently.
All right, I call these two cases 20-35051. Where the defendant was placed on probation, Sade Bobineau, that's you, man?
Yes.
You were placed on probation for theft from an elderly person, and you were sentenced to 10 years in prison, probated for 10 years on that case, and then you were sentenced to the same sentence on June 13th, 2022 on a second case, 21-36917, harassment of a public servant. And that's why we're here, as there is a first amended motion to revoke probation, which alleges a lot of things. Wow. 13 total violations. And we'll take that out. Does the defendant waive a formal reading of these first amended motions to revoke probation? In each case, can we proceed in summary? In summary, 35051 alleges that on June 13th, 2022, in this court, you were sentenced to 10 years in this. I don't think that's right. 10 years in the state jail division. I don't think so. And that was suspended for 10 years. That's not what happened. 10 years institutional division. We have any problems changing that?
We moved it. No objection. Okay. That's fine. No, it's now myself. I heard it. Mike Butler, Jefferson County, PX. Or GOP. It's also. Okay. Thank you.
Ended without objection.
Without objection, Your Honor.
So raise your right hand, man. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lord God. All right, so again, this states that you were sentenced to 10 years in the institutional division of the Texas Department of Criminal Justice, and that was suspended. You were placed on probation for 10 years. Is all of that true?
Yes, sir.
Which allegation do we work on? Only need one. Which one? We got 13. Anybody?
We'll go. Number 6, Your Honor, number 7, either number 6 or 7 would be 6.
Number 6 states that you committed the offense of illegal possession of marijuana on or about August 23rd, 2024 in Chambers County, Texas, in violation of condition 1 of your probation order. Is that true?
Yes, it's true.
Are you pleading true to that voluntarily and because it is true? You understand that a voluntary and knowingly made plea of true to 1 or more violations of probation, that is enough to grant the motion to revoke probation. Your probation can be revoked and you can be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true to that?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement's been reached where your probation would be revoked. You would be sentenced to 5 years in prison to run concurrently with the next case, 36917. Is that your understanding?
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
I'm going to hold that one in abeyance for just a moment and go to 36917. And can we waive a formal reading of this first amended motion to revoke probation in this case and proceed in summary?
We can, Your Honor.
In summary, in this case, this alleges that on June 13th, 2022, you were sentenced to 10 years in prison, probated for 10 years for the 3rd-degree felony of harassment of a public servant. Is that true?
Yes, sir.
Yes. And allegation 6 alleges similarly as the previous case that you committed the offense of illegal possession of marijuana on or about August 23rd, 2024 in Chambers County, Texas, in violation of condition 1 of your probation order. Is that true and correct?
Yes, sir.
Are you pleading true and correct to that voluntarily, knowing that intelligently and because it is true?
Yes, sir.
And do you understand? A knowing the voluntary plea of true to 1 or more violations of probation. That's all it takes to grant the motion to revoke probation. Your probation can be revoked. You can be sentenced no less than 2 nor more than 10 years in prison. Knowing that, you insist on pleading true to that.
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. an agreement that is similar in this case, that you would be pleading true, your probation revoked, sentenced to 5 years in prison, run concurrently with the preceding case. Is that your understanding? If I follow that, you have no right of appeal of your case. Do you understand? And again, how do you plead to this violation? Is it true and correct? And it is indeed true and correct. I'll show you what's marked as State's Exhibit 1 here. Did you sign that document in each case? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered it, evidence in each case without objection admitted. In summary, this states that if I follow these agreements, you have no right of appeal of your cases. Do you understand? I'm going to follow these agreements. If nothing further to add, I'm going to find you.
And Your Honor, just for the courts, she did still owe $350 in restitution that was never paid. That's how much she owed from the beginning on the felony theft that she has here.
What do you want me to do?
It'd be ordered that she still pay that. I know there's nothing really. She committed a new theft while she was on this and a new failure to ID. I mean, it's no way she's gonna actually.
I know, but I'm about to sentence her and that's about it.
Yes, sir.
She has nowhere to pay.
What do you want me to do?
I was just letting the court know.
I know.
Yes, sir.
What do you want me to do? But if she can't pay it,
Yeah.
what am I gonna do?
We ask that you waive that.
You're an indigent, right?
Yes, sir.
You're not retained, are you?
No, sir.
Okay. From probation, are you aware of any?
I am retained. But there's a,
How much is it?
$350, Your Honor.
For what now?
This was. I believe those items stolen from home there, but
Well, it's not good. Is there any way, ma'am, you can get that paid?
Not at the moment.
Not at the moment.
jewelry.
jewelry.
Oh, she was saying that.
Your Honor, she, according to the post-office investigation, the defendant stole jewelry in the amount of $350 from a woman that she was sitting with at the time, and then pawned it.
So what do you want to do?
I just
You want to go postpone it until it gets paid? What?
No, Your Honor, I'd just go forward with it because there's no way she's gonna, she got caught when she was out.
I'm going to find on each of these cases, you have pleaded true voluntarily, knowingly, intelligently to a violation of probation, namely condition number, violation number 6 in this first amended motion to revoke probation in each case. And that is enough to grant these motions by preponderance of the evidence or greater. I so order and rule that they have been proven violations. Thus, your probation is hereby revoked. In each case, you are hereby sentenced in accordance with these agreements to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. These will run concurrently. Which case is the restitution? The judgment shall also reflect in clause number
235051.
In cause number 35051, that restitution in the amount of $350 to
Bay Lane,
Bay Lane of what city?
Beaumont, Your Honor.
Beaumont, Texas. Complainant in this case is ordered and made a part of the judgment in this case. All right, do you understand what has happened
Yes,
here?
sir.
Okay, anything else, anybody? That is all.
Thank you, Your Honor.
Thank you. Here's another one. Which one? Keontae Baptiste.
Because
What are we gonna do? Get out.
I asked him, I picked up some discovery today.
You want some additional time? How much?
Well,
3, 4.
3.
3 weeks on Keontae Baptiste, those two cases, 25 CO 173, 19 30968. Those are reset at the request of defense. We'll call the case of Diane Rubin next, please. Thank you. Here's the pan.
Thank you.
I don't understand this. Okay, here is this turnover order. This is the one that's going to be used. I don't know if Kent's still here or not. That's the one we're going to use. I've just changed.
Do I need to give this back to Ken? Okay.
But we need to file it today.
Okay.
Okay.
Yeah.
And send copies to each attorney
Okay.
on that one. Thank you. Okay. Ms. Rubin, ready? Okay. State?
Yes, Your Honor, state's ready.
Go ahead.
Your Honor, the state would call Dominic Radosi.
Raise your right hand, sir. You solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth. So help you God. Thank you.
Please state your name for the record. Okay, and where do you currently work at? And how long you been there at Beaumont PD? And were you working there on the date of August 21st, 2024?
Yes.
And about 2:29 PM.
Wait a second. What do you do there?
I'm a police officer.
Just.
Well, I'm a field training officer, but it's almost patrol.
Okay.
And Officer Radosi, are you on kind of light duty right now?
Yes, I was injured at work. So
Okay.
I'm modified assignment.
And that's kind of why you showed up in a suit today.
Yes.
Okay. So you're working there on August 21st, 2024. Did you get a call to respond to a Baptist Behavioral Hospital located at 3250 Fannin Street here in Beaumont?
Yes.
And what was that in regards to?
And reference to assault.
Okay. And when you arrived on scene, who did you see when you arrived on scene?
We spoke to the person behind the desk who then got the victim for us to come down from.
Okay. And were you able to identify the complainant of the assault?
Yeah.
And who was that?
That was.
Or was it a Loretta Carey?
Yes.
And also were you able to identify the person who was alleged to have committed the assault? And who was that? And who, and when you say Miss Rubin, is that Diane Rubin? And do you see Miss Rubin here in the courtroom here today?
Yes,
Be kind and polite. Don't be talking over other people. You'll get a chance to speak. Thank you.
And could you please point to Miss Rubin and describe an article of clothing she's wearing? Your Honor, I'd ask that the record reflect the witness identified the defendant.
Yes, it will.
And-
Hold on for a second.
Yes.
Oh. This is weird. Okay, I'm looking at these second amended motions to revoke probation in these two cases, right?
I have a first amendment, Your Honor, I believe. I don't know if I have this. Do
I have a second amended filed
Yeah.
12/19/24 in each
Okay.
case.
All right, and I think it was a duplicate of her. I think I'd added the.
No, do you have the second amended
I
there?
don't see the first one, yes. Yes, sir.
You have it?
Yes, sir.
Okay. Correct me if I'm wrong, but these two, both of these motions allege that the defendant was placed on probation July 29th, 2024. Agree?
Yes, sir.
All right. Second amended violation states she committed the offense of assault on a public servant July 22nd, 2024, which would have been what, a week before she was placed on probation?
Yes, Your Honor, the
So
other
how
one,
was that a violation of probation?
well, in the first amendment, it's actually that the data is incorrect. In the first amendment, it was
Oh.
correct. The August 21st.
Okay, we're on the second amended though.
Yes, sir.
This doesn't work. This is an impossibility under these dates. Right?
Right, I don't think that's what they're trying, I don't think the state's gonna even put evidence on that one, I know me and him talked before that, he's not gonna.
Right.
I think he's banning in that issue anyway.
Yes, sir.
Okay, well, then, well, why don't we go to first amended one?
Yes, sir.
That's alleging she violated probation, failing to report on July 31st, 2024. Right?
That was, Your Honor, in the
2 days after she was put on probation?
in the original first amended, I had the August 21st, 2024. That was the incorrect date on that one.
What's correct on the
The
motion?
August 21st, 2024.
Well, it's not in here, is it? It's not written on why. What are you gonna do about it?
We are
Well,
moving.
what? I mean, we're talking about, is it? So 2 and 3 are incorrect dates, right?
Yes, sir.
So. So number 1 is what we're gonna be going on in each case?
Yes, sir. The August
Which is
21st,
August 21st,
2024.
which would have been a month after she was put on probation or so?
Yes,
3
yes, sir.
weeks?
That's correct. Your Honor.
Oh, okay.
Yes, sir.
Oh, okay. All right. Okay, so abandoned. I'll write abandoned on these, on 2 and 3, right?
Yes, yes, Your Honor.
Okay, go ahead. Sorry. I understand.
And so you show up there, you're able to talk to Miss Carey, is that correct? And ultimately, did you end up arresting Miss Rubin for assault on a public servant?
Yes, I should prove that I was saying.
Okay. Pass the witness, Your Honor.
No questions, that's officer.
Can this man be excused? You are
Yes,
excused.
Your Honor.
Thank you. Thank you for waiting, sir. Next.
The state would call Loretta Carey.
And raise your right hand. You solemnly swear or affirm the testimony you were about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. Please have a seat. Thank you, ma'am.
Please state your name.
We're stating, this is all about something that. So the defendant was on probation for about 3 weeks when it is alleged that she commits assault on a public servant and she's on probation for assault on EMS personnel.
Okay, that's correct, Your Honor. Go ahead. Please state your name for the record. And Miss Carey, where do you currently work at? And what do you do there at Baptist Behavioral Home? Okay. And so what are your kind of duties there at the hospital?
Taking care of patients, doing vitals, lab work, daily. Everything their needs, whatever they need.
And so do you deal with a lot of individuals that come in that have psychological issues or mental health issue? Okay. Were you working there on August the 21st, 2024? And did you have a patient there in the hospital by the name of Diane Rubin?
Yes, sir.
And do you see Miss Rubin in the courtroom here today? And could you please point to her and describe what she's wearing?
She's in a full doctor.
Your Honor, I'd ask that the record reflect that the witness identified the defendant.
Yes, it will.
Okay. And Miss Carey, did you have to treat or deal with Miss Rubin on that date?
Yes, sir.
And had you dealt with her before? Okay. And so what were you doing as far as treating her or helping her that day at the hospital?
It was a close observation, meaning someone had to be with her constantly.
Okay.
I was sitting with her.
And did y'all have kind of a little day room there for everybody to go down and watch TV and do things?
Yes, sir.
Okay. Did you go down there with Miss Rubin?
Yes.
Okay. And while you were down there, what happened while you were down there with Miss Rubin?
She got up and walked around, and then she went back to her chair. Then she got up again, and she came straight to me and just punched me in the mouth. And then she grabbed my ring finger, and I was trying to get loose from her. She twisted it so hard, the only thing I could do, I just pushed her, and she went to the ground.
Okay. And did you do anything to provoke her?
No, sir.
Okay. And at that time, did she always get around really well?
Yes, sir.
Okay. Did she sometimes use walkers, things like that?
Most of the time, she was walking on her own.
Okay. And so she punches you in the mouth, you said, and bent your finger back?
Yes, she did. She grabbed my finger and wouldn't let it go.
Okay.
She was just twisting on it.
Did that hurt pretty bad?
Yes, it did. I couldn't wear my wedding ring for like 6 months.
Okay. Did you have issues for that for quite a while?
I still do.
You still have issues from that? Okay. And did she kind of just grab on, just wouldn't let go? And you said you didn't do anything to provoke that. Okay. That's the witness.
Good afternoon. I want to ask you some simple questions. I know these sound really silly and I apologize, but I need to get this on the record, okay? You're not employed by the government, are you? Okay, so you're employed by St. Elizabeth, you said? I'm sorry, Baptist, wrong, other hospital. I'm sorry, wrong one. Okay, and you're not a juror or a grand juror involved in this case, are you? Okay, you're not an arbitrator, referee, or other person who is authorized by the law or private written government agreement to hear or determine a cause or controversy, are you? You're not an attorney at law or notary public when participating in the appointments of government function, are you? Okay, you're not a I'm sorry, let me read it again. Attorney at law or notary public when participating in the performance of a governmental function. Next one is you're not a candidate for nomination or election to public office, are you? Okay, and you're not a person who is performing a government function under a claim of right, although you are not legally qualified to do so, are you? That's what it is.
Wait, hold on. What was your job duty or at that time? I'm sorry, can you put the microphone for the there?
Psychiatric mental health technician. No.
Okay. Okay, this says she assaulted a public servant. Okay, come on. Assaulted a public servant in these allegations.
Yes, sir. But even if she's not a public servant, lesser included of assault still applies because of.
That's what y'all are gonna go on?
We'll have to, Judge.
Okay. When assault of anyone is a crime, if it's proven, and it is the first condition of probation and all the probations. This or commit no offense. Well, hold on. You have, hold on for just a second. You got 708 days on MTRP. I've got the 2 MTRPs here. Or is there, is that for both cases?
Correct, yeah, sorry.
Oh, okay,
I was just
okay.
trying to go fast.
And then we got 2 new cases that are pending, so
Right.
that hadn't been,
That's 267.
okay. We have 708 days credit on the 2 cases, the MTRPs so far. Okay, thank you. Go ahead.
And Ms. Carey, you said you had dealt with Miss Rubin before,
Yes, I remember her.
and has she ever done anything like this before to you?
Other people she has.
Okay. So it wasn't uncommon for Miss Rubin to have kind of assaultive behavior there in the facility. It's not, it wasn't uncommon for Miss Rubin to be assaultive in that.
That's rude. Don't be talking over these people, ma'am. You get a chance to talk in a minute, okay? Thank you very much. Okay, thank you. Go ahead.
Was it uncommon for Miss Rubin to assault others there in the facility?
No, sir.
Okay. I pass the witness, Your Honor.
No more from this witness, Your Honor.
All right, is this the excuse? You are excused, ma'am. Thank you.
Thank you. Thank you.
They would call Lita Valley.
And raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you. Have a seat.
Please state your name for the records.
Helena Malaire,
Ms. Blair, where do you work at?
County Adult Probation,
And how long you been working there?
3.5 years.
And do you have a probationer there on probation with you by the name of Diane Rubin?
Yes,
And do you see her here in the courtroom here today?
yes.
And could you please point to her and describe an article of clothing she's wearing?
She's wearing a blue jumpsuit.
Your Honor, I'd ask that the record reflect that the witness identify the defendant.
Yes, it will.
And on the 29th day of July, 2024, did Ms. Rubin plead guilty in this court to assault on a public servant? And was she sentenced to 7 years TDC that was probated for 7 years?
Yes.
And she was placed on probation with your department?
Yes.
And that was in cause number 24 DCCR 0258?
Yes.
On that same date, did Ms. Rubin also plead guilty in cause number 23 DCCR 1004 to assault on EMS personnel?
Yes.
And she received the same 7 years TDC probated for 7 years?
Yes.
And as part of her probation, did she have several conditions that she was required to follow?
Yes.
And as one of those, does it commit no offense against the laws of this state or any other state?
Yes.
And as far as you're aware, did she commit an assault there on August 21st, 2024? How has she done while she was on probation?
When Ms. Rubin was released from custody, she never reported, so I have never met her.
Okay.
I didn't find out that she was in a behavior center until the day they was gonna release her, where she assaulted with a staff member there.
So essentially, she didn't report and has just picked up new offense. Okay. Pass the witness.
Anything?
No, Your Honor.
What do you know about her family group's situation or where she would live? Where she was living when she was on probation?
Well, some lady, a lady from the hospital had called and said that she had like a caregiver, somebody that was over her check. And that was about it. And it was the address on, I think on Grand.
And she's indicted as a transient. Transient. Okay. What do you think? What do you think we should be doing with her? Because I know y'all are gonna be talking about.
Yes, sir.
What you're gonna be asking for, but what is probation? She's here. I'm curious what probation feels.
I think she needs to get some mental health treatment.
Okay, I'm looking at Dr. Grapon's report that he prepared in this case dated April 25th, and it's going to be made a part of the record for these two cases. And he diagnosed her with a schizoaffective disorder with mild cognitive decline, borderline intellectual function. She is competent to proceed to a resolution of her legal issues. And she has underlying mental illness, which is, according to Dr. Grapon, adequately treated in her current institutional setting, where she is provided medication and monitoring. She does have the ability to communicate with her attorney. This, she should remain well compensated, competent, so long as she remains on appropriate psychoactive medication. She has a long-standing history of medication non-compliance, which frequently becomes significantly mentally ill when not taking the medication properly. He represents, according to Dr. Grapon, a revolving door of mental health treatment and medication non-compliance, and has had a history of multiple hospitalizations and a number of past alleged legal issues. That is such a bleak statement of her mental and physical status. I think we would all agree. It's made part of the record as court's exhibit number 1 in these 2 cases on this date. And I'm going to ask for a copy of this to be placed in each of the files, cause numbers 23 CR 1004 and 24 CR 205. You just don't have enough room to write on this line here. Here we go. Lacey, if you can make a copy of this, if you can make 2 copies of that, I'll put them in each file. I'll
They're
put a copy.
electronically in every file, Judge.
Rather this hard file.
Okay.
Which is what everybody looks at. Thanks.
Yes.
Well, okay. So we have 2 things that seems like, or 2 options here. We release her. If I revoked her probation and gave her 2 years in prison, she's already served it. She's released, she goes out into the general population and will really is, Dr. Vipon says she's competent, but there's no plan for really a life of existence anywhere rational. She's just going to go out and into the earth, onto the earth, and there's no place seems like she's supposed to go. She's a transient. That's one thing. And what do we do? Just hope for the best. Or the other option is we keep her on probation, but like he says, she needs to be institutionalized for her own safety.
And yes, Your Honor, I think that's the concern of everybody, every complainant in every one of these cases. She was actually habitual on both of the indictments. And we agreed to the 7/7 as giving her a break, but I don't think there's any way that she can be able to complete probation successfully, unfortunately. And I don't know what other to ask for other than the 7 years to maybe she gets some treatment.
When we say institutionalized, we're talking about just sentencing her to prison, and then that's her existence.
Well, my concern, Your Honor, is that
she's competent and it's headed toward proof of an allegation of assault. That seems clear. She's deemed competent, but it's a human being, and we don't seem to really have a good place here for her.
yes, sir. And I guess that's my only concern is that every one of the healthcare, they seem to suggest that she maybe downplays her physical abilities a little bit, and that seems to have been some of the concern. Ms. Valier, do you feel that way, or what do you think as far as your opinion on that?
I have no opinion on that
Okay.
because I never met her.
Yeah.
I went to visit her in the jail and she refused to visit, so I don't know anything about this really.
And I guess just some of those complainants, Your Honor, when we allowed her to have the 7/7, they were just essentially fed up with getting assaulted. It wasn't the first time, as Miss Carey had said, there had been multiple instances. So we're having these nurses and people.
Okay, I see where this is headed.
Yes, sir.
I mean, unless something changes dramatically, I'm going to grant these motions.
Yes, sir.
What do I do? What is the state's position? Let's jump ahead here. So what do you think? And then what's this defense on this lady's behalf? What is it that's legal and humanitarian for her situation, particular circumstances? Anything?
That's the question that we all trying to figure out, Your Honor. What do you do?
That's what we're here to do. I mean, there's nobody else who's going to do it but us. One of God's creator, one of our creator's children.
Good.
Hold on, ma'am. You're gonna get a chance to talk in a minute.
I would argue as their attorney to continue on probation is what I would argue. Legally.
But in what way though, to deal with her situation?
And maybe a mental health caseload or something where we can get her some mental treatment.
Well, isn't that
But, I
what
mean,
we've been doing?
Yeah, this is.
It's been all this.
And that's why she was in the middle of, that's where she committed this new assault, this alleged assault was in the hospital getting treatment, so.
Well,
Has she ever been dealt with by MHMR, anybody, Top, anybody that can help with services?
Yeah, they got apartments.
And the only thing I think, Your Honor, is that if she's allowed to continue on probation, we're gonna be right back in this situation in a month, and she's assaulted another individual.
I know,
because
we've got to we've got to worry about victims, but let's say we release her. She's liable to victimize somebody else in a different setting,
I wanna go
okay, hold on. You're gonna get a chance to talk. You're being rude. You're gonna talk in a second, ma'am.
We have mental health services out in jail, but can we get Top to come out and talk to her, or will they talk to her out there? I don't remember whether they will or they won't. They used to not go out to the jail.
I don't know.
I just don't know how to get her mentally evaluated to get her somewhere.
Because she's assaulted, jail staff as well.
Yes.
Yeah, I
And
don't
she's
know
a
what to-
transient. What are we gonna do? God, you put her back in a home.
And I don't think we can involuntarily commit her, so I don't know,
Well,
she's
it's not-
competent. I don't know what to.
There's gotta be an answer. Someplace. Letting her just walk into the highway is not gonna let anybody feel good.
Trying to think, there used to be an organization that helped with mental health cases that would try to help them get into a home somewhere. And I think Manzolini did one, a case similar.
All right, what's everybody's argument? Because here's what I'm gonna do is I'm gonna listen, but my inclination is to withhold a decision at this time until we can get some more information on what professional services can be available.
Getting into
Realistically, for this lady.
Well, like you said, releasing her is not gonna help.
Sure.
Keeping her on probation, releasing her is not gonna help. I think we come up
Okay.
in between now and then to try.
Here's what I want to do. I'm gonna reset this 1 week. Give everybody a chance to kind of look into what we can do, aspects, avenues might be available in her best interest for not only her safety and well-being, but everyone else as well. Yeah.
See what that was.
Okay.
taking a check.
She does have a pay. Yeah, Pete, his name is Pete.
How do you spell it?
Pete.
Where's Pete? Where's Pete? Is Pete taking your money? Who is Pete related to you?
No, he's just like a guardian.
Guardian?
Guardian?
He's your guardian? Who made him your guardian? A judge?
No, she's Social Security.
And he's not related to you? He's not your brother?
Just,
Were you married to him or something?
no,
Probation's got
because all the people.
Yeah, I'd like to know what Pete's been doing that money. I'd like to know where Pete's been all the time. Obviously, fellow people might want to talk to Pete.
You ought to get him.
Where does Pete live?
Oh, no, he's all of a part down. He's staying in Coochie.
Things and coots. He's got his information, I think.
Yeah, they got a number, and I'm gonna, his number and name, I'm gonna follow up on that, yeah, find out who this guy is.
Okay,
See
I'm
what.
gonna reset this for one
Yeah.
week. So we can get some more information on what would be a decision in her best interests and the best interests of the community at large. Okay, well, we're gonna work on this and try to help you, ma'am. Yeah, yeah, just don't hurt anybody. Don't, these are people trying to help you. Please be sweet to them, okay? Don't hurt them because we're trying to figure out something so that you can go home or leave and live your life the way you want to, but you can't hurt people and commit crimes. Okay, all right, good, good, thank you. All right, reset this next week, thank you. Langston, hey, there you are. I've got, boy, I don't think I can pronounce this one. It's Quang Vinh Kim.
He's here.
I know I butchered that. Is that close? Oh, good. I guessed right. He's there. Come on.
He's here. Come on up.
Judge, he needs to fill out a new indigent affidavit.
And I've met with him too.
Yeah. Are you, is Mr. Adams your attorney?
Yes, sir.
Are you appointed on this or
Yes, sir.
hired?
I'm appointed.
You were charged here in 25 CR 281 with the second degree felony of burglary of a habitation. If convicted, you face no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Do you understand? Okay. Are you able to hire a lawyer? Are you working somewhere? Why are you getting the people aren't going to pay for your lawyer if you can hire your own. You're going to go hire somebody? Who have you talked to? How long have you been arrested? When were you arrested? Sir?
2 months.
2 months ago and you hadn't talked to anybody?
I'm talking right now. I'm working.
No, who have you talked to?
I'm doing
You have talked to Rife Kimmer?
Yes, sir.
Do you even know what he looks like? Have you
Yes,
heard
sir.
about him? What does he look like?
Guys.
I'm sorry, what?
I have 2 guys that you looking at. 2
Sir?
guys that come to right now.
Okay. What have you heard about him? Do you know anything about him?
He's.
Is he good reputation? Yeah. That's him right there. You want to meet him?
Yeah, I can meet him right now.
Oh, that's good. Good. Yeah, but we want you to hire somebody. If you're gonna hire him, great, but you need to wait. You don't wait. It's been 2 months. You need to talk to him. Okay, okay. So what I'm gonna do is give you a couple of weeks.
Yes, sir.
2 weeks, okay, to talk to him and come back, or anybody else you want to hire. And we'll see where you are on that. Where are you working?
Oh, landscaping right now? Landscaping?
Okay, yeah. All right. How much do you make an hour for that? They pay you on the job for the job?
Yes, sir.
But you got a lot of work going?
Yes, sir.
Good,
Yes, sir.
good. Get a resetting for 2 weeks and then go over and talk to, introduce yourself to him. He's a very nice man and he helps people, just like setting first. Thank you. Let me see who else I can get for you. Jasmine Dudley.
She's here.
Can't make this stuff up. Nothing. It's just
She'll also need.
like a movie. Say that again.
She'll need to fill out an indigent affidavit.
Wait, you were Miss Dudley? Okay. Here's this one. In 25 CR 364, you have been indicted for the 3rd-degree felony of harassment of a public servant. This carries with it, if convicted, no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. So it's very serious. And right now, Mr. Adams is representing you, and I think you're appointed right now,
Yes, sir.
Langston. Are you able to hire somebody?
I've been talking to this thing down where.
Are you
Yeah.
able to hire somebody? Okay, you're gonna have some time to go talk to some people, okay? He's been appointed to help you right now until you get somebody else. But if you're able to hire somebody, you're required to hire, whoever it is you want. Because the taxpayers aren't gonna be paying for the mistakes of people when they're charged with crimes. You gotta fix, it's like everything else. When you get in a situation, you gotta fix it. And you just do it responsibly and then you'll be fine. And these are good lawyers who help their clients who deal with this court. So I'm gonna give you a couple of weeks to talk to some people. You'll get a resetting here and come back in 2 weeks, okay? And make sure if you need any advice, call him until you get another lawyer, okay? Oh, thank you. Duracia Williams, I think is.
But something here on how to get, same with this. Judge. She keeps with
Okay,
her-
25 CR 425 is called. How do I pronounce it?
You said it right.
Did I? Okay. And you are charged here, ma'am, in 25 CR 425 with the third-degree felony of evading arrest or detention with a motor vehicle, which, like the lady before you, if convicted, you're facing no less than 2, no more than 10 years confinement in prison. That door's locked. And a fine up to $10,000 can be assessed. So it's very serious. And are you appointed on this one too? Are you able to hire somebody?
No.
Okay, well, why not? You're not working?
working.
You're not employed? Why not?
They laid me off. I haven't found another job.
When did you get laid off?
In March.
Well, why haven't you gotten another job? Have you been looking
I
for?
work in a refinery, so turn around and.
Well, there are other jobs available. I mean, you gotta just not live off others, right? If you're able to work, go find some work, Day I turned 16, I worked at 3 a.m, Saturdays and Sundays. I've been working ever since. And if I can do it, anybody can do it. But you just have to be independent. But the people aren't gonna pay for the lawyers for people is in the way it works. You gotta take care of, if you're in a mess, you gotta take care of it and fix it, like we all have to do. It makes us better people doing it that way too. Did you fill out an indigent form? Yeah, it's not signed. Here. Here, take a look at this and see. It looks like there are some things completed, but it needs to be filled out, okay? And just have a seat right over there and do that. What the judge wrote is you weren't cooperating. You weren't cooperative for whatever reason. But give her some.
I got her a new one. Judge.
Okay, we'll work on that one and then fill that out and then we'll look at it and if